Hello and welcome everyone to Immigration and Jobs Talk Show. I am Napasa Prasad, your host for today's session. And before we move ahead with our webinar that's lined up with our amazing guest today, I have this important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, folks, welcome to Immigration and Jobs Talk Show. And we are here to dive into uh, today's topic of discussion. Yes, we are going to discuss about, USCIS has officially announced that it has reached the H-1B cap for fiscal year 2025. So, what does this mean for thousands of aspiring professionals and employers hoping to secure an H-1B visa? And to unpack this, we are going to have our guest for today, a regular face who makes it a point to join us every week. So, without further ado, please help me welcome Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. Thank you so much, Prashanthi, for joining us.
Hi, Napasa. It's good to be back.
Yes, so maybe you could tell folks out there what can they expect from today's session.
I guess we're going to be talking about alternatives to the H-1B cap. That would be a major chunk because the now that the cap is over, you will not be able to be on a H-1 until next March because that's when the next cap starts. So now that the cap is completed and no further lotteries are going to be done as per the USCIS announcement, we have to find alternatives for work employment, right? So for employment, so work visas. What if there are any alternative work visas for employers as well as for employees? So we're going to discuss that, and we're going to discuss a little bit about, what is the scenario for the future, what changes, if any, are likely to be made. What are the good ways of making ensuring that you have a better chance in the cap, et cetera, et cetera. So that's what we're going to be talking about today.
Absolutely. So, friends, stay tuned and thank you for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So, please feel free to, participate in this conversation. Maybe you have some questions with regard to our topic today. So, please feel free to comment them. And another thing is, you can also join us in this discussion by dialing this number, which is displayed on the screen. And the number is 425-436-6335. And when they ask for the access code, dial in 988-888, and you will be able to jump in to this conversation. So, very happy to do this. And absolutely. So, whether you are an employer, a current visa holder, or someone considering applying in the future, this session is going to provide you insights and strategies to um, go through this complex landscape. So thank you so much, Prashanthi, for helping us today. And I think without further ado, let's go on with our questions. And I have this first one that is, with the USCIS announcing that the H-1B cap for 2025 has been reached, what does this mean for applicants who were, not selected in the lottery? And are there any alternative pathways for them to work in the US?
Yes, so they're not, they are alternative pathways that obviously they're not as good as the H1 and they're more limited in their nature. So let's go and see what the alternatives are to a H1. One is, of course, cap exempt H1. If you're not subject to the cap, how can you be a cap exempt? Is if you are and if your employer or if you are an employer who is an institution of higher education, non-profit related or affiliated to an institution of higher education or a non-profit research organization. If you're one of these three, then you're cap exempt and you can file your H1 at any time. You're not subject to this so-called H1B cap. So if also you have to remember that not only are you the direct employers are cap exempt, but also if you're an employee indirectly to an employer, that is, say you have a consulting company and the consulting company has a client who is cap exempt, then in those circumstances also your H1B petition would be a cap exempt petition. So that's something very important to keep in mind. The other alternative is, of course, you could file an O1 visa. O1 visas are generally reserved for individuals who have extraordinary ability in the sciences, and the arts, in education, in business or athletics. And by definition, not many people qualify for extraordinary ability because they are extraordinary. But where possible, it's good to review and see if you have if you qualify for an O1. Maybe if you are a researcher, you could more easily qualify for an O1 because it's easier to show that your research is extraordinary. Um, so, the O1 is definitely another option, but as I said, it's limited to only those who are extraordinary in their field. How do you show that you're extraordinary? You show that by showing that you're in the top 1%, say, of your field. That could be through, um, it could be through, newspaper clippings about you. It could be about peer review. So people that are top in their field, in the field that you're working, can give you a recommendation letter recommending that you are of extraordinary ability in your field. You could be a member of where membership requires of a certain organization where membership requires really high standards. You could be judging other people's work. You could have published, your articles in prestigious publications in your field. So there are many ways you could have received awards in your field. So there are many ways, as I said, of showing extraordinary ability. Other option is the L1. Intra-company transferee. So there is an L1A and there's L1B. L1B is for those employees who have specialized knowledge. It does not have to be proprietary, but it has to be knowledge that they cannot train, in 6 months or 1 year. It's usually helpful for L1B if maybe you have knowledge of the systems, the processes, or maybe you have knowledge of the domain of the end client, which is not easily obtainable without additional training. So if you worked in order for an L1, whether it be L1B or L1A, you should have a company in India and there should be a company in the US, and there has to be a relationship between the two. And the company in India, say, I'm just giving an example of India, should be transferring you as an intra-company transferee from India to the US. And to work at the US organization. So as I said, L1B is one option where there's specialized knowledge. L1A is another option, which is for multinational, allows multinational companies to send their executives, top executives or managers. So if you are L1A, you have to be top executive or managerial level positions, and you have to show documentary evidence that you worked in the company from the past 1 year, either in the specialized knowledge if you're L1B, or as a multinational executive if you're L1A. And you have to submit documentation, etc. So it's a very document heavy petition, the L1. The advantage of the L1A is that you qualify for EB1, and therefore you can file your green card under EB1. You file an I-140 directly, you don't have to file labor cert. For the L1B category, unfortunately, it's not EB1, and you have to file a labor cert and an I-140, just as you would in a H1B situation under EB2 or EB3. So that's L1. Now, there's certain country-specific work visas. So people belonging to a particular country can only get those work visas. For example, Canadian and Mexican nationals can get a TN visa. TN visa is available and is not subject to any cap. And it's fairly easy to obtain. You can apply at the border as long as you qualify under one of the designated occupations. The designated occupations for TN are available online, which if you want to check them out. And that list also has the educational credentials that are required for that particular position. So if you have those credentials, and if you are under one of the designated occupations, if your job is under the designated occupations, then you can get a T1 at the border, TN at the border. um, so for Canada, it's at the border. In Mexico, you'd have to actually file at the consulate. Another country specific is visa is H1B1, which is same as the H1B, but there's a special cap quota for it. I believe it's 10,000. And this is available for people who are from Singapore and Chile. Another visa available is the E3 for Australia. So if you're an Australian national, you can apply for an E3, which is very similar to a H1. You need to show specialty occupation. Again, you can go and apply directly at the consulate. You do not have to file a petition and get an approval from USCIS. And there's no cap again for the E3. So that's the E3. Then there's also E1 and E2, it is treaty trader and treaty investor. For countries, again, you can go online and check which countries this is applicable to. So if they have signed the treaty trader or treaty investor agreement, then you can bring your employee as a trader, treaty trader, or a treaty investor. Again, there's specific requirements for this. You have to show that the investment required has been transferred from the foreign company to the US company. The amount of investment is really, it's got proportionality test, meaning that depends on what investment is needed by that particular industry. And the company has to have done significant, for a treaty trader visa, significant trade between the US and that foreign company. And the employees must have skills that are required for that particular trade. And investment is, you're required to invest a certain amount of money depending on the type of industry that you're in. So that's E1, E2, treaty trader, treaty investor. Again, no cap for that. The other option is the F1 OPT and CPT. OPT is two types, post-completion OPT, and that's for 1 year after completion of your degree. And then there's STEM OPT, which is only available for people in the STEM field, and that's an additional 2 years after the completion of your post-completion OPT of 1 year. You also have CPT, curricular practical training. This is available for students where the school requires you or allows you to take to get hired off campus, but prior approval is required. Usually, curricular practical training has to be related to the degree that you're studying. So that's CPT and OPT. So you have that as well. You can also file for a green card directly in EB1 for Indian nationals. And for people who are not from India and China, you can apply in EB2 and EB3 as well, because the priority dates are not that backlogged. You still do have to wait. You have to file the labor, I-140, and then file for the green card consular processing. And the National Visa Center will send you an application. You can pay the fee, upload documents, and then the consulate gets involved, and then they call you for an interview, and they will give you the green card if you qualify. So, unfortunately, this is, of course, only available for people who are not from the backlogged countries, China and India. All other countries, EB1 is sometimes current, EB2 is not that far behind, so it's easier to apply directly for that green card and not have to apply for a non-immigrant visa. And have to go through the lottery, etc. Of course, you can always wait for April 1 for the next lottery, and then you can file that. So that's an overview of what the alternatives are for a H1B. Pasa?
Yes, thank you so much, Prashanthi. I mean, those were great options, and folks out there, the Prashanthi has in detail mentioned, the different alternative visas that you could apply for, and maybe to know which would be the best fit for you. It's always best to consult an attorney. So why not contact attorney Prashanthi Reddy herself, and you can do that by calling her on her number, and her phone number is 212-354-1010. You can also email her at prashanthi@reddyesq.com and go visit www.reddyesq.com to get to know more about Prashanthi Reddy and the law offices of Prashanthi Reddy. And at this moment, I'd like to say hello to Sneha and Ritika. Thank you so much for joining us with your questions. We are going to address them a little later in our show. And for now, Prashanthi, what are the next steps for individuals who have been selected in the H-1B lottery, and how should they prepare for their petition submission to maximize approval chances?
So once you've been selected in the lottery, since we've had two lotteries, most probably, you already know your results and you've most probably filed your petition, because even for the second lottery, the filing deadline was sometime in November. But for next year, if you do get picked, then it's very important that you follow these few guidelines that I'm going to tell you. Number one, ensure that you send the application out to the service center that is on your registration approval. So it's no longer based on your address or your employer's address. The address will be that you need to send out your petition will be on the lottery approval notice. So keep that in mind. Number two, make sure you send out your application within the given period. It's 90 days to send out your application, and the last date will be mentioned again on your lottery approval. So make sure you keep track of that. Also, always important, don't send it in the last minute. Try and send it at least a month or 2 months in advance, so that for some reason, if the petition comes back because you did something wrong, then you have enough time to resend it again. Number four, make sure you send out the petition with the correct fees. Always important, because the fees are complicated. It depends on the number of employees. It depends on, so number of employees that the employer has. And also the asylum fee is applicable to some, it's not applicable to some. It's a lower fee for some. So again, it all depends on the number of employees that you have. So keep that in mind, and there's several different kinds of fees that are affected by the number of employees. So keep that in mind and submit the correct fees. Number five, what you should do is make sure that you send out a complete application. Make sure you fill out the forms completely, sign wherever required, uh, choose the correct boxes, review your case thoroughly to make sure that you've not checkmarked a wrong box, or not checkmarked a box, or forgotten to checkmark a box. Make sure you sign. Yeah, the attorney signs, the petitioner signs. There's no beneficiary signature required. Also, make sure that you submit all the documents that you need to submit for a H-1B, which includes status documents, includes documents about your company, where the person is going to work, POs and contracts, if applicable. Don't leave anything to chance. Try to avoid an RFE. Submit evaluation documents, degree certificates. These are beneficiary documents, because otherwise you'll get an RFE, and then the chances of approval are lower if you get an RFE. And also the processing time is higher. So you want to avoid getting that RFE if you can. So I think these are a few pointers to what you should do in order to successfully file your H-1B.
Thank you so much, Prashanthi, for those tips. And I'm sure they are going to be very, very beneficial for all our viewers out there who are, applying for their H-1B visa or have been selected, at least in the lottery. Thank you so much. Now, let's go on to our next question, and that is, what does hitting the H-1B cap so quickly in 2025 indicate about the demand for skilled foreign workers in the US job market?
Well, it means that there is a high demand for skilled workers in the US market. There is still a high demand despite the layoffs that we see in the IT industry. There is still an extremely high demand, which means that there are not sufficient US workers to fill those jobs. Otherwise, they would not be looking for foreign workers, because, as per Labor Department rules, the foreign workers have to be paid just as much as the US workers. So they have no incentive to look for foreign workers other than the fact that there are no U.S. citizens available, for the job. Um, otherwise, consulting companies could just hire U.S. citizens and then contract them out to other companies rather than looking for H-1Bs. So, and that's not necessarily the case. As I said, there's no availability of US citizens for a lot of these STEM related jobs and definitely in the healthcare industry as well. So, I just wanted to take this a little further. And, what does it mean that the cap is being hit? What does it mean for the job market that H-1B numbers are no longer available? What does it mean for the job market that H-1B numbers are limited even? So just to answer that, we have to figure out first whether limiting, uh, expanding H-1B numbers will help American workers or will hurt American workers, right? So there's always talk about the H-1B numbers have to be increased, but on the other side says that increasing H-1B numbers will hurt American workers. So what are the facts of this? There are a lot of research that's being done on this, and economists have done research. There are several papers written on it, and in fact, the research shows that hiring the hiring more H-1B workers, in fact, improves the job market for American citizens, because this is how it works. If there is no job available for a particular STEM position, then that job tends to go overseas, right? Microsoft has started its operations in Canada and all over the world because they're having problems with the H1s and finding the right talent. So they're looking for that talent elsewhere outside the country. But if they found that worker here as a H1B, then based on that job, five other jobs are created for American workers. May not be STEM jobs, maybe administrative jobs, for which there are plenty of American workers available, or business related job, MBA or BBA, business administration related jobs. So that's what the research has found. So cities that uh, get more H1Bs, and this is of course just random because it's based on the lottery, they see that the job market uh, improves in those cities and more jobs are created. Um, I mean, Bill Gates said that Microsoft has found that for every H-1B hire we make, we add on an average of 4 additional employees to support them in various capacities. Bill Gates has said this. So even though the results may seem counterintuitive, it's a fact that more American jobs are created when more vacancies are filled by high-skilled workers, right? So this is something to keep in mind. And as I said, restricting H-1B visas just basically leads to offshoring. As and I was saying that, um, all those jobs just go out of the country, and that's a loss of so much uh, loss to the economy because all other industries boom when one job is created. There's a boom in real estate, there's a boom in spending, there's a boom in retail. So it's a domino effect. When one H-1B is restricted, it restricts the entire economy in so many ways. So yeah, I would, Nipasa, to answer your question, I think it indicates, filling of the cap this year and all the previous years indicates that there's a high demand and the demand is not being met.
It's true. So true. Thank you so much, Prashanthi, for the detailed explanation and for helping us understand this better. Let's address some of our viewers' questions now. I think we should, and let's take up Sneha's first. I was selected in this year's lottery, but my employer delayed filing the petition. Now that the cap is hit, does that mean my application is no longer valid?
Well, if you did not file the application in the 90 days period that was given to you, you cannot file it now. If you've already filed it, then you don't have an issue. Your application will be processed even if there is a delay in processing it. So the cap
Okay.
does not have any effect on a petition which has already been filed. And if the petition was not filed, then whether the cap is reached or not reached, you cannot file it again, because even if there was another lottery, you will not be selected in the other lottery because you were already selected.
There you go, Sneha. Thank you so much, Prashanthi, for taking this up. And now let's go on to Ritika's question. How does the H1B cap being reached impact the timing and planning for fiscal year 2026 filings? And what steps can employers and individuals take now to prepare for the next filing season?
So I guess in order to prepare the next filing season, you have to make sure that you've done your homework, make sure that you have identified, of course, don't miss the deadline. That's the most important thing. So keep an eye out for when the registration opens up. Ensure that your employer has all the necessary information for them to file the registration. So do some homework to see what information is needed. There's not much information needed, simply a copy of the applicant's passport. And also you need some information with reference to the company, the address, the federal ID number, phone number, other contact information, the signature, etc. of the employer. So ensure that you use either an attorney or you are well aware of how to file a CAP registration, because if you do it wrong, or if you don't pay the fee correctly, or if your fee doesn't go through because the bank has blocked your credit card or something like that, then
Mhm.
you will not be successful in your CAP registration. So make sure all these tips are followed for the next year before you file your registration. Keep yourself informed, most importantly. Um, with reference to timing, um, you should at least do all the preliminary work. Start it now. Identify the employees that you're hiring. If you're an employee, then file. Identify the businesses that are going to register for you for the cap. So I think you should start now, um, and be aware of what is needed to file a registration to start off with. And then after that, once your registration is picked, then you would go into the other information with reference to how to file a H1B petition. And you can, then look into that information and make sure that you have all that ready. You do have 90 days, but the sooner you file it, the better. So first step is registration, making sure you have all the information for that. And the second step is, if you get picked, then making sure that you have all the information required to file the H1B petition within the 90 days period.
Right, right. Thank you so much for taking that up, Prashanthi, for Ritika. And I think now we should go to Hari's question. This is also on YouTube. Hari's asking, we submitted our AOS I-485 in September 2021 when FAD is current. PD 8 2013 India, I-140 approved in 2016. Now my elder kid is turning 21 in the coming month. How do I make sure he is protected under CSPA? Thanks.
He's as long as he's filed adjustment of status, and the application is the 485 is pending, he's already protected. And even if he turns 21, it does not affect his green card application. So you should be good.
Okay. So, Hari, if you have any further questions, you can keep commenting. But thank you for participating. And thank you, Prashanthi, for taking that up. And now we have Hardeep's question. How likely will the percentage of H1B registrations selected for fiscal year 2025 be higher than in the first selection round last year for the fiscal year 2024 cap?
I think it'll be the same as last year. I don't expect that they will select a higher percentage of H1B registrations. I know why you're asking that. You're thinking that maybe they expect that a lower percentage will file H1s, and therefore they'll select a higher percentage. I don't think they'll do that. They'll do, they'll follow a measured approach, because they can't be sure how many people will actually file H1s after they get the registration picked. Um, So they'll follow a measured approach and go, step by step. They will pick a more number than required, because historically there is a certain percentage of H1s that are not filed even after getting selected in the lottery. But I think
Mhm.
they will take a two-step approach, and they will do a second lottery rather than trying to pick as many as possible in the first lottery.
Right. Right. Thank you so much for taking that up, Prashanthi. And Hardeep, if you have any further questions, please keep commenting. Thank you for participating with your question. Let's move on to our questions, Prashanthi. And, for companies sponsoring H1B applicants, what strategies can they adopt for future cap seasons to increase the odds of their employees getting selected?
Well, we know that the lottery system, it's a lottery system, so it's a random lottery system, so it's really hard to um, do anything to increase or decrease your luck. But there are some things that can be done. Number one, try to, if you have a US master's degree, use your US master's degree for the registration, as long as it's related to your degree. Um, but you have to keep in mind that the US master's degree has to be from uh, a private, for a not from a not a public organization, or a private not-for-profit. So it cannot be a private for-profit university. Um, then you will not qualify for the lottery under the master's cap. So try to use your US Masters, because the US Masters has a separate 20,000 lottery numbers. So that definitely a person with a US Masters has a better chance of being picked in the lottery than a person with a bachelor's degree. US Masters people get two picks in the lottery. They first get run into the Masters lottery, and then if they don't get picked, they get run again into the Bachelor's lottery. So they have higher chances because they run twice, and also because there's a separate 20,000 master's cap for US master's degree holders or higher. This goes without saying, file multiple years, keep filing. So don't wait until the last year that your OPT is expiring to file your H1. So mathematically speaking, filing a H1 cap multiple years increases your overall chance of becoming successful in getting picked in the lottery. Therefore, in every opportunity to get, please make sure you file that lottery, um, file the registration for the lottery. Um, so, if you're in a STEM, then you get most probably 3 years in a row you can file for the lottery. So make sure you make use of all those 3 years. Um, so again, find, alternative ways to get picked. I mean, alternative ways. If the H1B is not picked, then I guess you'll have to find alternative work visas that, like we discussed. Um, so, try to find that if you're not able to get picked and you're not successful. Also, sometimes you might be a master's degree, but you might not have completed your master's degree. See if you can still file a registration and a master's cap, even though you have not completed it. Perhaps if you have completed all the requirements towards it, but you don't have the actual degree, you would still qualify. Um, so, you might be able to do it that way. So, see if there are any other alternative ways of doing it. File a registration with multiple employers. Now, this is a little tricky because USCIS specifically prohibits multiple H1B filings with the same employer or with different employers if there's collusion between the employers. But if you are approaching separate employers independently, and if there is a separate job that is being offered through each employer, separate job meaning the client is different, the job is completely different, it's not the same client and several employers are filing for you. So if that's the case, then you should file multiple. But now, unfortunately, even if you file for multiple employers since this year, they've removed that incentive, and that, so you will only be picked once even if you file for multiple employers. So that no longer holds good. Of course, file a perfect application. That's number 5. Make sure you don't make any mistakes. Um, make sure your H-1B is properly prepared, your registration is properly done, the credit card doesn't get declined. So all that, make sure it's a perfect application. Uh, so you will get maximize your chances of getting the H-1B approval.
For sure, for sure. Thank you so much, Prashanthi, for taking that up. And we should address Girish's question on YouTube now. Girish is asking, how has the insertion of the H-1B visa cap evolving industry trends and shifting immigration policies between 2025 and 2020, sorry, 2015 and 2025 impacted the diversity of talent acquisition strategies?
I think with the unavailability of numbers, visa numbers, or the shortage of visa numbers, what has happened is employers are looking outside the country to find talent, and they're moving the entire job outside the country. So, as I said, a lot of jobs have moved to Canada, a lot of jobs have moved to India. Given you the example of Microsoft. Um, so, yeah, that's how it's affected. Jobs have basically moved outside the country.
Thank you so much for taking that up for Girish. And
So
Girish,
they're
if you have
talking.
any more questions, yeah.
Girish is also talking about startups versus established tech giants. So startups have more issues, obviously, with filing or getting H-1B approvals and versus or getting talent into the country versus the tech giants. And being a smaller company is definitely more difficult for people to get their talent, mainly because larger companies, number one, they have more immigration options. They have better staff who knows about immigration and is able to go through all the loopholes. Also, they have the ability to find talent outside the country and continue to be competitive. Like Microsoft opens offices all over the world and finds the talent they need wherever they need it, if they're not able to get it here, right? But as a startup, you don't have those kind of resources to open up offices outside the country and to tap foreign talent outside the country and get them working remotely outside the country, because then you have to set up offices there in other countries. So you have to have the money and the resources to be able to do that. So finding talent outside and retaining them is not possible for small businesses while it is for large companies. Also, large companies have the option of filing blanket L1 applications, L1A and L1B. This is pretty much gives them an unlimited stream of talent that they're able to tap and bring to the US. Small companies don't have that because you have to be a large company to be able to qualify for an L1 blanket. Of course, there are issues with L1 blanket as well, but definitely a good resource for big companies to tap into. So also their employees have a higher chance of getting a visa approved rather than a smaller company, higher chances of getting a H-1B approved with USCIS, not only a visa with Department of State, again, because um, it's a larger company. And USCIS also, unfortunately, discriminates with reference to their processing if it's a smaller startup when compared to a larger established Microsoft type company.
For sure. Thank you so much for taking that up in details for Girish. Girish, I hope you've got your answers. And if you have any more questions, keep commenting. Let's take up Ravi's question now. With masters from India, do I qualify for STEM category?
With masters from India, do I STEM category? I don't understand what STEM category means. Are you talking about OPT STEM?
STEM OPT, I think, yes.
Yeah, can you please be more elaborate as to what you mean by STEM category? What STEM category? F1 OPT STEM? Then you have to have a master's in the US in the STEM category to qualify for STEM OPT.
Okay. Ravi, we would like to know more about you. And in fact, you can also call us up, on this number 425-436-6335 and dial in this access code 988-888. Say hello after that, we'll be able to hear you. And hi, Rag. Thank you so much for joining. Rag says hello, Napasa and Prashanthi. Rag, please feel free to join us on this call also, or yes, just comment your question. We will address it soon. Let's move on, Prashanthi. Now, if you could tell us, given the limited number of H-1B visas and the high volume of applicants, do you think the lottery system is still the fairest way to allocate these visas? Why or why not?
There are arguments for and against, with reference to whether the lottery is like a blind system is the best way, or should the numbers be allocated based on where the need is, or where the country needs them, which the industry with where the country needs them, right? So, such as high demand areas such as IT or healthcare, etc. So, the argument for, of course, there is. Let's talk about whether it's the arguments for the lottery system. Is this a good way of allocating H1B numbers, because there is oversubscription, and earlier it used to be first come first serve, but that was chaos because all the cases, thousands of applications were filed in one day, and then they would just reject applications that the excess applications, and there was no system on the basis of which they were rejecting them, because all of them were being received on the same day, right? So now they're trying to follow a system which is like a lottery system. So and then there is 90 days to file it. So it's a better system compared to the previous one. The lottery system grants equal opportunity. There's transparency in the process, and administratively it's easy. So you don't have uh, thousands and thousands of pages of applications sitting in USCIS being and having to be processed and being sent back if they are not um, approved under the lottery and they're not selected under the
Yes.
lottery. That was the previous system. So definitely the new system is better in that way because it's fairer, and administratively it's much, much better. But there are arguments against the lottery system also, because if you're leaving it to chance, which is what a lottery is, it's not merit based. So you're not considering the applicant's skills or experience or the applicant's potential to contribute to the US economy before deciding whether to give them the number or not.
Mhm.
Highly qualified individuals may be left out, while people less qualified will be selected because of the pure chance of the lottery.
Yes.
It discourages innovation because there's no incentive for employers to seek out the most exceptional talent, right? Or people with master's degree or maybe 10 years of experience, because the qualification for a H1B is the same for everyone. So what changes can be made because of this? What are the potential alternatives to the lottery system to allocate H1B numbers? I guess you could have a merit-based system where you prioritize and give numbers to those applicants based on factors like education or work experience or skills. Or you can allocate numbers based on industry specific. So say if you are a hospital or you're in the healthcare industry, you can give a certain allocation of visas, H1B visas to them, maybe to nurses, to doctors. Um, or you can just, the best alternative is to increase the H1B cap, because we know that the numbers that are presently there are three times that are being filed. So you have to increase the cap by three times to meet the demand. So
Okay.
that's, in a nutshell, what the alternatives are and what I think about of the present lottery system.
Visa lottery system. Yes. Thank you so much, Prashanthi. Thank you for taking that up. Rag is here with his question now. But before that, let's take up Ravi's. Ma'am, I meant the H1B under master's cap for masters from India.
Okay. I'm glad we asked the question and he
Yes, I'm glad.
responded. Yeah, a master's cap. To qualify for a master's cap, you have to have a US master's degree. So it cannot be an Indian master's degree.
Okay. So, Ravi, unfortunately, I do not think you qualify for the H1B master's cap then.
Unless he does
Thank you,
he does
Prashanthi.
a master's degree. he
Again,
can qualify.
another
Yeah,
one.
if he does a master's degree in something else, then he could qualify.
Mhm. Okay. All the best, Ravi. And now let's take up Rags. Rag is saying, what about the tech non-profits as compared to startups and the big companies?
There is no. I mean, is he talking about what about what? I mean, what is the question? The chances of getting a H1 visa, or is this a continuation of the previous question? Uh, I can't hear you, Nipasa.
Rag, if you could be more specific with what you want to know, maybe give us more details on your question, it would be, I mean, more
Yeah,
convenient
rather
for us
than
to answer.
me presuming what you're saying, and yeah, ask the question completely.
Yes. And Ravi
It's
says,
easier for
thank you.
the
Okay, Abbas now. We have this is
viewers
on.
also that.
Right, right. We have Abbas's question from Prashanthi's channel. So really good to have you, Abbas. If I have one of my company will file H1B, can I work with the other company without filing H1B? They are same job title while I'm an OPT and applying for H1B. Thanks.
Um, so again, the fact scenario is not clear, but looks like the person is on working for another company on OPT and wants to know if they can continue to work on OPT while the H1 is being filed. Yes, you can. You only need to move to that company which files your H1 once it's October 1st if it's a cap case, or the H1B is approved, whichever is later. Then you need to move to the employer that's actually filed your H1B cap. You cannot continue to work for the previous employer.
Okay. Thank you for taking that up for Abbas. Abbas, I hope you got your answer. If you have more questions or you need more clarifications, keep commenting. I think now we have some more questions, Prashanthi, and these are from our Facebook groups. So I'd like control to please display them. Let's take up this first one. For Dropbox H1B, is there any fingerprinting process or direct Dropbox?
There's no fingerprinting process as far as I know. I think it's just a Dropbox. And this because Dropbox is available for people who have previously had, filed a visa. So the presumption is they already have your fingerprints on record. But again, I could be wrong. So I can look that up and answer if there's any fingerprints.
Sure. Sure, Prashanthi. And while we check that, maybe we can read out this next question. This is from an anonymous member. I am on H1B visa. Now my mother is in ICU. If I am traveling to my home country and while returning, is there any issues? My spouse and my newborn kid will stay in the USA. And please let me know what all documents do I need to carry along with me. Thanks in advance.
I'm presuming this question is because Trump administration is going to come to power, so everybody's worried about traveling, at least until things are more clear. Um, so I think, I mean, I don't expect that the laws will be significantly changed over this short term period, because in order to change the laws, there is a certain process and we will be given notice. But what will happen is become more difficult. There'll be more scrutiny on everything. There'll be more requests for documentation. So I with reference to this particular aspect of traveling and coming back um, on a valid visa, and if you have, as long as you have a valid job, etc., there shouldn't be any problems, but they might ask for more documents. So make sure that you carry everything with you, including your pay stubs to show that you're in status, your H1B approval, of course. If you can carry the original, that'll be great. And be ready to be prepared to answer any questions. Make sure you're in status. You file the required amendments if needed. If you've changed job location, you are getting paid the salary as per the LCA. So make sure you're meeting all the conditions of the H1. Don't take it for granted. Review your petition, carry a copy of your H1B petition, ask that from your employer. And I would just be more careful rather than presuming that they'll just brush you through like they usually do. They just wave you through, right, at the port of entry.
Mhm.
So presume the worst and go prepared.
Okay. Thank you so much, Prashanthi, for addressing this one. Let's move on to our next. This is another anonymous member asking, last year in September, my husband moved to the US on an H-1B visa and I joined him on an H-4 visa. Unfortunately, this September, he was laid off. To maintain lawful status, we applied for a change of status to B2 before the grace period ended, and USCIS has confirmed they received our application. Our B2 status is valid until April. In the meantime, I've been admitted to a nursing school to complete my prerequisites, and I'm eager to stay here to pursue my career in nursing. I plan to apply for an F1 visa, and once my husband secures a new job and returns to H1B status, I intend to continue my studies. Has anyone have has anyone been in a similar situation? And what are the chances of my F1 visa being approved under these circumstances? I would love to hear your experiences or advice.
Yeah, there are a lot of people who are in similar circumstances. In fact, every week I get several phone calls, almost once a day, from people who have been laid off and are trying to explore how to remain in the country and what to do with the 60 days grace if they don't get a job within that 60 days, because 60 days is not a long time to find a job, right? So most people do file for a change of status to a B2 or an F1. It depends on what their long-term plans are. Um, I have not seen issues with change of status from a 60 days grace to an F1. Um, they are asking for proof that you're maintaining your residence in India, and they're asking for property documentation, proof of residence, etc., Aadhaar card or whatever ID cards if you're from India.
Mhm.
So they are sending RFS related to that, and also proof that you have money to, uh, you know, uh, to continue your education or to pay for your tuition. So these are some questions they're asking about the F1. But in your situation, since you have a pending B2 application and you don't have the actual B2 approval, and you'll be filing an F1 um, from the pending B2 application, um, there might be a question of what is your present status, and they might send an RFE asking for proof that you have an approved B2. But USCIS has again said that they will accept bridging petitions. So hopefully, unless the new administration comes and changes that, you should be able to file for a change of status from a pending B2 to an F1.
Okay. Thank you for
Napasa,
taking that up, Prashanthi.
sorry,
Yeah.
Napasa, I have one more minute, and after that, I have somewhere to be. So
Sure, sure. Let's take up a buzz's question quickly then because he's here. So it's a continuation. Because I couldn't find a full-time job, I had one company I'm working with. They will file an H-1B, but I still have other job offers for another part-time. But they said they won't file H-1B. Can I work for both without affecting my OPT status? He's asking.
you can't, you should file, as I said again, you have to file the H1 because you have to file within that period of time. You don't want to lose your uh, H1 if you get picked in the lottery. And you cannot work for the second company on OPT unless you file your H1 for consular processing. Then your H1 will not get converted to a H1 until you leave the country and come back. In which case, you can continue working on your OPT for that company and then change to the H1 employer when you want to by leaving the country and coming back on a H1 visa. But you cannot work for both OPT and H1 at the same time.
Okay. Thank you so much for taking that up, Abbas. And thank you, Abbas, for your question. Thank you for participating. And Okay, last but not the least, does the USCIS have a bias for or against grant taking nonprofit tech initiatives?
I don't see why there should be a bias
Okay.
for
Thank you,
nonprofits
Rag.
or yeah. I don't see that there will be a bias. I don't see a reason why.
Okay. Thank you so much, Prashanthi, for answering so many of our questions, especially our viewers' questions. I'm sure they must have all benefited, watching us here in the session and learning so much from the session. Thank you so much, and I'm looking forward to having you back once again in the coming week.
Thank you, Nipasa. Take care. See you next week.
Thank you, Prashanthi. Have a great day. And folks, you can always contact Attorney Prashanthi Reddy. You can write to her, you can email her or call her on this number 212-354-1010. And her email address is prashanthi@reddyesq.com. And go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Thank you, everyone, for joining us. But stay tuned on Immigration and Job Structure because we have more sessions coming up like these. And yes, check out our space. For now, it's Nipasa saying bye. Have a great day ahead.
Hello?
Hello, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan. And before we move on with today's amazing discussion that we have lined up for you, I have this important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us wherever you've joined us from. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So please feel free to drop your questions in the comments if you have any, especially with regard to our topic of discussion for today. And it's going to be amazing because we have none other than our guest for today is Justin Rivera from Wasden Immigration Litigation, a senior immigration attorney at Wasden Immigration Litigation, and his passion lies in guiding individuals and businesses through the intricacies of immigration law. Well, Justin brings years of experience from top law firms and the Texas Attorney General's office with a proven track record of success in achieving the best outcomes for his clients. So today it's going to be awesome because Justin is going to join us once again. And today's topic of discussion, I will tell you what is it. But hi, Justin. Thank you so much for joining us today. It's so good to have you.
Hi, thank you for having me. Yeah, and I believe today's topic of discussion is going to be kind of just a roundup of the year. The different things, some of the different things we've seen in 2024. Maybe looking ahead a little bit on what we can anticipate moving forward.
Absolutely. Yes. So, what shaped US immigration in 2024? And we're going to do a complete recap. And thank you so much, Justin. I'm excited for today's discussion.
Sure thing.
So, folks, if you have any questions with regard to our topic, please feel free to drop them in the comments. We will take them up. We will address them a little later in our webinar today. And to start off, Justin, I have some questions prepared. And if you could tell us, USCIS recently announced that medicals are now required at the time of filing for the I-485 applications and reversing the previous policy allowing submission with an RFE. So, how will this impact the adjustment of status process and applicants' preparedness?
So yeah, this actually replaces a longstanding policy. It was something that had been, I believe USCIS had this policy in place for 25 years. Could be wrong, but I think it was something close to that. Anyway, traditionally, you weren't having to worry about presenting medicals at the time you applied because you would then just get a request for evidence. And then at that time, you could get your medicals taken care of. Now, the validity period of the medicals, that had been an issue. They had been much shorter than they are presently. I believe now they've moved them out to where they last a significantly longer time. They're still fresh, essentially. The argument basically posited by the service is because of that, let's just get the medicals when we're filing. And if you don't present them to us, we're going to reject your application. But that way, when we're actually processing the 485, we don't have to worry about issuing an RFE on medicals. We can just go ahead and approve. Beneficial in theory, and I think long-term, probably something that's going to be good. The issue will be its short-term implication. The announcement came out with next to no notice period. It was pretty much almost immediate, which inevitably is going to lead to an uptick in rejections, probably even improper rejections, where people are jumping the gun on implementing the policy before it was actually implemented. So that's going to be the short-term impact of it. I'm hoping that the long-term impact of it is of benefit in that it does create a situation where now that these are absolutely necessary at the time of filing, you present them and you're able to have your I-485 processed a little bit faster.
All right. Anything new added to the list? A list of medical examinations that you'll have to go through?
So I mean, the thing about it is it's kind of a constantly evolving animal. It's something that at any time there can be some sort of alteration or change made to what's being required. So that's the other
Right.
side of the coin with medicals is, sometimes you would often be like, let's not worry about the medicals now. When they process your case in X amount of time, years or however long, if the policies have changed, we'll have to get new medicals then anyway. So as a result, just wait till the RFE comes out and address it then. So you do kind of have to look at what's the impact of that, because obviously USCIS is not going to say, oh, this is required when we're adjudicating, but it wasn't required at the time you submitted your application. So we'll probably just let you go through. It would shock me if they did do that. It would be practical, but it would be surprising. So I definitely think there could be an instance where, if something new comes out that's required, someone gets an RFE where they say, hey, now you have to, provide a new medical. But that being said, it's not that big of an issue, or it shouldn't be that big of an issue. And hopefully, like I said, the underlying goal for them is to move down those adjudication timelines and make the process faster. And hopefully this does that.
Absolutely. Looking forward what this change would bring. Yes, for
Mm.
sure. Let's go on to our next question, Justin. And what are the most significant immigration policy changes introduced by Biden administration or Congress in 2024? And how do they reflect the administration's broader immigration agenda?
So I think that they did some positive stuff. I mean, give them credit where it's due. I'm looking over here because I wrote them down. They did automatic extension of the validity for green cards to 36 months for LPRs who timely file before my 90. They are increasing the H-2B cap with 65K additional for next year. That's positive. TPS for Lebanon, that's positive as well. From a practical practicing perspective, primarily dealing with, work-related non-immigrant visas and immigrant visas, I think that they have tried to speed up processing, which is positive. But the other side of that, at least in my opinion, is I think that when they've introduced these new premium processings for things that traditionally didn't have premium processing, I think that they have kind of pushed back against actually using premium by issuing requests for evidence. And I have traditionally been of the thought process that just by virtue of filing and premium processing, you're not really increasing your probability of an RFE. I may have to redact that statement after what I've seen over the past couple months, because I do feel like there has been an uptick in premium processing requests for evidence. So while it is in theory they're trying to do things to help the system, I do still think the system kind of gunks itself up to kind of give the adjudicators more time. But I think overall the Biden administration, over the past year, they have taken steps to improve how the process is and streamline things.
Mhm.
So that being said, with that administration moving out, we'll probably see a little bit different of an implementation moving forward.
Right, right. And just a few days left, before Trump joins the office. So, what do you think is happening in this 1 month? Almost a month. I think we still have a month.
You might see a flurry of action going out the door as they hurry to try and finalize policies in the federal registrar. I know that there had been talk about there's the extension, the automatic extension for H4 EADs, and then the L2s. I'm they may make that they may put that in the system permanently. They may make that through policy something that remains.
Hmm.
That would be a positive, obviously. Um, you might see some other small changes or designations, but the fact of the matter remains is anything that's not just like made law, something that's just an act, or like designations of TPS and things like that. Those are things that can be reversed with very little action that has to actually be implemented. It's the actual rule making changes that take a lot of time to be modified. And those kind of permanent things, if we see that through the last month, that would be very beneficial. So we'll have to wait and see where it is on their priority list. But
Right.
I'm hopeful that we see a couple more positive changes.
Me too. Me too. All right, Justin. So, how did the Deferred Action for Childhood Arrivals or DACA program evolve in 2024? And were there any major legal or legislative updates affecting Dreamers?
So I definitely will say that I will definitely say here that DACA is not a main part of my practice. I mainly do, work based. That being said, I try to follow DACA. I did see that there was expansion for healthcare. So in the ACA marketplace, it was actually in the beginning of November. People who were on DACA were actually able to buy into the marketplace to get health insurance, which is awesome. And then there's faster work authorization for people that have earned a degree. I know that that's a policy that they're implementing or wanting to implement. So those were the two big alterations that I saw. A lot of, and I genuinely mean this, not like it's not a situation where I'm like a lot of people are saying, and I'm just bringing it up. I've had a lot of conversations recently about where DACA goes with the changing of the administrations. And I try to point out to those people that in terms of what the new administration wants to do for immigration, they've laid out a lot of track in terms of what it is they want to do. I think everybody is very familiar with the fact that they want to do the mass deportations, ending birthright citizenship. They've now talked about deporting pro-Palestinian student protesters that are on temporary visas, ending parole programs, and ending TPS programs. From what I've looked at, I haven't really seen DACA on the table. And I think the reason for that is because it is, generally speaking, a popular program. I don't think that there's a large amount of pushback against DACA, even from people that are more restrictive in nature for immigration policies. So I definitely think that you're probably going to see DACA in the news, and people discussing DACA and whether or not it's going to be altered or attempts at removal. All that is to say, my opinion would be I don't see it going anywhere, just because it doesn't seem like it's something that they have high on their to-do list.
Okay. Okay. Thank you so much, Justin, for the detailed explanation. And folks out there, thank you so much for joining us. You can keep commenting if you have any questions. Type them in the comments and we will be able to address them in this show. And thank you, Priyanshu, for your question. We will address it a little later. So stay with us, all right? So, Justin, my next question to you is: did the US immigration system witness any new visa reforms, particularly related to the H-1B program or family sponsored immigration? And if yes, what were their implications?
So a really big one for the H-1B was the beneficiary centric lottery.
Yes.
Moving away from the idea that multiple petitioners are able to quote unquote game the system by putting an individual in, a multitude of times with the intent of just making sure that they get selected. Now it's beneficiary centric, meaning regardless of the number of sponsorships, it's one person is entered one time. There's no real way for you to utilize multiple registrations. So that was a very big change, because I think in the past, there's been this idea that there are certain types of companies or joint groups of companies that will seek to work together basically to improve their odds of selection. So that's gone. Increased fees was another thing. You saw fees going up. You saw the introduction of the I believe we call it the asylum fee now, this extra $300 fee that's supposed to be utilized for people for USCIS to reallocate at the border. That was something. Online payment was another thing. Being able to file applications online and actually have legal representation for those H-1B payments. The credit card payments, I think, was another thing. At least for me, I hadn't really used that at all in the past, but now that's something that I think is becoming more common now. Just the ability to just use the G1450 form and make a payment from a credit card rather than having to just use traditional checks over and over. I think that's been beneficial to streamline the process. There's definitely been, I don't want to say attack, but USCIS has focused on multi-registrations from past lotteries. That's something that I've seen. An increase in notices of intent to revoke for people that they believe were sponsored by an organization that colluded with other organizations to increase the probability of someone's selection. This is something that's being kind of fought on in court. Our firm, Wasden Immigration Litigation, actually has some cases active in this manner regarding this factor, but it is something that we continue to see. And it's something that might continue into next year. It just really depends on how much USCIS is trying to push the issue. The other thing that I've seen personally is an expansion on the scope of notices of intent to deny and notices of intent to revoke as they relate to previous alleged assertions of fraud or misrepresentation. Kind of giving you examples here, I've definitely seen situations now where people are trying to extend a current non-immigrant status. Maybe they're trying to extend an H-4 or an H-1B, and they get a notice of intent to deny, basically saying that they are ineligible due to an admissibility based on a perceived finding of fraud or misrepresentation based on a prior non-immigrant visa. A lot of times this is an F1 issue, particularly with working with some of these, quote unquote fraud employers. But I've definitely seen an uptick in that as well. Whereas, even maybe 2 years ago, you weren't seeing any attacks on admissibility for people that were extending status in the United States. At least I wasn't seeing them. So that's another thing that I've witnessed as well for the H-1B program. Prospectively, I think we've had previous discussions about this. It's definitely, there's a lot on the table in terms of what wants to be done by the next administration coming in to make changes. Realistically, those changes will make the system more restrictive, but we are in a wait and see approach. But kind of curtailing the end of year for what the Biden administration seemed to do with the H-1Bs, they really wanted to go after fraud. That seemed to be their biggest goal, was going after fraud or misrepresentations that had been made by companies. And unfortunately, the impact of that is wide-reaching in that it can also impact employees. So the employees in some of these circumstances have ended up having their cap subject H-1Bs revoked, which puts them in a circumstance where they're not able to be on an H-1 anymore because they're no longer cap exempt. So that has been something we've dealt with as well. But I definitely think fraud, misrepresentation, going to be on the table next year. I think going to be a big aspect of the new administration. Would not be surprised to see a significant uptick in, site visits, FDNS investigations. I think all of that is going to be on the table moving forward.
Absolutely. We are in for a lot of changes starting 2025, folks out there. You just have to stay updated. Research is important, and it's very, very important to stay updated with each because everything is so dynamic and it keeps changing. Like Justin
Mm,
mentioned earlier, there are always new updates. So you just have to be very, very vigilant, careful, and updated for sure. And
right.
folks, you know what? You can also join us in this conversation, by the way, by dialing in this phone number. And you just have to dial 425-436-6335. And when they ask for the access code, dial 988-888 and just say hello. We'll be able to hear you. Looking forward for you to join us on a call. So also thank you to Yash Chopra for your question. Stay with us. We are going to address your question a little later in the show. All right. And so, Justin, now my next question to you is, how did U.S. Customs and Border Protection, or CBP, and Immigration and Customs Enforcement, or ICE, approach border security in 2024? And were there any notable incidents or shifts in enforcement tactics?
So I will say that according to CBP's website, they have tripled their expedited removal numbers from last year. So I think there was a significant uptick in expedited removal. Now, how does that apply to people that are attempting to enter the United States on a non-immigrant visa? Well, every time you are admitted to the United States, you are inspected. You undergo inspection with CBP. Most of the time, that's people who are flying in. So when you go through CBP at the airport, you open yourself up to inspection. That inspection can be pretty brief and quick. If an officer just makes a very quick determination, says, okay, I don't see anything in your record, you're good to go, then you're fine, you go right through. If there is cause for concern, an idea that there's a problem, or maybe even a notation in the person's immigration record, that person is put in what's called secondary inspection. This is a longer interrogation period. When they're put into that circumstance, they are basically going to be questioned about whatever specific reason the officer initially pulled them in. They'll probably talk about their current non-immigrant visa, any prior non-immigrant visas. They can bring up statements that were made at the consulate, statements that have been made to officers in the United States. All of that is on the table. I have definitely seen, just anecdotally, an increase in my opinion, aggressiveness with officers and how they are operating when they do these CBP delayed secondary inspections. And when they're in that circumstance, they have a lot of power. They have a lot of power over the individual, because they're able to make determinations that are long-reaching. If they cancel someone's visa and they place them in expedited removal, that carries with it a 5-year ban from the United States. And that's not even speaking to the reason for the removal. If the reason for the removal is related to fraud or misrepresentation, then you're also incorporating a lifetime ban. So I have definitely seen an increase, in my opinion, in that. The officers, when they do these inspections, they have a right to look at the information that is physically contained on your person. This includes things like a computer, a phone, any of that stuff, social media, emails, all of that is on the table. Just anecdotal, just speaking off from personal experience, resumes have become a very big point for them. They are very, very diligent in reviewing people's prior resumes. If they have a copy of the physical resume on their person or a copy of the resume on their computer, they are looking at these documents very closely. They want to look for, did you list an employer that you didn't actually work at? Did you list an employer that they're alleging you didn't have work authorization to work with? Did you ever verify that you worked with that employer? And if you didn't work with that employer and they were listed there, did you try to procure an immigration benefit using that resume? I have seen a lot of cases over the past 2 or 3 weeks where people were dealing with these resume issues, where they were either drafting a resume or making changes to a resume, and the iteration of the resume, even if it's not the final version, was on their person when they were going through, and they were pulled off, and this issue was brought up. So I would say, just kind of generally speaking for everyone moving forward for the next 4 years, really good idea is, if you're going to carry any form of a resume on your person when you're coming into the U.S., that resume needs to be 100% accurate and up to date, and also be prepared for any and every item on your person to be open to inspection. So if that means making a determination like shipping your laptop ahead of you instead of carrying it with you on your person, that's something to think about. I know people are not going to ship their phones. I know the world we live in. But if that's the case, maybe be aware of everything that's on your phone, because it is all information that the officer could look at. So yeah, just kind of buttoning that up. I think we've seen higher rates of screening, and I think we're going to continue to see that moving forward. As we move into the next administration, because there is just so much power. There is an imbalance of power when there's a CBP inspection underway, because you have someone that's in a room, they don't have legal representation. They are opened up to questioning. Most times these people are not prepared for these questions. They're probably being asked about employment that was 4, 5, 6 years ago from a time where they were maybe on an F1 or on an H with a different employer, makes you open to possibly making misstatements. And those misstatements are something that the officer would seize on and, use it for grounds for visa revocation. So I do think that moving forward into the next couple of years, we as counsel and then the employees are really going to need to become simpatico on being ready to deal with these issues, dealing with the idea of increased scrutiny for inspection and making whatever changes we can to ensure that the process is as smooth as possible when somebody's applying. Because at the end of the day, no one's going to just hang out here for the next 4 years under the guise that they're scared to leave and re-enter. It's just not
Mhm.
realistic. So we do have to
Right,
have a plan in place on how we help people moving forward.
right, right. Well, thank you so much. And talk about investigation or scrutiny. I think we will not have any more privacy then. I mean, if
No.
everything in your phone can be checked, that means anything and everything in your life can be checked.
Right. And yeah, I mean, there's circumstances where people have had their emails gone through for, 8, 9 years long of emails. Just an
Whoa.
officer just going through everything, typing in employer names, typing in manager, supervisor names, because their goal is to look through everything to see if there's anything that they can find that gives them cause to move forward with revoking a visa. So yeah, I think it's been more difficult moving forward, and I think it's going to be much more difficult as we deal with the next couple of years.
Wow. Thank you, Justin, for giving us a sneak peek into what we can expect in the future. I think we
Mhm.
should address Priyanshu's question now from YouTube, saying, I'm waiting on my green card. What do you think were the most important changes in 2024 that could impact me? Okay.
I mean, if you've already filed and you're waiting for adjudication, then hopefully the process is fast enough that it's been streamlined and you're not going to have to wait a long, long time. If your 485 is pending, and hopefully it moves quicker. My worry, prospectively, would be a really easy way to make immigration more difficult without having to actually make wide sweeping changes is to really just make small changes that slow down the process. Small things that we now require this, which we didn't require before, or
Mhm.
we're going to start requiring interviews for everyone in this type of category, even though we haven't done that in the past. That was something they
Mhm.
did before with the introduction of biometrics for in categories that traditionally hadn't required biometrics. It's adding steps to slow down a process to make it much longer and more difficult. That would be my worry moving forward. I would definitely hope for you that you're hopefully able to get your 485 adjudicated before the end of the year. If not, hopefully before maybe February of next year. If that's not the case, it'll be another wait and see. But I'm hopeful that they do seem to be operating under the desire that they're trying to move cases as quickly as possible. So for you, I would just say, the changes in the medicals, that shouldn't have affected you because you've already filed the 485. And hopefully you're just able to get everything as quickly as possible.
Me too. Me too. All the best, Priyanshu, and thank you for participating with your question. If you have any further questions, you can keep commenting. And now we have Yash Chopra's question. For students on F1 visas, were there any updates this year that made it harder or easier to stay in status while they're studying?
So one thing I did notice that I hadn't noticed before was there had been kind of an expansion on STEM OPT, like what kinds of categories, what kinds of study, what fields qualify for STEM OPT. As a result of that expansion, I definitely saw an uptick in requests for evidence in relation to, I believe it's called the CIP. So it's the specific number that's basically used for the program type. And then the need to show a nexus between the CIP type chosen and the actual STEM OPT eligibility based on the field of study. I think that it's interesting because I don't know if USCIS did that just because they were thinking that people were overreaching on getting people into STEM OPT, or if they genuinely were just saying, how does this correlate? I actually personally hadn't seen any denials because most of the time you're able to get something from the school that provides a very clear cut explanation. However, I do think that opens up a window into a potential strategy for something that could be used for the Trump administration moving forward. It's possible that targeting the CIP codes a bit harder and making the regulation more restrictive could result in the removal of some fields. We'll see what happens with that, but that is something that I look to, that I wonder about moving forward.
Okay, okay. Thank you for taking that up, Justin, for Yash Chopra. And I wonder if you deal with asylum cases, but we have a next question from Sunita about asylum. So maybe we
So
can.
I don't specifically work on asylum cases, but I will generally tell you that asylum applications. My understanding with asylum is that uh, the process was still difficult. It was still not, not an ideal streamlined process, but it was still somewhat better than what it was like in the Trump administration. Uh, in the Trump administration, I think it's going to be significantly more difficult than it was. I think that asylum is one of the specific things that he looks at targeting, or that his administration looks at targeting, is limiting the ability for people to even apply for asylum in the first place. You're looking at things like Title 42, the MPP Remain in Mexico program, just more generally the border wall. I know that they definitely look at ending TPS for people. So that's something that's on the table as well. But yeah, I would say, just generally speaking, I know asylum is probably going to get much harder. I don't even think the asylum levels were very high this year. And that being said, knowing that, I think that moving forward, it's going to be much more difficult.
All right. Thank you. Thank you. And Sunita, I don't know if that would be helpful enough, but there you go. Thank you, Justin, for taking that up.
Hmm.
And yes, moving on, my next is also about asylum, actually. The US saw a significant number of border crossings this year. And what changes were made to asylum protocols or Title 42 policies to manage the influx?
So we know Title 42 obviously had been taken off of the table eventually by the Biden administration. A lot of people complained that it wasn't done as quickly as they wanted it to be done, but it was still something that was inevitably done. And so that was beneficial, obviously, for people that are trying to get into the country to apply for asylum.
Yes.
I think that you're going to see a reiteration of that policy somehow. I'm not sure if they're going to use like bird flu or something like that as a justification, because it has to tie to a health concern. But I do think you're going to see that coming up. I think that the Remain in Mexico program is going to come back, as well. I think that that's going to be something that's on the table. And I think that you're even going to actually see an iteration of that implemented in Canada, because they have already come out
Okay.
and started making statements about, oh, people immigrate, people come in, illegally, quote unquote, not only from Mexico, but from Canada as well. So we need to
Okay.
increase scrutiny. And how do they do that? They probably implement similar policies that they have along the southern border. So, yeah, I think that you're going to see restrictions. I mean, that's what people voted for. They voted for the idea that they wanted to curtail entries at the southern border, and to a lesser extent, I suppose now, uh, at the northern border. And so I think what you're going to see is at least a desire from the administration that's coming in to really
Mhm.
get a handle on those numbers and curtail them, because that's how they're really going to try to show that they're implementing the promises that they made. And so they have a lot of avenues, I think, that they're going to be able to do. I mean, family separations obviously on the table, as well, even though it was incredibly unpopular. You're dealing with a circumstance where this administration's coming in, and they know that they've been able to do something like this in the past, so they're probably going to lean towards it moving forward. So I think you're going to see all of that. I think it would. There's no way to me, that we're not going to see numbers drop. It wouldn't make sense. I think that there's going to be crossings should go down. If they don't go down, I'd be very surprised.
Okay. Okay. Well, yes, I think border security is going to definitely get harder. And now that we have our border czar, Tom Hooman, I think he's going to do everything to make it even harder.
Yeah,
Yeah.
absolutely. I could just, yeah, it would not shock me if, there was everything on the table in terms of what they can do. I think there's going to be more officers hired, more money thrown into this
Yes,
circumstance, the re-implementation of all the policies that they were able to use last time, and then a couple new things that they didn't have before.
for sure, for sure. Well, thank you, Justin, for taking that up. And now, my next question to you, Justin. I'm really rushing through, right? I really hope you're okay with that. But yeah, with the labor shortage continuing in key industries, how did changes in employment-based immigration policies such as the H-2B and the EB-3 visas shape the US economy this year, 2024?
So yeah, I mean, I think you saw it with the H2B expansion. The fact that they're hiring, they're expanding. I think it's by 65,000. I think that they definitely realize that there's a shortage. Actually, Roshni just asked a very similar question, that there are shortages in certain industries, particularly farming, that needs more employees. Like there needs to be more people doing those agricultural jobs because there's just not a workforce there. So I think you've seen, I think you've seen the Biden administration implement policies in order to address that issue. Do those policies remain in place moving forward? I kind of think they do. Just because things like the H2B, it's genuinely beneficial, and I don't see a lot of pushback. In terms of all of the different types of immigration programs that have high approval rating, I don't really see a lot of pushback for the H2B. Also speaking kind of more generally about healthcare and those those other industries that have shortages that are typically filled by non-immigrant visa holders. I'm hoping that there'll be a bit of credence given to them moving forward. I think maybe there hopefully will be more of a preferential treatment to those fields when they're trying to fill them with specific non-immigrant visas, because I mean it's needed, and I definitely think when you kind of look at immigration, there is this push and pull with immigration where there even the people I think that are hardliners on immigration will admit that restricting immigration within the parameters, within the fields that have valid shortages, it's nonsensical, because if there's genuinely not a workforce available domestically to fill that need, then there has to be someone else that's willing to come in. And that's where you have to utilize immigration. So I think that I've seen positive movement on that regard over the last year. And I think, I've been critical a lot of the Trump administration and immigration. I actually think you might see that remain as we move forward. I think that that's not something that they're really going to want to push back against, because it has that high approval rating. It just, we don't want to create shortages where there's literally just not people to perform agricultural work. And you're dealing with circumstances where there's just not employees available to do stuff, and people in that field are losing money as a result, and it's being felt by consumers because there's less availability. So all of that would lead me to believe that that's something that it has been trending in the right direction, and it's going to continue to do so.
Wow, thank you so much, Justin, for the detailed explanation and also for taking up Roshni's question at the same time.
Yeah, it was very convenient.
Yeah, actually, yes, made sense, and thank you for doing that. Well, moving on, what impact did new immigration trends have on American industries? Well, since we spoke about it already a little bit, but
Mm.
healthcare and tech, where foreign labor also plays a critical role, if you want to add anything more to this point.
So I think a big thing to at least address on is tech and where we're going with the tech industry. I think that there's a back and forth right now in terms of what is wanted by people in higher positions of the Trump administration. You have the Stephen Miller side, restriction, America first, you know, curtail immigration as much as possible. But then on the other side of that coin, you have the tech industry people that have supported the Trump administration. Obviously, you have Elon Musk, Vivek, and then there's other individuals as well. Those individuals, it would make sense, want to ensure that the tech industry continues to thrive, and in doing so, utilize foreign employment. So that's going to be things like increasing or keeping at the same level individuals that are employed on H-1Bs, L-1s, TNs, all of that. So I think that tech is it creates an issue of who wins out in that circumstance. And it would make sense to me if you saw the tech industry, if they're continuing to grow, continue to utilize these non-immigrant visas without as much pushback as I think you may see in other industries. And then to be truthful, there has been conversation about, is there almost a two-tiered system of the way you look at the allocation at this point, where, if you're the big company over here and you apply, your process is a streamlined approval. If you're a smaller company or maybe a consulting company, do you go through a more rigorous, detailed process that requires you to jump through a couple more hoops? And I do wonder if that's going to kind of be what we see. I think it's been something that's already existed with the Biden administration. I mean, personally speaking, I've worked on both sides. I've worked with very big companies and very small companies. Everyone gets RFEs at the end of the day, whether you're a big company or you're a small company. The detailed nature and the specificity of the RFE may be a little different if you're a smaller company than you are a big company, especially if you're a third-party placement company. And so I do wonder how that's going to be impacted moving forward with tech and what we'll see there. Yeah, I mean, for healthcare, kind of speaking on what I said before, industries that have legitimate need and have shortages, hopefully moving forward, we're going to see that factored into the analysis of visa allocation.
Yes, I think it's very important to be proportionate, in all levels so that, these needs are met optimally, I guess.
Right. Yeah. I mean, especially if there's literally just not availability. I mean, if you're in a
Yes.
situation where you're an employer and you need to fill a position and the applicant pool is tiny and the applicant pool is being overfished because there's so many companies that need these people, you have to find that somewhere. That position
To
doesn't
fill
go
that,
away.
yeah.
Need has to be
Mhm.
serviced. So in order to do that, you have to, look to what your other options are, and that includes, bringing people in.
It's true. Well, thank you, Justin, for taking that up.
Mhm.
So, did 2024 bring about any significant changes to family reunification processes or humanitarian visas, such as the U visas or the T visas? And how did these changes address the needs of vulnerable populations?
So again, as I said kind of earlier, not my specific wheelhouse, but I do have a cursory understanding of U and T visas. So for the U visas, I know that they made some tweaks essentially to the eligibility category, basically moving it to where you needed to prove not only that you were assisting law enforcement or attempted to assist them, but that the actions were helpful to law enforcement during the investigation. So I know that the goal of that, I think, is supposedly to streamline the process. But obviously, with changes can come additional scrutiny. So whether or not that helped, you would have to speak to someone who specifically works on those kinds of visas. But I know that the goal was to make the process better as a result. Now, with the U visa, you do have that 10K cap. And I know that there's a pretty big applicant pool for that 10K cap. And I know that that cap gets met pretty consistently. So I know that there's a long processing, and that's probably something that's going to continue. I don't think that that's going to be at the top list of the new administration's to-do list for immigration. The T visa, I know that they wanted to streamline the process for victims of human trafficking. They made changes to eligibility qualifications, and then they wanted to modify what they call the bona fide determination process. So I know that those are both situations. If you're unfamiliar with it, T is victims of human trafficking. U is basically people who can help the government because they either witnessed or were a party to some sort of criminal activity against their will, and they're now seeking to use that information, and they want to help the government, and in return the government seeks to help them by giving them a visa. So those are two different ways that people can qualify for that. And I think 2024, outside of those changes, those were the only ones that were made immediately aware to me. In terms of what you're looking at prospectively moving forward, I doubt that there'll be a lot of change. I don't think that there'd be any reason for there to be a change. Again, this is another one of those circumstances, kind of like the HGB, where you look at these visa types, the U and T, and you say, what's the approval rating of these? I don't think people push back a lot against helping people that are victims of human trafficking or people that were, victims of criminal activity that are trying to rectify that issue. So I think you're probably going to see a lot of status quo moving forward.
All right. Thank you so much, Justin, for taking that up. And folks out there, you can call in to ask your questions and, maybe take this opportunity to have a one-on-one, like short consultation, you can say, with Justin if you have any questions for him.
Oh,
And you can call in this number, dial this number 425-436-6335. And when they ask for the access code, just dial 988-888 and say hello. We'll be able to hear you. And yes, looking forward if you can join us. And so, Justin, yeah, Many applicants faced lengthy processing delays this year, and how the policy changes or staffing improvements address challenges, faced by those awaiting green cards, visas, or even citizenship approvals this year.
So, I mean, generally speaking, as they're one to do, USCIS has asserted that they've increased processing times and that there's been significant improvement. Now, the idea that there's been significant improvement and then the actual day to day, people with boots on the ground implementation of it may be two different things. Kind of going back on what I'd said before, I mean, advanced parole is better. That has sped up significantly. I know that fiance visa petition timelines have gone up, and then also citizenship, the N400s, those have been processed faster. The other thing has been that expansion of premium processing into categories that previously didn't have premium. That is, in theory, supposed to speed up processing times. What it looks like in reality, though, is that though they're basically taking those fees and turning around and issuing a request for evidence. That's not to say that it's an absolute certainty, 100 out of 100 you're getting RFE'd. But I personally, like I said on a previous question, have definitely seen an uptick in the issuance of RFEs for premium processing cases. And honestly, some of the RFEs are lazy. I say that meaning, specifically, I have a case presently that has a request for evidence pending on it that is asking for someone to show that they have continued to maintain H-1B status at the time they applied for the benefit. Well, this isn't an extension. It's a change of status. The person's in a different status and is changing status to H-1B. So if you were going to ask about maintenance of status, those questions should have been about the person's current non-immigrant status, which is not H-1B. So there's basically an RFE that was issued for a nonsensical reason that has to be addressed, because if you don't respond, then you open yourself up to a denial. But as a result, when the RFE is responded to, it goes back in the queue for processing, but it buys the officer time. So even though they've issued something that has no real rational basis, at the end of the day, it takes time. Takes time to get to us in the first place. Takes time to draft a response. Takes time to send back to USCIS. And all of that gives the officer more time to handle the adjudication and still operate within the auspice that they are fulfilling their premium processing obligations. So that would be my thing. Is I feel like with premium, some people say you're buying yourself an RFE. I don't 100% agree that you're buying an RFE, but I do feel like the RFEs are being used as a method to delay adjudication, whereas their proper usage would be to ensure proper adjudication and provide additional information as needed.
All right. Thank you so much, Justin, for addressing that. And, I also have a couple more questions from our YouTube channel, if you don't mind. We'll quickly
Yeah, I got
go
a
through
couple quick
them.
minutes.
Cool. So let's go with this first one. Control, if you can zoom in a little bit. Hi, my interview was on 16th September 2024. What does this mean? This is the
I mean,
image that.
it means your application's pending. Like, I'm sorry, I can't really give you
All
a
right.
lot more than that. Your application pending. Now, that being said, what can you do about your application pending? You can look at your processing times and see if your application has fallen outside of the parameters of processing times. If they have, then you're eligible for a service request. So I would look into that as a possible avenue to remedy it. Another thing that you can do that I've talked to individuals about is actually call USCIS and ask them for a specific case update. Some officers are more willing to go into a further level of detail. It just kind of depends on who you get on the phone. But I would look at maybe expediting request if possible, based on service processing times, and then also calling.
All right. Well, thank you so much, Justin, for taking that up. And now moving on, let's go with our next control, if you can just show us. Would you write an amicus curiae, I don't know if I'm pronouncing it right, brief on
Yeah,
2313?
it's an amicus brief. I don't know if I would write an amicus on a case that I'm not familiar with. I would have to look at the facts to actually make that type of determination. Amicus briefs, I mean, that's a process. That's basically you saying that even though I'm not a party to the case, I have an interest in the outcome based on, Ayla's done some of these actually recently on different decisions. There was a huge case a couple months ago for people, and I don't expect you guys to pay attention to this, but for people on this notion of consular non-reviewability. So consular non-reviewability is the idea that a consulate can make a determination, an officer can make a determination on visa eligibility that is above review by the U.S. court system. It basically says if your visa is denied for X, Y, Z, whatever, that is the officer's determination, and a court will not look at that in the U.S. So there was a very interesting case because consular non-reviewability is a powerful tool. It's basically something that, the officers make a decision. You can't really get to the officer to get them to explain their decision, and you can't attack it to try to overcome it. It's very, very narrow routes. Some legal net is one of these, but it's very narrow. It has to be specifically a legal question, not a factual question. So all of that leads to there is a lawsuit for someone who's a U.S. citizen whose spouse is denied entry, right? So they sued under the guise that consular non-reviewability is not as wide in its interpretation as it should be, meaning there should be specific instances where the consulate's action should be reviewable. For example, if it directly harms a U.S. citizen, right, by saying that the spouse can't enter the United States, direct harm to the citizen is harmed, what is their redress? They can go before the courts. They have standing. So while that case was pending, AILA provided an amicus brief, and their amicus brief was really attacking the idea of consular non-reviewability. Basically saying that these officers have far too much power. Their determinations not being challenged lead to people making incorrect conclusions. And those incorrect conclusions then become patterned because if they've made that decision before, they'll make that decision again. So all of that leads to this notion of there should be some circumstances, for example, when a U.S. citizen is directly harmed by a decision that remove the bounds of consular non-reviewability. So that was something that they amicused in on to see if they were able to help sway the court's opinion. FYI, they did not. So consular non-reviewability still reigns supreme and exists as an absolute bane in the existence of any immigration attorney.
Well, thank you so much, Justin, for the detailed explanation. Let's move on, Control, to our next one. This is hi, has anyone had an issue not receiving an H4 EAD renewal rejection notice? Can we have the full one, please? This is the half. I filed my H4 EAD renewal before.
Oh, goodness. I think generally I probably know what they're talking about. If you hit read more, it's probably going to say that they filed their H4 EAD renewal, never heard anything back, and never got a copy of the rejection notice, right? So that is not, unfortunately, that is not entirely uncommon. It's literally something I've had to deal with before too. So yeah, it's not a great situation. Because what it does is if you don't apply before the EAD card, you may not be able to get the automatic extension. So that can happen. And there we go.
Yes.
Yeah.
So I filed my H4 EAD renewal before my EAD expired, but never received the rejection notice. I only found out about the rejection when I contacted the USCIS lockbox multiple times, but they responded me in August, and by then it was too late to reapply for my EAD expired. I reapplied in September, but now the receipt notice that is automatic extension isn't valid anymore because EAD has expired. Has anyone else faced this? Yeah. What should we do?
Yeah, so it's definitely not the first time I've seen this situation. And it's unfortunately it's a tough bet, because the prerequisite of the eligibility is that you're filing that before the expiration. So the only thing I can give as advice, generally speaking, to people who are worried about rejections is your timeline for getting that receipt notice should be at most 2 weeks. So if you're getting to a point where you're past 2 weeks, you need to start checking to see, whether or not the case got rejected. A trick that we use in my field, and I will pass on to you all so that you can use it, is file with a check and contact your bank to see if the check cashed. If the check's cashed, that means USCIS should have receipted your case. If the check has not been cashed and it's been 4 or 5 days since USCIS received your application, that lends itself to the notion that your case has been rejected. So
Okay.
in that circumstance, you may want to jump the gun, especially if your EAD is expiring soon. Jump the gun, submit another application, and just do it as quickly as possible. That way you're able to send another one in. Hopefully the issue is corrected. Double check, triple check, maybe even talk to an immigration attorney beforehand so they can look at it to see if you're missing anything. And then just send another one. Worst case scenario, you get 2 receipt notices. Costs you a little bit of money, but gives you peace of mind, and then you open yourself up to being eligible for that extension. So that would be it. The EAD, there's not a whole lot of reasons why the EAD gets rejected, to be honest. The I-765 application is pretty straightforward. Pictures is going to be the big one because you need the 2 passport photos. I've seen rejection for that before. The other ones is signature. Did you not sign or date somewhere where you were supposed to? And so those would be the big 2 things that I would look at to see whether you missed something in your analysis.
Wow, I love how you answered that. I mean, it's a great trick to also know. Thank you so much, Justin, for taking this up.
Mm-hmm.
Let's go on to our next one quickly, please. If you still have got some time, Justin.
Yes, dwindling, but a little bit, yes.
All right. So should we wrap it up then? Let's look back at 2024 for you, Justin. Maybe you would like to tell us about a case or something significant that you would like to share with us today.
Yeah, absolutely. That would be great. Thank you. I would
Yeah.
say for 2024 has not been. It's been decent. It's been a decent year for immigration. The big things that I've really seen are really this honing in on this fraud findings and this idea that for example, you have these kids that maybe went to school on F1. They needed to join employers for OPT or STEM OPT, and they were approached by an employer who said, "Hey, come work for our company. We'll help you out. You pay us a fee for training, and then after the training's done, we'll put you at a client site. It'll be great. You'll work at amazing clients, Amazon, Google, Volvo, whatever,
Yeah.
And these kids say, okay, and they do this, and they go work at these companies, and they do these trainings. They're maybe 2, 3, 4 weeks of training. They come out of the other side of the training, and they say, well, where's my work? And the company's either telling them, we can't find anything, just hold tight, or just not even talking to them. So that happened to an unfortunate amount of people. This has led to USCIS kind of overall, like not even just USCIS, all of the agencies, all of it, DHS, CBP, everyone. There seems to have been this conclusion that if you did that you engaged in fraud or misrepresentation because you worked with those companies to secure an immigrant benefit, be that your OPT or your STEM OPT application. As a result, you've had an admissibility increases for fraud or misrepresentation. There have been people who've come into the United States and been put in expedited removal. There's been people who've been denied at the consulate. There's been people who've even tried to apply within the U.S. for extensions and are dealing with this fraud or misrepresentation. This has been a wide-reaching thing. It's been something that we've been really working on. We recently had success on a couple cases. There had been previous success as well, but there was 2 very big recent successful ventures for 2 big groups of plaintiffs where they're now moving forward. Those inadmissibility findings are going to have been removed from their records, and they are going to be able to re-enter the United States subject to new non-immigrant visas. And that's great. It's huge. You have people who were in situations where they thought they would never be able to come into the U.S. again, or they would never be able to adjust status, to become a permanent resident. And so that is what I would kind of close on my highlight for 2024 is coming away with those wins at the federal level, at the court level, knowing that the courts are very likely going. Thank you.
Amazing.
And props go to John Wasden, deserves the shine there. My tacit involvement, I it's nice, but yeah, that I think going into next year is great because it shows us that where possible, the courts can be a positive avenue. So when we start to look into next year and you're dealing with things like an improper denial, a denial that just seems ridiculous, or something like that, an incredibly long delay that could require a mandamus action. We all have to realize and be comfortable with the notion that the federal courts are going to be an avenue that must be explored because it would not shock me if USCIS is not playing fair. And so that I would leave it at that. There is definitely hope going into next year that whatever is thrown at us, we're going to be able to fight it back. If we can't fight
Yeah.
back with USCIS specifically, we'll take it to the court where we need to.
Wow. But that being said, amazing. I mean, kudos to Wasden immigration litigation for being amazing. And I think, yes, we have great things to look forward to 2025. So thank you so much, Justin. This was great, lovely. And congratulations to you, Wasden immigration litigation, I would say.
Thank you very much. Thank you very much for having me. I always appreciate it. And I'm sure I'll talk to you soon.
Yes, I hope to see you soon. Have a great day ahead, Justin. Thank you so much for joining us.
You too. Bye.
Yes, folks, if you want to have a one-on-one consultation with attorney Justin Rivera, Wasden Immigration Litigation, why not contact him? His number is 844-592-7336, and you can email Justin at support@wasden.law or go visit www.wasden.law to get to know more about Wasden Immigration Litigation. And also, please do not forget to check them out on LinkedIn. Thank you so much for joining us, each one of you, and stay tuned on Immigration and Jobs Talk Show because we got more webinars lined up and discussions lined up, and of course, great news and amazing updates. So check out our space, and yes, don't forget to subscribe to us, like, share, and yes, thank you so much for joining us today. Bye bye for now.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into today's topic and announcing the name of our very special guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. So, folks, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very critical and timely discussion. That is, how will the Trump's administration impact EB2 and IW, EB1A, and asylum applications? So, as we all know, folks, that immigration policies have been a very significant, we have seen a very significant changes in recent years, and also understanding how these changes affect highly skilled workers, individuals of extraordinary ability, and those seeking asylum is more important than ever. So, to explain and clear all your doubts and to guide you on the right path, we have an expert with us today. Please join me in welcoming attorney Amin yacoub, an expert in immigration law with an impressive track record, with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yacoub ran his own solo practice, helping clients navigate complex immigration and litigation challenges. As an EB2 exceptional ability and NIW immigrant himself, Amin understands firsthand the complexities of the immigration process. His personal experience drives his passion for delivering top notch legal representation to his clients, ensuring not only quality but also efficiency. With a nearly 99% approval rate in securing EB2 and IW and EB1 visas for his clients, Mr. Yacoub is a true leader in the field. So, Amin, first of all, welcome to Immigration and Jobs Talk Show, and it's an honor to have a show with you. How are you doing?
Good, and thank you for the kind introduction. It's a pleasure to be here.
Absolutely, and it's an honor, to have a show with you, and we are really grateful. that you are here with us. So thank you so much for joining us. And also, I mean, I would like to ask that, before diving into today's topic and going to talk about today's episode, I would like to know that were you expecting Trump to be back in White House?
Yes, I did actually. I would say I did expect him to be back when Musk, especially, joined forces with Trump, because Musk hasn't failed yet in any of his endeavors. So it meant a lot when he joined forces, and he was like giving $1 million a day to people and stuff like that. So it's just I felt like he's going to come back to office to correct the economy as well. So people are feeling it here in the U.S. and feel like they need to have a better economy, and that is usually the number one drive for the presidential election in the U.S.
All right. So, I mean, I would also like to ask that how do you think that under Trump's era, how do you see the future of US? Do you think it will be a new era or a nightmare for US?
Yeah, I think we've seen Trump before, so it's not like we're just exploring a new candidate here. So we've seen him from 2017 up to 2021, and it was, I mean, 2016 up to 2020, and it was not a bad year at all. Was the economy went up and everything was, in terms of immigration, nothing actually changed during his era. I would say Americans were, at least according to polls, were feeling satisfied with the economy. Were feeling satisfied with the low mortgage rates, interest rates, and everyone had kind of a chance in applying for jobs and having employment in Trump's era. But of course, people blame the COVID-19 2020 on what happened during Biden's administration. But my point is just the last period that we actually witnessed Trump doing work as a president of the U.S. He was not as bad as the media might actually show, and it's all like a political fight in the U.S. Media is trying to show a picture of Trump. He's like anti-immigration and anti people who are willing to actually help the U.S. be a better country. And that's not true. And that's why I'm interested in talking about immigration under Trump, because it's a completely unpopular opinion if compared to whatever is going on the media or whatever is going on the newspapers. So that's how you. So the other party here is the Democratic Party. Everyone tries to influence the public somehow so that they vote for them, so that they actually get them to the seats of power. So we just have to be neutral and watch closely and wisely in order to see what is true and what's not true.
Absolutely. And also, I mean, as you mentioned, that media has portrayed Trump in a little different way. And we can see that, even when Trump was serving food to in McD, then also that, that social media post just spread like fire. And it was also giving a different opinion that he's serving because he wants vote, or there was some kind of other opinion, that people were portraying in a different, actually in a little negative way. And
Yeah,
on the other side, if we look upon the Democrats, then I would say that for Democrats, the media was a bit lenient. They were more supportive, right?
yeah,
So
yeah.
I think that's why. But also, I would like to know from your side that can you be a little specific about that why Trump won in this election? Instead of, as media plays a huge role, and what media was portraying that what people believe, but out of that also, people supported Trump and made him choose him the leader. So can you please go ahead and share the reasons behind it?
Yeah, so you're asking about my personal reasons why Trump is coming back, not the objective reasons here, or
That's
not.
okay, you can give your reason.
Yeah. So again, Trump is a businessman. He has more knowledge about the economy and how it works, and we have seen. So that's kind of objective and subjective at the same time. We've seen Trump before doing his job as a president from 2017 up to 2021. And we have seen the vice president, Kamala Harris, doing her job as a vice president from 2021 up until now. So when we compare both candidates, we basically see two people who are not new people to us. They have been in power, they have been doing things, so we can just observe and see, was the economy better under the first or the second one? Was every aspect. So what was immigration better and faster for under the first presidential candidate, or under the second vice president who's currently still in office? And by doing that, just a simple analysis to me, it seems kind of obvious that we can see that actually Trump, even asylum, nobody would actually wonder that. It's like asylum was much faster under Trump, and I'm talking about affirmative asylum. So that's an immigration issue, and of course, this is one of the biggest uh, portions of the policy of Trump. So he's not anti-immigration; he's anti-illegal immigration. So he's what he wants to do is to vet people coming in, so that he focuses all the efforts, all the efficiency of USCIS on legal immigrants, and basically move things faster. In 2017 up to 2021, what we usually had happened was they actually accepted people in asylum in 5 6 months. They scheduled an interview in 5 6 months. Now an interview would be scheduled in 6 years. So we are seeing a completely different era in immigration under Biden's administration, and everyone is so panicking about Trump. Everyone is so panicking about Trump and immigration, again because of the media here. So that's why I feel like it's important to actually show what is true and what's not. And my opinion, may convince you or not, but I'm relying on data here, and I'm relying on statistics as well. Approval rates of EB2 and AW and EB1A under Trump's administration and under Biden's administration. So hopefully that will be useful, and hopefully that will actually make immigrants relax a little bit when they think about applying for EB2 and AW or EB1A under Trump, not under Biden, because everyone is so panicking right now. And I want to say, do not panic. This is not going to be worse. I think it's going to be much better actually for you.
Wow, that's great. I think this is really insightful, and this conversation, I'm loving it from my side. And also, I mean, before delving into the questions that we have prepared for today's topic, there's one more question that's intriguing in my mind. That do you think, as Trump says, that there will be a mass deportation from the very first day that he'll be joining the office in 2025? So, do you think that that will happen, because there are millions of people and practically that's not possible? So,
Yeah.
what's your call on that?
So is it possible? Yes, it is possible. Is it practically possible? Possible? I don't think so. He tried to do the same thing in the first year he actually took office in 2017, and he couldn't. And when he's saying mass deportation, again, we have to be very specific about what kind of population he's actually trying to deport. So anyone who has legal papers is not subject to this mass deportation. But anyone who has entered the country without any legal papers, without a visa, and they entered through the borders and they came to the US unvetted, probably he will do his best to deport these people. Now there is a status in between, which is people would actually come through the borders and try to obtain a legal status. So the question becomes, what happens to those in between people? So they would be in a safer condition than those who actually came to the US and remained without papers. And you would be surprised. We actually have many unvetted people coming through the borders. And I don't think that's wrong to actually, make a legal move regarding undocumented uh, immigrants or people who have never respected a rule in the immigration law. I think that happens normally in all countries around the world. So no country actually allows anyone to come in. You have to have a visa. So it's not like something out of the ordinary here. But if you do have papers, no one is going to be able to touch you because you have to be before a court, which we call procedural due process, before an administration, whether Trump or anyone else, actually has any decision over you or deporting you. So if he decided to deport someone with legal papers, let's say a CO8 pending asylum status, then he would actually advise USCIS to refer them or defer them to court. And once they're referred to the immigration court, then they would have what we call a day at the court. So they can represent themselves, they can have an attorney. And if they won the case, they're going to be remaining here in the US legally. If they lost the case, then they will be deported back to their home countries. So that's important to clear some, again, complexities regarding the mass deportation and the media, hyperbole statements that's like, just people are leaving, people are going to be, Trump is going to basically take people, arrest them, and remove them from the U.S., all immigrants. So generalization is not accurate here. And it's important to distinguish between all these strata of people and immigrants in the U.S.
All right, that's great. So thank you so much, Amin, for explaining that and taking that question up. Now I would like to shift our topic, shift our eyes on this topic, that how will the Trump administration impact EB2 NIW, EB1A, and asylum applications? So, I mean, my first question to you is that how might the Trump administration focus on merit-based immigration affect the adjudication process for EB2 NIW and EB1A applications?
Yeah, so that's one of the most important questions that we actually get on a daily basis right now. So, how would he impact those kind of policies? So, first we have to distinguish between what he can do and what he cannot do. So, as a president, he is having very specific authorities that he actually allowed to do. So, for example, we have the matter of Bansal right now, which is the landmark decision behind the EB2 national interest waiver. Is he allowed or is he authorized under law to basically reverse a court decision? That's a no here. So the answer is no. Is he allowed to change immigration law, the INA Act of 1990, which actually put forward the national interest waiver, the EB2, and most employment-based immigration visas? The answer is no, because Congress has the authority to actually put it, reverse it or change it, amend it with a majority of votes, which is very, very difficult to do because we have, again, even if we have right now a Republican Congress, we still have people who are believing in the immigration under Republicans and under Democrats. So people would be rejecting any kind of change or radical change, I would say, to the INA Act itself, which has been existing since 1990. So, what kind of impact would Trump be able to do to immigration? Would be direct impact. So, even though he has control over the borders, he can actually advise Homeland Security to not allow people in. He doesn't have much control over USAS except as directive opinion. So he would be giving a directive statement to USAS saying, well, please try your best to do better when it comes to evaluating the national interest waiver or whatever. And my idea, again, would be that he would actually broaden the scope, not as people think, that he would actually make it exclusive to scholars or scientists. And I believe so because he even suggested to give a green card to everyone who's graduating college from the US. So what we're seeing right now is Trump is probably pro legal immigration for the talented, for the people who are actually making a difference to the U.S. And people who are making a difference would be called, the EB2 NIW applicants and EB1E extraordinary ability applicants. So probably I would actually expect some uh, broadness, and that is going to be broadening this kind of categories. And I'm not the only one who thinks so. I'm not the only immigration attorney who thinks so. So people who are versed in the field actually agree with me. So it's just, I believe he is going to be giving directives to USCIS to accept more applications under EB2 NIW and EB1E if really the person is going to be making a difference. And that question remains a question to be answered in the case itself, in the petition and the exhibits. So whether a person is going to be making a difference or not is basically proved in a case, which is usually like 200 up to 400, 600 pages of documentation. So it's a completely objective um, way of evaluating what Trump is about to do here regarding the EB2 NIW and EB1E applications. And I think they're going to be much better than right now, even though we do have a direction from Biden's administration when he took office to try to grant as many EB2 NIWs to people who are working on AI, for example. But from the statistics posted by USCIS, what we're seeing is a drop in the acceptance rate down to 65%. So that direction didn't help much, which shows the nature of the direction. It's not binding, it's just suggestive to the president.
Much, Amin, for your answer. And also, I would like to ask and being a little specific about what specific changes to evidentiary requirements for EB2 and IW petitions can we expect under a Trump's administration based on past policies?
Yeah, so that takes us back to the matter of Dinosaur. So the matter of Dinosaur, as a landmark case, actually places all the evidentiary requirements that are required for EB20W, uh, and basically, if we complied with the case law, which is the matter of Dinosaur, and the INA Act, we complete the case correctly. So there is no say of a president here. It's all legal work. It's all decided by a court. We cannot bypass a court. President cannot bypass a court. The court itself may revisit the decision if it wants, but at the moment, it has been existing since 2016. The matter of Dinosaur. Before then, we had a case called New York State Department of Transportation. So we have multiple case law that basically a body of case law precedents that actually put forward the evidentiary requirements for EB2 and IW petitions. We never rely on what the president says or what the president did not say. We rely on case law, we rely on the law itself, for regulations, and we have to comply, us and USCIS officers. If a USCIS officer might be subjective somehow, he or she might actually make a decision that is not relying on the regulations. And in that situation, the correct action is usually an appeal. Or a motion to reopen, of course. So it's just a matter of complying with regulations. I do not believe.
Um, Amin, can you hear us? I think due to some reason he might got disconnected. But there's no problem, friends. Still you can continue posting your questions, and we are definitely going to take them for an hour as Amin Yacoub is with us for an hour. So till the time Amin will come back, we will try to have him back again with this episode. But you don't go anywhere. We'll be coming back with another short break. So don't forget to join us here. We'll be right back.
Yeah, I don't know what happened, but I'm back
Uh,
now.
no, no worries, no worries. I mean, not to worry anything about it. So, yeah, I was saying, everyone that Amin will be back again with a very insightful discussion as we were going on. So, Amin, please go ahead and continue with your insightful information. We would love to
Yeah.
know.
So where did it go off so that I can continue from where I stopped?
That's okay. You can give a brief about it.
Okay.
Yeah,
So I think the last question was, would Trump be able to actually influence the okay, now I see.
yeah,
So what specific changes to evidentiary requirements for EB2 and AW petitions? Uh, Again, I said briefly, based on past policies, he only can give directions, but for specifically EB2 and AW applications and EB1E. For EB2 and AW applications, we have to rely on the matter of domicile, which is produced by a court. So only a court can revisit that landmark case. No one else can actually change it. A president cannot interfere with the court decision and produce another decision. So that's regarding the evidentiary requirements for EB2 and IW, and also the regulations in place. They're actually an extract from the INA Act, which was passed in 1990. Again, it's not expected from the president under the Constitution to have the authority, which he doesn't have, obviously, to actually change something in the INA Act itself by direct will. So if that needs to change, the Congress has to change it. Now, what remains is the EB1A, which is not a part of the question, but I can cover it. EB1A is also placed by the INA Act. So again, Congress will have to change the law for us to actually change the evidentiary requirements. Now, what the USAS officers might actually have from Trump's side is, please broaden your interpretation of the law a little bit, or narrow it. And I believe what we're going to be seeing, according to what he said multiple times regarding legal immigration, and that he is pro legal immigration, and also because now we would have Elon Musk, who's an immigrant himself in his administration, we will be seeing broadening of that interpretation of those evidentiary requirements that are put forward by the law itself, the INA Act, and the matter of Dinosaur Court decision.
I mean, I would like to ask from you that you are saying that we are going to see a broader aspect. We will be seeing more opportunities, for EB1 or for everyone. So I would like to know it from you that how can you explain it in a bit that how we can see a broader opportunities, because most of the time we are seeing that Trump is trying to implement this and trying to reduce or making the immigration process a little lengthy. Yeah.
Yeah. So now I will use some data, but I don't think I can share the screen here, but it's accessible. You can just type in Google USCIS statistics based on EB2 and AW. So you're going to find the graph going up in 2017, 2018, 2019 of the number of petitions, EB2 and AW petitions, and EB2 and AW approvals under
Amin,
Trump.
I'm so sorry to interrupt, but if you want to share your screen, you can also do that. Or you want us to share, then you can share the link in this private chat and we can share it from our side.
Yeah, okay, sure. Just give me
Yeah,
1 second.
yeah, sure.
So
See, will be
here's
clear.
the link.
Yeah, you
This
can.
is just one statistics, but we have multiple statistics as well.
Mhm.
We can go through this one, and
Yeah, I think control. If you could please show this data. Yeah, I think we
yeah,
can.
can I control it? Can you scroll down a little bit? So yes, zoom in. So we have here 2017 as well was up. If we looked at here, it's going to be 2017, 2018, 2019 under Trump. And then 2020 was the COVID. And then 2021, Biden's administration. and then 2023 we're still in Biden's administration. Now we're going to see that the blue line, which is the receipt, EB2 NIW, or EB2 category in general receipts, is still going up, but the green line, which reflects the approvals, is starting to go down under Biden's administration of 2023. In 2024, it went down even below. So what we're seeing here, except of course in 2020, which is an exception, is a rise in the petitions and a rise in approvals under Trump in 2018 and 2019, and in 2017 as well, based on another statistics. And if we can you go down a little bit? I want to show you something else. Yeah, next page, please. The one below this. The one below this. Yes, here. So here we're looking at the O1 petitions, for example, STEM and non-STEM related. So they kept going forward and upwards since Trump, again, had a hiccup in 2021, went bad a little bit, and then it went up again. So O1 is not as influenced as EB2 NIW and EB1A because they're non-immigrant visas. So we're not going to be seeing the same difference on E2s, O1s, and L1s as we're going to be seeing a difference on EB2 NIW and EB1A because they allow people to get green cards, basically. Can you go to the next page, please? Next page. Yes, here. So here we actually see approval rates. If you could zoom in a little bit, it's towards the right end of the table. So 2018, that was under Trump, that was 97%. In 2019, that was 97%. That's for EB2 in general, but it's included. The NIW is included in there. You would actually see the petitions included in all of this. In 2020, we have a high percentage rate, but then it dropped down towards the end of the table to in 2023 down to 90%. Again, that's including the EB2 petitions that are sponsored by an employer, not only the national interest waiver. And that was published by USAS. It's not like something that I drafted for this live stream. So if we just took a look at the data, we're not going to be finding a source that would actually collaborate the statement that Trump's era was bad for EB2 NIW and EB1A, especially. Maybe it was a little bit stricter when it comes to the H1Bs, which I agree with, but it's not the same for EB2 NIW and EB1A. And I do not believe there is any reason to actually think that Trump's coming back would actually make things worse, because they haven't. So why would I be convinced that Trump would actually come and say, well, let's change it to 40%. So why didn't he do the same thing in the past administration if he wanted to do it? So it's kind of unconvincing to me. And based on what I said, again, the court has to change its decision. And I don't believe that's going to be happening anytime soon. Congress has to change the law. And I don't think that will be happening anytime soon either.
All right. I think that's great and that's very well explained. And thank you so much, Amin, for the data also, because that's pretty much very clear from our side also. And we can see the stats. So with this, we can have a clear picture about it. So again, thank you so much, Amin, for that. And meanwhile, I would also like to, greet our viewers, Ram, Jitendra, and Maisha. I mean, these are lovely viewers who has joined us for today's episode. So I think welcome to everyone. And here we have a question from our viewer from LinkedIn. That is, at the moment, how long average time to process EB1A and EB2 NIW?
Yeah, so regular processing usually takes 8 months up to 12 months for both EB1A and EB2 NIW. If someone would like to have a premium process, they have to pay an additional $2,805 to USCIS, and that would actually allow them to receive a decision in 15 days for EB1A and in 45 business days for EB2 national interest waiver. So a decision means an RFE, an approval, or a denial. So it does not mean that they're going to get an approval faster or like they're going to get so a decision can be very general. What usually happens is a premium process, especially for EB2 and IW, would actually, and EB1E as well, would actually influence USCIS officers to produce RFEs. And it has been the case since, I would say, last year, middle of last year. And that's because the applications went up. Again, we have to consider that everyone who came through the borders, illegal immigrants, they stood in the same line before USCIS, but from the asylum side, because we have two types of asylum: the affirmative asylum for people coming through the borders in a port of entry, like an airport, using their passports and a U.S. visa, and people coming through the borders without passing through any CBP officers, without having a visa, and basically, getting their way into the U.S. borders through Mexico or anywhere else. So all these people combined, which is unfair for affirmative asylum applicants, of course, they're all in the same line before USCIS. So people are asking me and asking multiple attorneys, what's happening? Why are applications being late? And what's happening in all of this? What's really happening is whoever came into the U.S. through the borders, they're standing in the same line as everyone else. So now I-140 applicants, they're paying a fee called an asylum program fee, which is an additional $300. So the USCIS started charging the additional $300 fee so that they actually try to do whatever it takes to hire more officers to get the process going, because we have more than 4 million people who came into the U.S. through the borders undocumented. So what I'm saying here, or what I'm trying to get at, is if Trump really stopped whoever coming through the borders undocumented and only allowed legal immigration, things are expected to go faster in 2 years or 3 years, because we already have millions of people before USCIS. So it takes some time to actually finish the cases that the extra cases that they have, the frivolous asylum cases, and so on. So right now, as I said, just to summarize briefly, it's just 8 months up to 12 months regular process, and 45 days premium process for EB2 nationality waiver, 15 days premium process for EB1E.
All right. So thank you so much, Amin, for answering this question, and thank you so much, Mai Cho, also for participating in today's session. In case if you still have any follow-up question or would like to know about any other topic related to immigration, then please go ahead and dial on this number, and you can also give a call on this number and can also participate in today's session. And you can also comment us with any other different topic or any other follow up question that you would like to ask from today's attorney. All right, so now I would like to take Jitendra's question, and he's saying that I'm a physician applying for an EB2 NIW based on serving underserved communities. Could changes to the program's national interest definition under Trump affect how these cases are judged?
U.S. will always welcome physicians, especially if you're focused on underrepresented people or underdeserved communities. And there is always, of course, I have to note here, a shortage is not a reason for the EB2 and IW eligibility, because it's covered under the perm process regulations. So if you are sponsored and you have a full-time job offer and you're basically before the Department of Labor doing the labor certification, what we call the perm process, there is an exception for having a shortage in your field. So the argument, the same argument does not apply for a waiver. But what I'm saying is a waiver is actually not relying on the shortage, but it's relying on you serving those kind of communities. So that's different. But what I'm here, if you want to apply as a physician, your chances of approval would be really high because USCIS really appreciates doctors and physicians, especially if you're really about to serve or you have a proposal to serve the underdeserved communities or people who are being basically without doctors. But again, even though it sounds the same, we're not going to be arguing the shortage. We're going to be arguing that you're going to be serving those kind of communities, which is kind of different.
Absolutely. I think healthcare is the most important sector in any nation, and that's like a backbone of any country.
Yeah.
So I think that's very well explained. I mean, from your end, and to Jitendra also, if you want to know any other topic or if you have a follow-up question, then please go ahead and feel free to comment us on this session. All right. So, I mean, I would also like to ask about, are there any specific fields or professions that may be favored or disadvantaged under a Trump administration concerning EB2 NIW and EB1A applications?
I wouldn't say fields or professions. I would actually say how the case is prepared. So if someone is trying to argue that basically they're going to be a management consultant, but they're not going to be contributing to any specific field. There's just going to be a management consultant. That's not good enough. The proposal has to be the proposed endeavor, of course, has to be very, very specific. It has to highlight how it would actually bring the difference in the U.S. To what sector or sectors, and technically, how would that happen? How would it cause that kind of difference and impact on that sector? So anything that is not specific enough would probably be denied. So it's not really about the field itself. It's about the specific proposed endeavor. And if you do have a specific proposed endeavor in even arts, that would be accepted as opposed to having a very general proposed endeavor in being a physician or in being an engineer. So it's not about STEM versus non-STEM. It's not about being an engineer or a doctor or an artist or a theater production company or whatever. It's about the specificity of the proposed endeavor and how can we convince a USCIS officer that you have already had some success in the past, which we should prove in the petition, of course, and all the documents, and that you're aligning your education and professional experience and past contributions to your proposed endeavor in the future, which will bring in that difference, which is going to make America a better country in the future, or even a sector in the U.S. a better sector in the future through business or scholarship.
Right. And we really hope that America becomes great again, as Trump says, and that's how America feels. So, all right. We also have another viewer, Knife here, and Knife is saying hi. Hi, Knife. And the question that Knife has is, do you think that Trump government can be doing all what he talking, and if not, what are the challenges?
I don't think Trump will be able to do so because we have laws here. The Constitution, you have to understand that the U.S. is a democracy, right? So its rule of law is dominant here. So Trump cannot be a one man who's doing everything. So we have the judiciary, and we have the Congress, and we have the president. So three branches of the government. They have checks and balances, of course. The Constitution says or documents basically the relationships between all of them. So Trump does not have any authority to actually reverse a law that was enacted in 1990, which is the INA Act that provides most of the immigration visas. Trump does not have the authority to reverse a court decision, which is a landmark case. It's a precedent. So a court can only revisit and reverse that decision. Trump cannot do so. He cannot basically interfere with the court judgment and say, well, I'm going to reverse it tomorrow because I feel like it. What Trump can do is give directions to USCIS and CBP officers. Now, all these directions binding. The answer is not really. They're suggestive, and they are not binding. So USAS, and based on what I showed on the statistics, has been doing favorably. Basically approving many petitions for EB2 NIW and EB1A under past Trump's administration. So there's no reason to believe that in the next Trump's administration he's going to be doing something different. What I think is he's going to be actually broadening the visas, EB2 NIW and EB1A, to some extent, so that they accept more talented people. Because now he's having Musk in his administration as well, who is, I believe, is an EB1A or EB2 nationalist waiver himself. I would say probably he is either EB1A or EB2 NIWs, although some people argue that he's EB5. But why would he choose EB5 if there is a higher category? So, we should ask him this probably.
All right. So I would like to say, Kinfi, thank you so much, and my apologies for mispronouncing your name. But Kinfi, if you still have any questions that you would like to ask from our attorney, then feel free to post them, and we are definitely going to take them up. All right. So I mean, you are explaining fantastically about all the questions that we are taking up. Here's another thing that I would like to know from you, as you also mentioned about the border and about the security. So we all know that Tom Homan being appointed as border czar under Trump's administration. So how do you think that his approach will affect the border security, asylum policies, and immigration in the future?
So the question here is about asylum as opposed to EB2 NIW, or
I think, okay, let's take about asylum, EB2, and IW, because we are taking that as a topic. So yeah, please go ahead and talk about it.
yeah. So again, the affirmative asylum wouldn't face many challenges in the future, in my opinion, because these people enter the U.S. legally using a visa, and they are documented. We basically, USAS can easily, in connection with the FBI, can figure out if someone is or has been a criminal or not in their home country. So they vet people, and vetting is important to get people in. Affirmative asylum, in my opinion, would actually go faster. People would have interviews scheduled faster than 6 years, in 2-3 years from now, because we have to, again, the USAS has to decide millions of cases so that it actually creates that faster process in the future after undocumented people came in through the borders. So that's number one regarding affirmative asylum. Affirmative asylum people who actually applied and got the CO8 legal status, which is a pending asylum interview, and they're waiting in the U.S. legally for the interview. They shouldn't be fearing anything, again, because they are documented. And the first sentence in the USAS receipt that they have received actually says you may remain in the U.S. lawfully until you are scheduled an interview. So right now, they shouldn't be fearing any changes in anything. Also, you have to understand that from a legal standpoint, laws cannot be applied retroactively. It's unconstitutional. So even if Trump, let's say, which is, I would say it's an 0.01% chance. Let's say he said, well, now I believe that I want to get rid of affirmative asylees who are living in the U.S. legally with a CO8 pending asylum interview. That cannot apply to you because you are already here. You're already having the CO8 legal status. You already have the documentation. So that probably will stop people in the future from getting the same card as you, the CO8 employment-based, not employment-based, it's called the EAD, Employment Authorization Card. And that will prevent that for the future, not apply to the past or the present. So that's important to note because status quo will remain the same it is right now.
All right. So,
Yeah, I think there is an interesting question here, if I may reply to it. It's by Caveat.
is saying that for EB2 NIW applicants, there's a speculation that USCIS could enforce higher education or professional thresholds. So, do you think that applicants with advanced degrees but limited publications could be at risk?
Yeah. So I wanted to reply to that question because there is a misconception that is going around that you have to have publications and citations to have an approved EB2 and AW petition. And that's not true. So we have three kinds of applicants. We have the scholar applicant for EB2 and AW. We have the entrepreneur applicant for EB2 and AW. And the entrepreneur is not expected to have any publications or citations. And we have the professional path, which is a third unexplored path somehow, which is basically someone working somewhere in the US saying, through my employment in that institution, let's say nonprofit, I will be doing some novel technique, and that novel technique will bring in the difference on the US nationally and on the field itself, and therefore will have substantial merit and national importance to the US. So for the second and third paths for immigration under EB2 and AW, you wouldn't expect to have publications and citations. Only as a scholar, we would expect you to have publications and citations. So it's not going to affect you in any way right now or even in the past, since I would say the matter of Donosar, which actually reversed the New York State Department of Transportation. And the matter of Donosar said you can have a proposed endeavor that is important for the business, for entrepreneurship, for arts. So it broadened the criteria for EB2 and AW to actually cover multiple non-STEM fields and STEM fields that are not scientific or scholarly based. So that's regarding this question. Regarding the advanced degree question too, the INA Act itself, which belongs to 1990, so it has been enacted for some time and never changed, is the one that actually states that you have to have a master's degree or a bachelor's plus 5 years of experience. No one can change the INA Act except the Congress itself. Now, if the Congress decided to change it, that Congress needs the majority of votes, which is very, very, very difficult to get when it comes to immigration. So my answer is there is not going to be a change to the advanced degrees requirements for EB2 and AW. And there's not going to be a change or a possible change for the criteria itself for non-STEM, STEM, professionals, entrepreneurs, and scholars. All paths would be the same probably for the next 4 years. It would be interesting to see if he would really broaden the EB2 and AW category or not, show his directions to USCIS officers. But otherwise, I don't believe that there's going to be much change in this practice.
Wow, that's so insightful. And okay, so thank you, Kavya, for your participation and for your question too. So here's another question, I mean, that I would like to ask: that how might the reinstatement of policies like remain in Mexico affect the asylum seekers' chances of success in their application?
Yeah, that's a very interesting question. So if that person is Mexican, for example, and he or she has a visa and they can come into the U.S. Through a legal way, then probably they wouldn't face much challenges. Now, if that person wants to come illegally into the U.S., probably that statement will apply to them. Now, if that person is not Mexican, and let's say he or she is from Argentina and they traveled to Mexico and they wanted to come through the borders, Mexican-U.S. borders, then USCIS will actually try to stop them by, again, building a wall or whatever, and that will be through the CBP officers at the borders. So if Trump changed the policy again and tried to spend a lot on building that wall, that would be number one. Number two would actually be, and he tried to do that before. Actually, he tried to sign an agreement with Mexico, which we call in immigration a third safe country agreement. If you are an Argentinian living in Mexico, uh, do asylum over there. Do not come to U.S. To do asylum, to seek asylum. And that's crazy because Mexico may not be safe for Argentinians or for even Mexicans. So he tried before to pass this kind of international agreement, and he failed. It's very difficult to do, and because Mexico is also in the NAFTA agreement, which changed to the USMCA agreement between Canada, US, and Mexico, it's very difficult to try to build a different agreement, especially for a safe third country, saying, well, anyone who is in Mexico on a Mexican land will have to apply for asylum in Mexico, and he or she would not be allowed entry into the U.S. So it's very unexpected. I hope that covers all types of people who might actually come from Mexico, whether Mexicans or non-Mexicans coming to the U.S. legally and versus, of course, illegally.
Absolutely, and I think that's very well explained. So, to our viewers, also, friends, if you are navigating, your immigration journey, or have any doubts, or need any type of guidance related to immigration, then please feel free to contact Attorney Amin at the number that is provided. That is 407-578-1334. So this is the contact number that you can call him and ask your doubt. And with this, you can also email him on yacoub at boganmonths.com. And you can also visit his website, that is www.boganmonths.com. So these were the contact details that I would like to share. And now moving ahead with my one more question, I mean, that I would like to know about family-based immigration, right? So
Yeah.
now I want to know that how do you anticipate Trump's approach to family-based immigration will impact the individuals who are applying for visas or seeking asylum?
Um, Applying for visas or seeking asylum.
Mm-hmm.
So if someone is marrying a U.S. spouse, they are allowed to adjust status based on their marriage if it's a bona fide marriage. So if it's a good faith marriage, of course, and we could prove that that you can actually skip all the asylum process, you can skip all the visa process, and completely go ahead and apply for the I-130 and the I-485, I-765, I-130 and one, and basically get all the cards you can get in the least period of time possible under USCIS. So family-based immigration is highly recommended if you do have an American spouse, or if for example you have a father or a mother who is a U.S. citizen. Now it differs from, again, it's just the categories are different. So you would have a first preference for the spouses, father and mother, and first preference is actually for the spouse. Second preference is for the mother and father. Third preference will go towards sons and daughters, and fourth would be the brothers and sisters. So the lower the preference, the more years you would have to wait. Otherwise, there is no interrelation between visas or seeking asylum and family-based immigration. We can see some cases where basically a person who is applying for asylum in the middle, having a CO8 card, for example, pending asylum, waiting for the interview, he may actually marry someone in the process. And just by marrying an American citizen, that will completely change matters into getting the green card through marriage, not through the asylum process. And later on, after they have the green card, they can basically send a letter to USCIS and ask USCIS to withdraw their asylum case and basically go ahead and do the green card through the marriage-based immigration, which is family-based. Otherwise, there is no foreseeable impact on these types of visas.
Absolutely. And I mean, I would like to know from your side that it's almost 1 hour that we have reached. But I have some more questions from my Facebook group. So if you have some time, is it okay for you to give 5 to 10 more minutes to our audience?
Yeah, sure. 10 minutes are okay.
All right, that's pleasure. Okay, so I mean, we can see here. I hope you can see my screen, right?
Yeah, I see it.
Yes.
So, would a
Yeah.
pending E2NIW affect you when getting H-1B visa? Waiting time can acquire H-1B while there is a pending EB-2 G1 holder. Thanks, Brian. Yeah. So that's an interesting question. So the H-1B especially is a different breed of visa. So we call it a double or a dual intent visa. It's an immigrant and non-immigrant at the same time. And that basically means there's no contradiction whatsoever between the H-1B and EB-2 and IW, because EB-2 is an immigrant visa. So applying for a double intent visa like the H-1B at the same time was applying for EB-2 national interest waiver, which is an immigrant visa, that does not show any contradiction in any intent. So you can go ahead and apply for the H-1B and also apply for the EB-2 NIW. But the trick here is to maintain your legal status through the H-1B, because otherwise you may actually fall out of legal status since the dates are not current yet for the EB2 and IW. Meaning that if you got an I-140 approved, you would have to wait some time before you can apply for a green card and a combo card. So that means between the approval and applying for a green card, you would need to maintain legal status through the H-1B. So it would be highly recommended to actually go ahead and secure an H-1B before you apply for the EB2 national interest waiver.
All right, that's wonderfully explained. And here's another question that is do we need to submit ETA 9089 and related for EB2 and IW self petition?
Yes, it's a part of the regulations. So even though it sounds and it reads like it shouldn't be submitted, because it's basically a labor certification application for the firm process, you must submit it. You have to complete specific sections in the 9089 form. Right now, they have produced a new one, so you would have to download the new version and use it. And once you comply with the regulations and fill it out and sign properly, you have to include it in the submission. Otherwise, you will probably get an RFE requesting you to do so.
All right. So, moving ahead, here's another question that before submitting or mailing the petition, do we need to create an online account on USCIS?
No, you don't need to create an online account on USAS. I would say it would be helpful to do so, but you don't have to. You're not required to establish an online account on USAS. Now, it's helpful because it allows you to track the case, to actually get notifications whenever something is going on. If they updated your case, for example, to decided or approved or issued an RFE, you will get notified if you do have a USAS account. Now, if you're doing this through an attorney, your attorney would actually have access to your case and would actually get the notification from USAS on your behalf. So you don't have to do it if you have an attorney. You have. I would recommend doing it if you're doing this on your own and would like to stay updated regarding any changes that may happen to your case.
Absolutely. I think taking expert advice is mandatory in immigration process. So, friends, if you still, need any guidance or need any help, then here's the contact details of our attorney that is mentioned, and you can see the contact details like phone number, email ID, and also the website that is being provided on the screen. So, please go ahead and share your, any information or any doubts that you have, and I'm sure that attorney Amin Yacoub is definitely going to take them up and he's going to solve them. All right. So, I would like to ask a few more questions, if you allow. That is,
Yeah, of course.
Yeah, that's great. And I don't know why. Yeah, that's great. My screen is visible now. So which part of the ETA 9089 need to be filled for EB2 and IW? I have already filled in the Appendix A and final determination forms.
Yeah, that's all what you need to actually provide for the new version. So it's just final determination and the appendix A. So basically, education, experience, certification, skills, which is appendix A, and then the two pages where you have to sign basically as the beneficiary, and that's all. And the preparer, of course. So you would have to sign. If you prepared your own 1989, you would have to sign twice on the two page towards the end.
All right. So I think that's all from my end because I have covered a few questions that I wanted to ask from you. And yeah, I think, I mean, it's almost time for our very insightful session. And it's just 1 hour we passed and we didn't even realize. So from my side, it was a very, amazing, a wonderful experience and obviously an honor to have a show with you. And you were outstanding. You were clear. You made up a very great points that that was very insightful and that was very eye opening too with the datas and with all the facts and stats that you brought up. That was great. So how was your experience in today's episode? How it was?
It was amazing. I really enjoyed my experience, and I actually really enjoyed the questions as well. They're very, very interesting questions
Right.
from your side and from the audience side as well. It was really a pleasure being here, and thank you for the invitation.
Absolutely. And I think the questions, those were, interesting, but even the answers, those two were very much interesting. So I like that too. And there's another comment from Freelance Mastery also.
Yeah,
So
let's do that as the last question and move
all
on.
right. That's
Yeah.
great. So it's that what if my case was submitted under Biden's administration and got adjudicated when Trump's administration? Which administration am I entitled to?
Yeah. So probably that question has to do with the importance of the proposed endeavor than which administration would actually adjudicate the case, because they're the same USCIS officers. People think that, again, Trump is going to remove all USCIS officers and replace them with other USCIS officers. So they're just the same officers deciding the same cases under the same legal framework, whether under Biden or Trump. But your question might have a hidden question, which is there is a difference in the importance of there's a difference in the importance of policies between Biden's administration and Trump's administration. For example, solar energy is very, very important for Democrats and for Biden's administration, but it may not be as important under Trump's administration. So, since you have filed your case under Biden's administration, your case should be aligned with Biden's administration's importance when it comes to policies regarding solar, etc. Again, these are not black and white, so you have to understand that Trump is not like he's not going to dismantle the solar energy when he arrives. Again, like the biggest producer of electric cars is by his side right now. So we actually that's why.
I think due to some reason, Eamon, can you hear us?
Yeah, yeah. I'm just saying, last thing I wanted to say is um, there is not going to be a huge difference in policies and the importance of those policies, because right now Trump is more convinced of not solar but basically clean energy and stuff like that. But he's not willing to sacrifice oil and gas either. So we're going to be seeing a new Trump administration basically focusing on all energies, probably nitrogen as well. He talked about nitrogen cars, but he said, well, they're risky. So now that Musk is on his side, probably we'll be seeing a different approach towards electric cars, towards solar energy, and towards policies that Trump was in the past kind of reluctant to accept as important. Otherwise, to answer your question directly, your application will be decided based on the policies that are considered important at the time your application was received. So when you have received your USAS receipt under Biden's administration, that's the time limit, that's the time estimate where actually the officer has to look around and say, you have complied, you're actually contributing to an important policy under Biden, not Trump.
Wonderful, wonderful. So, yeah, I think, Amin, we also took the last question of today's episode, and that too very well explained. So, again, to our viewers, also, guys, if you are navigating any immigration journey or having any doubts, then please go ahead and contact our attorney, and he's definitely going to help you out. And I mean, from my side, as I also said, that it was a wonderful experience to have a show with you. And you were also saying that you also enjoyed the questions that we prepared, the audience they were asking. So big thank you to attorney Amin Yacoub for making this session a brilliant one and bringing a very insightful and a very eye-opening stats and facts about today's topic. And I think, yeah, that's all, and to our lovely viewers also who participated in today's webinar, thank you so much to everyone. Keep on posting your question, friends, and we are definitely going to keep them on asking and try our level best to provide a best solution to you. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you.
Thank you so
Have a good
much.
day. Bye-bye.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm your host Rivera, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. Welcome back, everyone, to Immigration and Jobs Talk Show. Like I said, I'm your host, Rajni Bharara, and today we are here to discuss the latest trends and insights in immigration law and employment opportunities. Well, I'm thrilled to have you all join us with us today, and I want to again extend a heartfelt welcome to all of our viewers today. Thank you for joining us. Your interest in these important topics is what makes this show very, very special. So thank you again. And today we have a very special guest joining us. Erin Green, an esteemed immigration attorney and an H-1B visa expert. Erin brings over 20 years of corporate management experience, working with clients ranging from venture startups to large multinational corporations. He is the founder of EEG Immigration Law Group, where he provides exceptional legal services and strategic solutions for complex corporate immigration issues. Erin has a remarkable track record, having overseen thousands of immigration petitions for high tech, defense, and biotech companies. He has served as the exclusive U.S. immigration advisor to the American Israeli Chamber of Commerce and has extensive relationships with Department of State officials representing corporate clients at the U.S. Embassy in Tel Aviv. In addition to his legal practice, Erin is a passionate educator, frequently delivering presentations on immigration processes and compliance to large audience across the country. His commitment to transparent service and dedication to his clients truly sets him apart in this field. Today, we'll be diving into an important topic: H-1B visas, current trends, fraud crackdowns, and what to expect next with none other than Erin Green. We'll explore the latest developments in H-1B visa sponsorship, discuss the recent crackdowns on fraud within the system, and look ahead to what applicants can expect in the upcoming year 2025. So without any further ado, let's welcome Erin Green to the show, everyone. Erin, welcome to Immigration and Jobs Talk Show. How are you doing?
Hey, good to be here. Doing good. Thank you.
Thank you so much. It's a pleasure having you on the show, Erin. Thank you for agreeing to be a part of the show. And guys, we have Erin's details displayed on screen in case you want to write it down. So you can write down his phone number, his email, and his website in case you want to get in touch with him. So make sure you do that. Now, Erin, without any further ado, I know we are here to talk about H-1B, but before I do that, I actually want to talk to you about, the picks of Trump's administration. I mean, the picks that Trump has had in past few days of in the last 1 month for his administration. So, Erin, how do you anticipate these appointments are going to influence immigration policy, and particularly regarding H-1B visa?
I think the new administration will be very strong on the border, on preventing the mass illegal waves of immigrants coming in. That's the focus. That's what he ran on. That's the people he's putting in place. Mr. Holman and all these others are going to be focused on that. What we have right now is a free, open border on our Mexican side where anyone can just walk in. I'm completely against the asylum scam that is going on and the ways that the last or the current administration has ignored immigration law to levels that are just unexplainable. For those of you who don't know, asylum means you're in a country, but you have to get out. You have to flee. You're in fear of your life. The government's going to come and kill you or cause harm to you. And if you can get to the next closest country, you're supposed to file an asylum claim and be there until your case is heard. Unfortunately, while we do have a lot of poor people coming from these countries that just want to work, they do not qualify for asylum. And asylum was not created for someone who just happens to need a job or to be poor or maybe lower class. But what they've done the last 4 years, and even before that, they've allowed these folks to come in illegally using this asylum. It's a big scam, and the government's perpetrating it. So to get back to your point, I think most of the efforts will be on securing a border like every country needs, allowing people to come in legally, allowing real asylum claims to be heard, and hopefully not allowing millions and millions of these phony asylum claims to be perpetuated. With regard to the H-1B in the business community, I happen to think that Trump is a businessman. People working with him are looking to increase the economy. The economy has been down the last 4 years. We've had inflation. We've had a lot of problems. So on the business side, I expect things to get better, get smoother. Hopefully wait times will go down. And we'll see better processing and intakes of cases. And those are some of the things I'm looking forward to. There's a lot of fear mongering out there done by whether it's law firms or just particular political interests who always want to fear monger and hope for the worst. But we don't see any evidence of that. For what we see so far is a business-friendly administration like we saw last time.
Okay. But Erin, a lot of people are also saying that it's not only going to, Trump and his administration are not only going to go after the legal ones, the illegal ones, but also it's going to be bad for the legal ones and strict scrutiny. And, basically, it's not going to be good, not just for the illegal ones, but also for the legal ones too. So what do you have to say about this? Do you think it's going to be hard or bad for the legal immigrants too?
I don't think so. I don't think. We've seen 4 years of this administration my firm, we process hundreds, thousands of H-1Bs, certainly where they're stricter on, for example, third-party client-side cases, and then it goes back. We've seen trends where there's more RFEs and then less RFEs and then more RFEs and then RFEs targeted. We see them coming in trends. But the trends don't really correlate with the administration that's in power. It doesn't matter. It seems like they are more internal, and they just seem to adjudicate in different ways in trends. So if you're talking about H-1B adjudications, it's hard to predict what the next trend will be. I mean, for example, I can tell you 20 years ago when we used to do L1s, L1As, and L1Bs, L1As would never get an RFE. They were so straightforward. For example, if you flash forward 12 to 15 years, you have them starting to RFE L1s as a trend, and L1As particularly. And so there's nothing correlating with the law or changes in law or changes in administration. It just seems to be internal trends that seem to come up and down, with what we see in our data. But I don't predict any stiff change where they're going to say, oh, we're not accepting H-1Bs. They can't do that. I don't see how they would do that or why they would do that. That would just harm the business community.
Okay. But do you expect any changes in the H-1B lottery process with the new administration?
So to give you a little bit about background about the H-1B lottery, as you know, before they went to this electronic system the last couple of years, they had just the lotteries where you prepared the entire case and you sent it in with your filing fees, which were a lot. Then they would do the lottery, and then they'd send the ones back that didn't have the paper, that didn't get accepted in the lottery. Then they went to an electronic system, which they forego all that paper being produced and sent in and all that mail, which is smart. However, it kind of opened up the door a little bit for easier methods of fraud. But before, I don't know if you're going to ask me about fraud, but before we get to that, I don't see it. And are you asking about how the process has changed this year's particularly from the years prior?
No, yeah.
Well, okay, so let's talk about the fraud, for example. So when they announced that they were going to electronic, I said in my head, I said it right away. It just popped in my head. I said, this is going to be a catalyst, and we're going to see hundreds and hundreds of thousands of more applications. Not necessarily because the economy is better or they're needed, but because it's going to be easier to do fraud. Because think about it. When fraudsters come together and they put these ploys in just to get H-1B approvals or lottery applications, the law is that you can't. So if you have a related company, you can't submit multiple applications for the same H-1B applicant. But if the companies are not related, you can do that. When they went to an electronic, now, of course, there was fraud existing before. Companies could do that, and they were willing to submit these huge applications with all the fees. And I guess if they got more than one applicant accepted, they would lose a little bit on the fees, right? When you go to an electronic system and you don't have to send any fees in, you're just entering names and maybe their birth dates and passports, etc. Then you have less overhead. The fraud scams have less overhead in terms of having to put all those fees up front. So what happened is they got a little bit smart, and I predicted it. If to get around the law, if you think about it legally, if let's say 20 people came together and opened 20 different companies, okay? But none of those people were related or had any other ownership interest or relationship with any of the other 20 companies, right? So you have 20 different companies. However, now let's say they have 100 people and they want to get them H-1Bs, right? So let's say each one of those 20 companies enters those 100 people into the system, and they could do that because technically they're not related, although it is technically a fraud scheme because let's say they're colluding to do that. That's where it can become so much easier to perpetuate fraud with the new electronic system. But now we see a lot of crackdowns going on, so they're getting a lot smarter. I think this year what they've done differently is they're starting to, they're asking for the passport number of the individuals now. So this year what they've done is they're looking at the individual. So if they're accepted, supposedly they're not accepting them again. If that makes sense, if that same individual has, and they announced that in their bulletin in January, and they've done that supposedly. So that's one way that they're cutting back on the fraud schemes. And then the other way is they're doing a lot more investigations into the filers when they see that.
Right.
For example, I have a company now, and we were doing an H-1B, and then we got an RFE or a NOID, a notice of intent to deny, which is similar to an RFE. And it talked about the past filing from the CAP, which I've never seen one of those before. And it was talking about, so the person we were filing for our company, but they had been accepted in the CAP for another company. And they were looking into the companies and asking questions about the companies prior. So you can see that they're on to these companies now who are doing that, which is a good thing, which will make it more fair for everyone who needs H-1Bs.
Okay. So hopefully it's going to be all good for the H-1Bs at least, and also for the immigrants.
Yeah, I think so. The only changes for next year, I think, is they're going to probably implement instead of $10 to enter someone, I think it's going to be $200. And they wanted to do it this year, but at the last minute, they decided to keep the $10 fee in place. So it'll be a little bit more. I think it'll be $200 per person you want to register.
Okay.
Which is interesting. But other than that, I don't know if they're going to change much from this year's fiscal year cap to next year. We don't have the announcements yet, but they usually start announcing them around this time. And then in January, they start coming out with announcements and changes if they want to make any. But I can tell you 780,000 caps last year was not a result of the economy. It was, I mean, if you look at versus the previous years, it's several 100,000 more. It's, that was because it was easier, and I predicted it. It was easier because you don't have to file all the, and they've gotten smarter in how they're doing it and set up these fake phony H-1B. We used to call them job shops when I worked at Infosys, and they're out there. They crack down on them, but they're out there. I can explain what that is if you want, or we can move on.
Yeah, please go ahead. We would like to know more about it. Yeah.
So when you're looking at an H-1B, a job shop, so technical staffing companies like yourself can have legitimate jobs and legitimate clients. And the requirement is technically that you're supposed to have a bona fide offer of employment for the employee that you're submitting the H-1B for. What the job shops do, and your H-1B employees or applicants or people who want to get H-1Bs have to be very wary of them, is they come along and they try and they say they can get you H-1Bs. They don't really have jobs lined up that are ready to go, bona fide job offers. They just try, and some of the other things they do is they try to take money from the employees. So anybody out there who's looking to get an H-1B, be very wary of these job shops. What they're doing is they're making a profit by trying to get H-1B lottery numbers in high volume and then utilizing those by placing people in the U.S. after the fact. Whereas a legitimate staffing company or a legitimate IT consulting company will obviously have clients and have jobs ready and available and file based on those jobs. And even when they're entering the lottery, should have that those jobs in place. There's a little bit of a difference there you can see.
Okay. But hopefully now that Trump is going to be back with this strict administration, it's going to, if not completely go away, at least it's going to be slowed down, right?
I really don't know. In terms of enforcement and investigations and audits, I mean, even during the Trump administration, we saw times when there were more audits and less audits. For example, FDNS audits are random site visits, which they do on H-1Bs and L-1s, where they're supposed to come to the office or the place of work. A lot of the officers are lazy and they'll just email you. But so I can tell you the last 4 years, we hadn't seen a lot of them. I've seen very, very few. I just even got one recently. But so I can tell you just within the last 4 years, there was like virtually none. And then maybe now lately a little bit of ramping up. But it's very sporadic. So it's hard to say that just because this administration comes in, there's going to be more FDNS visits and we're going to do a lot of them or. But in any case, a legitimate H-1B should not be worried about an FDNS site visit. They're very straightforward. They want some documentation. We did tons of those when I worked at Infosys. And so it's not something that should alarm anyone. And even if you get an FDNS site visit, they're looking just to make sure that what's in the application matches what's on the ground. That's basically all they are.
Okay. Thank you for answering the question, Erin. Now, I would also like to know about, because in Trump's last administration, this Buy American, Hire American was his initiative, right? How do you foresee this policy actually being reinforced or maybe altered in this new term, especially, concerning H-1B visa holders?
Yeah. So the argument, the H-1B argument on are H-1Bs good for America and the economy versus are H-1Bs taking American jobs has been going on for a long time now. At least the debate back and forth. Mm-hmm. I could probably argue both sides. But more likely, for starters, let's look at it this way. We have the most IT jobs in the world here. I think that's a fact. Statistically, anyone will know that. We have universities and our Americans who go to study, and they don't really go into the computer engineering or these IT fields. A lot of the STEM fields, they're very weak on that. Mm-hmm. We have such a high demand, and those jobs are here and plentiful, and they need to be filled by foreign workers, for example, H-1Bs, whether they're studying here or whether they're coming abroad to work. So the argument is that the American kids just simply don't go into this field. And I think there's a lot of statistics to back that up. I don't have them on me, but I've lectured about this and I've talked about this in different places. So there's a great need for IT workers specifically. And when you're talking about H-1Bs, as you know, the vast majority of H-1Bs are IT fields and certainly STEM fields. So you can make the argument that this is a much needed, our economy it needs these workers to come in, these H-1Bs to come in and do this work. Mm-hmm. The flip side is sometimes what happens is these companies, whether it's Wipro or Tata or Infosys, mm-hmm. they come in and they do an efficient job. They have clients who have, at least in the past, have had their own legacy IT departments. And what happens sometimes is that these vendors will come in, these companies, and do a great job. They'll hire him and they'll completely replace the IT department. So let's say there were 200 Americans working there, or mostly Americans, and then you bring in someone like a Wipro or a Capgemini or an Infosys. They mm-hmm. come in and they just basically take over the whole function for the company. And this is where you can see a lot of American workers being laid off, and then it becomes a political issue, and then it gets into the press. And even though it might not be that many workers at the end of the day, it could be a whole IT department of a company, a major company. Sometimes they're replaced or rehauled. And then you can see the political drama that unfolds. Well, here you can see people are talking about losing their jobs or, mm-hmm. Having to train their replacements in many of the situations. And I've seen that. I would tend to think that if there is a robust IT hiring here where there's just so many jobs that if those folks are really talented, they will find jobs, number one. But I can see the argument where you have specific cases, and they're more emotional cases because they're more like one-on-ones, but you can get a lot of sense of when a whole IT department is replaced and the new folks coming in, they had to transfer knowledge. I can see that argument. So I can see both sides, but I really tend to think that if those folks were really talented folks or needed, that they could find jobs when those kinds of, changes happen.
Right. So now everything will boil down to the talent and the skill that the person possesses.
Yeah. Now, as far as Trump, he's business friendly. I mean, he's coming in to make the economy grow again, and we want to be the best in the world. I think he knows and he realizes, and I have seen interviews with him in the past, from the last time, where he's acknowledging that fact about the H-1B. So when you read all these articles coming out about, Trump's going to do and Trump's going to do, a lot of it is fear mongering. A lot of these people just don't like Trump because that's the fashionable thing to do on one side of our country. But you got to read it and look if there's any facts to it. And yes, definitely on the border with the illegals, I think that will be a boost will be a boost to business immigration, because you need law and order. I mean, I have clients waiting years and years. I have all my clients, none of them want to overstay their I-94. None of them want to do anything even remotely illegal or looking illegal or something that could get them in trouble. And these are the folks that need the services of the USCIS, which is, you're talking about wait times for EAD cards, and people have to come off payroll. I mean, these are people too, and they've come here legally. They've paid thousands of dollars. Their companies have filed the right way,
Right.
and they've taken the back seat to allowing millions and millions of people to come in for what purpose? So that's my opinion on it.
But Erin, do you really believe that it has now become fashionable or cool to say that we are anti-government, especially anti-Trump? We don't believe in his policies or what he says, even though everything that he has said or done has always favored the country.
Well, when I'm talking about, if we're going to talk politics now,
let's just take immigration. I mean, because mostly that whatever policies or actions that he has taken so that so that illegal immigrants cannot get in, and so that the borders are the border policy is strict, so that illegals can't get into the country. But then people don't really favor that idea also, and say that he has always been against immigrants. So what do you have to say about that?
Well, his whole platform is that he wants people to come in legally. He wants people to respect the laws of our country. And if you can utilize those laws to come in, then you should. He doesn't want and there should be borders, and there should be places where you enter, and there shouldn't be, drug cartels running in. People leave the crime and the drugs alone. There shouldn't be drug cartels organizing people to come in illegally and finding loopholes because there's no boundaries or no wall or this or that. I mean, no country in the world would ever put up with this. So when he's talking about that, he's not talking about, well, we shouldn't also allow legal immigrants because they're bad. He's never said that. And so the perception that will flow over into business immigration is just completely false. And there's 4 years of evidence of that. And when I try to argue with some of my immigration colleagues who are very, let's just say, anti-Trump or pro-open borders, as I call it, I say, well, why don't you point to something in 4 years, which he's done? And then they talk about, if you remember during COVID, when they kind of shut down visa processing and a lot of embassies. Well, that was shut down because of COVID. I mean, and that slowed the entire world for traveling. And I come back and I tell them, that's not a good example, because that was a few months, yes, and it was hard maybe to get an H-1B visa, and maybe a few people got stuck abroad here and there. But that was really due to the disease, the COVID that was killing people. And yes, movement was stopped everywhere by every country. So if you want to argue this, I'll argue with any immigration lawyer who wants to come on here and tell me that these asylum cases are actually legitimate and can show me how. But they won't, because they don't have the facts on their side, and as usual. But anyway, not to get into the other side of immigration. We're here for business immigration, and I don't see the fear. People who are reading all these articles, you just read them with a grain of salt. That's what I'm saying, because nobody knows what's going to happen. Number one, and number two, if you look at the track record, those 4 years, the L's and H's, which is mostly what your audience is interested in, were not killed or hampered, or there may have been delays here and there, but that was due to COVID. So just be careful when the fear mongering starts, because the new administration's coming in and one side has simply lost the election. So just be careful. That's all I'm saying.
All right. Thank you so much for that insightful answer, Erin. And a lot of people have joined us and have also posted their questions. So we are definitely going to take their questions. Or maybe let's just start with Hosam's question. So Hosam said he has posted this on YouTube, and he says, I'm a medical laboratory scientist certified ASCP. How can I apply with you?
With me. So as you know, most, whether it's a green card or simply, petitions, O1s, and you need a sponsor company. So if this person is a scientist and he's working in or I guess he's not in the US, I don't know, I always tell them, like, I don't find job. I guess that's your job. But we're a law firm. Our clients are companies, and we can certainly file, extraordinary ability or outstanding researcher green cards. There's an O1 category if he meets that. But like I say, most folks outside the U.S. who really don't know much about how the process works, maybe they didn't go to school here. Really, you need to find that company that wants to hire you. You have to look either in your home country, or here, find your field, apply to jobs online. And then at some point, when someone is interested in you and your services, the question will come up if they need sponsorship. That's where I come in. So we're not, I'm not going to find jobs for people. We're a law firm. I think you do that. If you're a staffing company, that's probably what you would do. But after they have a job and they're like, okay, now how do I get the person into the U.S.? We want to hire them. Then they come talk to me and we strategize and we find what solution they can have, to work in the U.S. legally. I think that's the person's probably outside the U.S., I guess.
Right. So, Hosa, maybe you can write to me. My email is rajni@staffingly.com. And yes, maybe you can share your profile with us. If we have anything else, anything for you, we are definitely going to get in touch. But thank you so much for your question. If you have a follow-up or a question for Erin, make sure that you post it in the comments below. Meanwhile, let me quickly take Kavya's question, which he has posted on LinkedIn. So Kavya says, Erin, she says, can we expect more jobs for students with H-1B sponsorship? Currently, companies are not ready to take students because they need H-1B sponsorship. Is there an increase in H-1B sponsorship of IT jobs for immigrants?
Okay, so it's hard. Okay, so look, when you're talking about, are there going to be more H-1B opportunities? Are there going to be less H-1B opportunities? That usually goes with the economy. I think now that we're going to have a business savvy administration coming in, we saw the last few years companies like Amazon and Meta, which was Facebook, we saw them lay off. I can tell you, Meta laid off like over 22,000 employees, or one of them in like a 2-year period. Large layoffs, and yes, a lot of them affected H-1Bs. They were in STEM fields, they were in IT fields. I can tell you, we had some of my companies. They were calling me like, hey, we got a new person we're hiring. We got a new person. And they seem to all be coming from Meta. So in terms of answering the overall question, it's hard to say, well, there's going to be more companies are going to want more H-1Bs or less. Companies want talent, and they have roles and jobs they need to fill. They don't care if they're H-1Bs or non-H-1Bs. Now, I can tell you this. If companies are hiring H-1Bs, it's because they really need the talent and it's there. If you think about it, to hire someone who needs sponsorship is going to cost them, in terms of lawyers and fees and all the headaches and potential green cards and perm filings and all those fees. If you look at it from a comparison basis, it's going to cost them a lot more, obviously. So if they're willing to spend that, it tells you, and it goes back to the first question you asked me, if they're willing to spend that, they don't have someone equally talented or even right there, who's going to cost them $20,000, $30,000, $40,000 less in the long run, which goes to show you that the vast need, and I think it's only going to grow. We can see a lot of movement. I don't know if anyone's out there is doing AI, but a lot of those companies are coming up. And then the traditional companies like, the big thing like Google and all of them, they're still hiring. Their numbers will fluctuate. I think there's going to be more opportunity, but it's hard to say, it all depends on what you're doing and what field you're in. And then, the market is still good for students, for foreign students coming out and then, sending in resumes and being hired based on their talents. Yeah.
Right. So, Kavya, I hope you have got your answer. Thank you so much for your question. If you have a follow-up, please continue posting your follow-up. We are here with Erin for some time. We'll be taking your follow-ups too. So right now we have questions from Rag, then RK, Ankit Goel, Lokesh. So many questions are here. Guys, I'm definitely going to take your questions and ask it from Erin. But before I do that, Erin, I would also like to know from you that what factors do you believe have contributed to, the decline in H-1B visa approvals in 2024?
The decline in approvals. Well, I can tell you, So are you looking at statistics where you have the top 10 visa filers and like Amazon went down a few thousand? Is that what you're talking about?
Yeah, Amazon and then Google and so many
Yeah.
companies actually went, yeah.
Okay. Yeah. So if the question is USCIS getting any more stingy or harder to approve? That's not the situation. I will go back to individual company hiring and the economy. When the economy is slow and these companies aren't making what they do, they tend to lay off. So that's probably what happened there. I don't know internally at like Amazon. I don't think they would say, well, we're just going to lay off. Although there are companies who do take a policy I've seen lately where they might say we're not hiring those who need sponsorship. I mean, obviously you can't discriminate, but for business necessity, you can ask that question when you're recruiting people. Will you need sponsorship? So that might be a trend, but I think it's more the economy has been bad. And we're in the last year or two, we're seeing ramifications of some of these big companies just wanting to lay off and making cuts and maybe not hiring as much until they can get back, until the economy can start rolling like it did, prior to the last several years.
Okay, so it has nothing to do with USCIS's strict approach or nothing to do with the government or the law.
No, I file H-1Bs every day. They're very straightforward. Yes, you'll get an RFE. Sometimes you'll get an RFE when it's not warranted, but there's not. I would say it's even easier to get an H-1B approved now than it has been. If you think about third-party client sites, they've completely, in the past, I can remember getting massive RFEs on the third party. Oh, where are they working? They're not working at the company. And they've stopped doing that for the last several years. So we don't see those RFEs anymore. If you got a U.S. degree, they're not going to question the specialized knowledge. Yeah, they'll throw. Those are usually boilerplate RFEs. And you get those and they're unfortunate and they create a little bit of a delay and more cost. But right now, I don't see a huge uptick in those. I can tell you I have seen months in the past where there's so many H-1Bs or a particular year where they're going, but it really doesn't correlate with changes of administration from what I've seen in my experience.
Okay. Thank you so much for answering the question, Erin. Let me again move to our viewers' questions because we are getting quite a lot of them. So let me take maybe RK's question. So RK says, just like the perm process, if you have major layoffs, you can't file new perm. That should be the case. If you do major layoffs, your site should not be eligible. Get H-1B for the fiscal year. H-1B is a great program, should help add workers, not substitute. If a company has 10 American workers, then apply for 5 H-1B at the end of the year. That should have 15 workers, not 10 or worst 8. I don't think so there's a question, but this is what he says.
I think he's trying to say that he doesn't want H-1Bs to replace American workers. I mean, I have a lot of clients. I've worked with big companies, small companies. I don't think these recruiters, and I deal with them a lot, I don't think the recruiters are trying to say, let's get this person because we don't want the American, number one. And then he'll make the argument, well, maybe the H-1Bs will work for less, so they're cheaper in the recruitment. I mean, we know about that when we're recruiting. Maybe we can get them cheaper. It's hard to qualify that. I just think if they need more, they're going to hire more workers, and they're going to hire them where they can get them and as fast as they can get them to get them in there. If a company's growing and the IT needs are growing and the AI is growing and all that stuff, then they need them. They're going to find it's a market out there. These recruiters are cutthroat. I mean, and then if you're coming out of school and you have a skill, like lately I saw maybe 4 or 5 years ago when AI started to become popular and all those AI jobs. I mean, I remember some of these students would come out and my client would be like, we got to offer them this and the perm and the green card. We got to give them everything because these kids come out of school. They got 3-4 offers. I mean, they got companies after them for these skills. It's amazing. So, yeah, I would have to counsel my client and be like, I mean, I'm doing your immigration, but yeah, I can see the talent pool. These guys with these niche talents, guys and girls with niche talents, they're so sought after that you're going to have to offer them the perm quicker. Some of the companies would start their perm right away, right? Even they're doing their EAD and they're on their OPT and they start it right away. So yeah, I just think it's economics basically. Are there cases out there where companies won't think they can fire Americans and hire cheaper labor? Probably it exists, but I think the overall mass numbers are because these jobs are there and these companies need them and they'll get them from wherever they can.
Okay. Thank you so much again, Erin. Let me take. Okay, Rizwan is here. Rizwan says hi. Hi, Rizwan. Please post your question if you have any. And then Dezaljin, I hope I'm taking your name right. I'm sorry if I'm not. He says, hello, everyone. Please post your question in the comments below. And now let me take Rak's question. So here, Rak said, will L1A for a tech non-profit RFE? What do you have to say?
You broke up there. Let me see if I can read that question. Will L1 tech nonprofit face extra scrutiny or even an RFE? L1A for a tech nonprofit. So there's really no difference whether you're filing for an L1A for a nonprofit or a profit. The issue with scrutiny will come whether the company can support the salary of the L1 worker. And is there a structure in place where the L1A will be overseeing professionals or supervisors? So the scrutiny is across the board for L1A. It doesn't matter whether you're a nonprofit or not. That's what they look at. And yes, L1As have been harder over the past 10 or 15 years. They used to be just a piece of cake. You didn't hardly have to file anything. Now, when we do an L1A application, we put in org charts and emails of the manager actually overseeing people, really the nuts and bolts evidence to try to avoid the RFE. When I used to do L1A petitions, there were like 2-3 pages. Now my support letter has gotten to 15 to 25 pages. And I'm trying to avoid the RFE for my client is what I'm trying to do. So I'm trying to get everything in there, as much evidence as I can. So you can just see the trends. And, L1B has been traditionally the hardest, application to be approved of all the work visas. And those you really have to put together a very strong L1B argument. It's evolved over the past 20 years from, like I say, maybe 2-3 pages and a little bit of explanation to 15, 20, 25 pages and exhibits like this. So there's been a big evolution in the L1 field, even though there's been really no changes to any L1 restrictions or laws or adjudications or obviously numbers, because there's no limit or lottery on L1s. So it's interesting.
Mm-hmm. Okay, so Rak, I hope you have got your answer. Thank you so much for your question. Please continue posting your follow-ups. Sita is also here. Sita says hi. Hi, Sita. I hope you're doing well. Please post your questions in the comments below so that we can take it and ask it from Erin. Meanwhile, let me take Ree's question. Reese has posted this on LinkedIn. Reese says, so if most companies are laying off, why do we need to import labor? Does the law have some throttle for economic slowdown?
If most companies are laying off, why do we need to import labor?
Mm-hmm.
Well, we talked about 2 big companies that had big layoffs in the press. And yes, other companies do lay off from time to time. I'm not sure if most companies are laying off right now. I don't know if that's the fact. But assuming that is the fact, if most companies are laying off, and I guess you're talking about H-1B fields, IT workers and STEM workers, mm-hmm. Do we need to import labor? Probably not. And that might be the reason why Amazon's or H-1Bs went down 3,000 in 1 year, or some of the other companies in the top 10, their numbers went down. That's probably the answer, is they weren't importing labor or sponsoring a lot of H-1Bs. So you might have answered your own question right there. Does the law have some throttle for economic slowdown? I don't know. What do you mean by throttle?
Reese, if you can please, write your question in detail. What do you mean by this? Because I was also trying to figure out what actually this question meant. So maybe if you can explain us what you actually want to know from Erin. Meanwhile, let me take Rizwan's question. So Rizwan says, hi, I moved from Pakistan to the USA 3 months ago. I am a front end developer and I have applied for lots of jobs but not received job. Please, any job or intern. Okay, well, again, he says this is about a job opportunity, which I don't think we should be talking about here. Rizwan, how about you send me an email on my email ID, which is rajni@staffingly.com. Reach out to me there, and I can help you with something if we have an opportunity for you. Okay, so Rak says people manager L1A has better success than functional manager.
Okay. Where's the question? Okay.
Yeah.
People manager, regular L1A has better success than functional manager. I would agree with that. We do functional manager, but functional manager L1A are much harder to prove. You have to really show that the function of the company that the person is managing has some intrinsic value or worth. So, for example, let's say it's a project you're managing. When we do those, and we don't do them a lot because, as he says, they are much harder. But let's say we have to do that because there's simply no management of people in the traditional sense. We would show that project, we would show the financial figures, number one, from that project versus, let's say, what the company's income revenue is. We really have to build a case and show them, yes, they're managing, but it's functional and how intrinsically valuable this is to the company. And you can do that with numbers. You can do that with revenue. You can do that with letters. If it's a project management situation where they're managing that project or that function for the company, it can be a project. Then you want to bring in additional evidence, maybe letters from the client showing the longevity and the importance of the project to the company, how that project, without that project, the company wouldn't exist, or things like that. But yes, they are very hard to do. He's right. The functional manager is very highly scrutinized. That's not to say that the L1As are not scrutinized as well, but it's just a functional manager. You have to really put in the worth of the function that they're overseeing or managing.
Okay, so Rak, thank you so much for that comment. And Ankit is also here. Ankit says, my company is filing multiple H1B petitions for different candidates, including me. How does USCIS determine if a company is trying to game the lottery system? Could my application be impacted even if I'm not involved in any wrongdoing?
So if he's describing a situation where an unscrupulous company is somehow filing multiple H1Bs illegally for the same person, yes, you could be impacted because even if it's approved, they're doing investigations and they can come back and revoke the H1B at a later point in time, which means you're going to lose your H1B, even if you're not even working for that company anymore. An example I gave at the beginning of the show was one of my clients. They're working for this company, but now they're challenging how they were picked in the lottery, and was that legal and was that correct? And that's something new. So that's interesting to see. And it's good that they've got people who are looking at this, and they maybe have a better electronic system in place where they can kind of, look at the data and see who's filing for who. And that's why they're asking for your passport number. Because they can easily see how many applications were filed for. Maybe 150 applications were filed for one person. They could see that, and that's where they're going to start looking. So that's good for them in their investigative process.
Right. So this reminds me of a question that actually I prepared for you, Erin. So I want to also know from you, how can applicants actually ensure that their job offers are legitimate and not at a risk of being categorized as fraudulent?
Yeah, that's a good question. Research the company who's offering you a job. See who they are, number one. I guess if you're in India, and there's a lot of companies in India, and some of them are legitimate companies and some of them are not, right? And I guess that's the situation we have here. Some red flags are they're requiring you to pay for your H-1B. You're not supposed to be paying for your own H-1B, number one. So that's a red flag. If you're the company and they're like, hey, yeah, we're going to get you an H-1B. We just need you to pay for it, or we need you to forward us some money here. Be wary of that, number one. Number two, ask questions. Where am I going to be working? Where's the job? That should be in place. A lot of times, obviously, the employee is not going to see the contract between their employer and maybe, the client, but try to ask questions around what you're going to be doing, where you're going to be, where's the physical location of the job. If you're an employee and they're filing, you're entitled to see the LCA, although that will come later after you've already decided to go with that company. But your H-1B employees are entitled to a copy of their LCA. They can see everything that's been submitted for them. You should also have a copy of the I-129, which tells the government, here's the job, where it's going to be, what the person's going to be doing, here's the salary. All of that stuff's in the application. So if you're an H-1B, if you're looking to become an H-1B, just research the company, look for some of these red flags, and don't pay money to a company in India who says, yeah, I can get you an H-1B, just we need $500 up front or something. So look for those red flags.
Right. But Erin, do you believe that stricter penalties for fraud will deter companies from questionable practices, or do you think that can happen?
Yeah, I mean, if they're starting to crack down on them and they can actually get these companies and prosecute them, yes, certainly stopping them from filing H-1Bs. The problem is, these companies they morph. They're one set, and then they find them and they stop them, and then they open up new companies, right? Mm-hmm. So if they're in the business, and if they're in the criminal business of job shopping, they might not even be in the U.S. They can certainly prosecute the ones that are in the U.S. easily, and they have. There's been some cases, you've probably read about them. But if they're overseas and there's a lot of players involved and they're savvy, they simply open up another company tomorrow and they repeat the process, right? Mm-hmm. But yeah, hopefully they will have more efforts to be able to locate these, and then they prey on the cap lottery. This is their big money maker, right? Every year. Mm-hmm. So hopefully, with all the it's gone electronic, but with all the data that they want, they can do a better job of pinpointing who the lawbreakers are and who are the actual legitimate H-1B filers.
Right. So now with upcoming changes under Trump's administration, what adjustments should applicants anticipate regarding H-1B visa policies?
Okay, like we discussed before, I don't think there's going to be a negative impact to companies filing H-1Bs, adjudications of H-1Bs. I hope it gets better. This past year, we have fees on H-1Bs and Ls and other business immigration visas that we've never seen before, called the asylum fee. I don't even know how this is constitutional, because these companies are filing these petitions and they're paying now an additional asylum fee on top of all the other fees we have to pay for the illegal asylum scam program that's going on the border. Now, why that floats into business immigration, I don't know, but you can see there's something that hopefully they will do away with. I don't understand why businesses have to pay an asylum fee for a program that is just overwhelmed and in my opinion is a scam. So hopefully that will go away. That will make things a lot easier for small companies who are already paying exorbitant fees, and now they got to pay an extra $300, and even bigger companies who have to pay $600 for every application, on top of the ACWI fee, the fraud fee, the I-129 fee, and all these other great fees that we have. When I started practicing immigration law, I was in Israel at the time. This must have been around 2000 or 1999. Mm-hmm. The fee for an H-1B was $85. There were no other fees. Wow. Now I file a fee for my client. They're looking at almost $5,000, not including premium, for one H-1B. $85, $5,000 premium. I remember when they started the premium program, it was an extra $1,000 or even less, I think. That's gone up every year. Now it's $2,800 to add premium to your case. Mm-hmm. Lovely. And USCIS takes in so much money in fees. Just USCIS, if you think about it, if it was run properly, they could make massive profits for the government. But apparently they don't, because now they got to add more asylum fees onto it. So they're not making profits, and the wait times and the client service, in my opinion, in 20 years I've been doing this, has gone like this. Now you can't even talk to. I mean, a year and a half ago, I could at least get someone on the phone. Now they've gone to all these things where you got to email them. They've gone to the lockbox. The lockboxes are just a nightmare. Now they have vendor companies coming in and intaking all the mail before it even gets to USCIS. And I can tell you the folks doing that are not the best, let's just say. And these lock boxes are sending cases back at a rate I've never seen in over 20 years. We're getting cases back for the stupidest reasons, for little things here and there. It's just very frustrating what's going on right now. And I'm hoping with all of these efficient people that he's hired to look at USCIS and efficiently clean that up, because that could be a moneymaker with these fees as high as they are. You could be efficient and make money and bring back the client service that we used to have, which wasn't 100% the best, but at least it was some good client service where you could, they make mistakes and clients pay a lot of money. So when you make a mistake and clients pay money, you need to have some client service that can help efficiently. So hopefully that will change for the better as well.
Okay. Well, let's hope that. Thank you so much for answering the question. Erin, RK is back, and this time he says, do you think it would be a good idea to make it that 70% of the H-1B must be granted to individuals like F1 students who have already invested, lived, worked inside the US?
It's interesting. It's an interesting. First of all, as you know, F1 students, if they're in the STEM field, they're going to have 3 H-1B lotteries to make it. Now, most of them do. I do have some. We have some that go 1, 2, and 3, and unfortunately, they get unlucky. So I can see that. I don't know if that would be a solution. Maybe something for F1s where after their STEM OPT was finished, and they could show that they applied for 2 or 3 lotteries and didn't get it. Maybe they could get some kind of extension. That could be a good idea. And then they could keep applying for the lottery. Maybe that could be when you focus on 70%, that might not be fair to other companies who rely on H-1Bs who maybe don't have a lot of F1s. So I have both types of companies as clients. But there's a lot of things they can do. They've talked about in the past making it. You could also say, well, some of these big companies, they get thousands and thousands, and you might be a little company and you only need 1 or 2 H-1Bs. Is that really fair that they're depositing 3,000 or 10,000 H-1B lotteries and you're depositing 3? And maybe all the ones who are small companies should get all those filled before all the big filers. Well, that would hurt the big filers. There's been a lot of different proposals on how to make it. They had it they proposed maybe H-1B should go first to the highest salaried applicants. The problem there is now you're going to kill small businesses. Microsoft and Google, that'd be great for them because their salaries tend to be very high. But now you're killing the other side of the H-1B filer. So I don't like that. There's a lot of proposals to make it more fair. Right now, as we stand, it's traditionally anywhere from 33 to 40% chance of you making an H-1B lot, closer to 40 if you're a master's. If you have a U.S. master's, probably closer to 32 or 33% if you don't have U.S. master's. So those are pretty much the numbers. Now, I can remember one year a few years ago where we didn't have a lot. They didn't fill the numbers. That was when the economy was really bad, if you recall. And the H-1B went on. When I started doing immigration, there was no lottery. Of course, there were 300,000 H-1Bs a year, and they went on year round. So we just filed them whenever they came up. Yes, this lottery system is interesting, but I guess it has to be there because the demand is so high. How else could you have a fair way of intaking them? But there's a lot of different ideas out there. I don't know what the best one is. It would have to be really thought through and fair to different kinds of H-1B filers.
Right. People can come up with their ideas, but ultimately it will depend upon the government, what they come up with and what they decide to do, right? So thank you so much.
Yeah, F1 students are a big part of, they're already here, number one, and they tend to be very talented in terms of these niche IT fields, even more so than your run-of-the-mill, let's say, H-1B worker at one of the big Indian companies. You know what I mean? These folks are very highly specialized. They're already here. Culturally, they're very attractive. They've already blended in. There's a lot of advantages to them. So maybe they should look at something to help the F1 students a little bit more. The STEM OPT is great. We haven't had that forever. That was new a couple of years ago that came in. Maybe an extension of that, but yeah.
Okay, so actually, Lokesh also wants your advice. He says, I have been with my current employer on H1B for 3 years, but I received a better offer from another company. With the current climate of fraud crackdowns, how likely is that my transfer petition might face extra scrutiny? What can I do to avoid any delays or rejections?
Okay, so H-1B transfer, or what we call H-1B portability cases, is exactly here. You're working and you have a great job offer and you want to jump ship, you want to move to the new company. So first of all, the first thing to note is that your current employer will not see the new H-1B application. They have no way to see that. So your current employer will never know that you talked to a new company or that even the new company filed an H-1B for you. So as long as you're staying with your current employer and don't tell them anything, you really don't have any jeopardy of losing your current job. That's why a lot of the H1, we do a lot of H1B ports. When the H1B workers are porting, they always want premium because they want to have the H1B approval in their hand. Mm-hmm. So first of all, H1B ports can start working when the application is filed. They don't have to wait for the approval, which is great. However, a situation like this, where you already have a good job and you got another good job that's going to file an H1B for you, this guy wants premium so that he can have the approval notice before he says anything to this job. I understand. It's a sense of security because you could start working with the other employee based on the approval, based on the filing, and then something can go wrong in that application. Now you screwed yourself and you're going to be really screwed. So yeah. So if the new employer could file in premium, that might be good for you. That way you don't even have to involve your current employer until you have a new approval notice, and then you can move. That's usually what's been going on. That's what we see most of the time. My client gets a new one. They're like, yeah, but they want premium. And then the client's like, well, I don't want to spend $3,000 if I don't have to. They can start working with me now. I'm like, yeah, but a lot of these port H-1Bs will not start with you until they have that a little bit of the security of knowing they have that approval notice.
Right. Okay,
now, if you're talking about, go ahead, sorry.
No, please go ahead.
If you're talking about fraud crackdowns based on what's going on with the lotteries, that can come and hit you. If you were involved in a lottery with an unscrupulous company and you feel that maybe they were doing something, they were one of these, what I call job shoppers, then you got to be careful. That could come back and hit you at any time. That's out of your control. You're not going to know what investigations are going to be done against a company that you had an H-1B with 2 years ago, and then they're going to bust them, and now they're going to revoke every single H-1B they had. And then, yes, you could be affected by that. So,
yeah, right. So thank you so much for that advice and for that answer, Erin. Lokesh, I hope. And Erin, we also have questions which are posted by the viewer on a Facebook group. So if you allow, I would like to share my screen.
Yeah, sure.
If it's possible.
I can run over. I have time. Share. I can answer questions. That's fine if you want to go along. Yeah, I can hear you.
Okay. Thank you so much. Okay, I would like to share my screen. Okay. So this is one group where people have posted questions regarding H-1B. So this anonymous member says, because of long waiting time of NIW, this is, I think, an EB1. Maybe let's take H-1B related question. Okay. Kaushik has posted this 14 minutes ago, and he says, hi all, if you valid visa until April 2025 and have renewed H-1B petition till April 2028, you are good to enter US with the existing visa along with renewed petition without restamping with new petition, right?
As long as the visa is valid, unexpired visa, correct. So let's say I work for company A, I have a visa for 3 years, I port to company B, I got an approval notice, and now I want to travel. With the new approval notice of company B, you can use the visa from company A as long as it's valid. In my example, it's valid for 3 years. Yes, you can keep using that visa to go in and out, even though you're not working for company A anymore, but you must have the approval notice for company B to show them every time you enter, if you don't want to get a new visa stamp.
Okay.
But the visa always has to be valid. You can't come in on an expired visa. That's one thing you cannot do.
Right. Okay. Kaushik, I hope you have got your answer. Let me quickly read. Okay. So actually, we've been continuously getting questions on this group. Please respond fast. I have doubt. I have Dropbox appointment today. My pay stubs have old pay and company didn't mention my new salary in employment verification letter. And in Dropbox, they won't ask my revised offer letter, but I have it. How will they know about my new salary? What should I need to do?
If you've already submitted everything in the Dropbox, there's nothing you can do. They're going to send, you've already submitted your passport. They'll send it back to you with the new visa. If they have a problem, they'll let you know. Getting increased salary is not a big deal. In fact, if you're an H-1B in the U.S. and you've gotten a huge jump in salary, we don't file H-1B amendments for that.
Okay.
So I don't panic. This person's panicking too much.
Right. So maybe they need to calm down a bit.
Yeah.
It happens because you have just applied for the visa, so that's fine. This anonymous member says, can I get stamping to passport, which will be expired in 7 months? Once stamped, I can get passport renewed and can fly to US from India with all new passport and valid stamping.
Yes. If you have let's say you got an H-1B visa, but then the passport expires, but the visa is still good, you get your new passport, you travel with both passports, and he will look at the visa in the old passport, and you can travel like that. Correct.
Okay. So, okay, this person says, hi guys, I worked with DXE Technologies in India, which was an HP enterprise back then. Now I skill set. Okay, no, this is not related to. Hello, please assist me in understanding the table. Okay, this is again a table. Okay, this person says, I got NOIR, H1B after USCIS site visit. Any idea how long will it take for USCIS to take final decision? Employer replied for the notice.
So the NO notice of intent to revoke was received, and the employer already responded to them.
Mm-hmm.
And that was outside a regular filing, I guess. Or was it a premium case that was filed?
Not much details are here,
Well,
but this
I mean, if
it
it was
says H1B after USCIS site visit.
After a site visit, okay.
Yeah.
It's hard to say. Those can sit for a long time. I guess there's no premium in play here. So if they've responded, it's hard. It could be all over the map. It could be a couple months. I don't know. We've had those that have pended for a long time, and we were like, wow. I mean, the good news is you're still working and you don't have to leave or anything. So
Okay.
It's hard for me to get timelines. Are the hardest questions I have from my clients, because you can look online and see time frames, and those are usually not really good. And then someone's asking you, well, when am I, it's not premium. When am I going to get my case? And we can look at trends, but it's hard to really give really good pinpointed timelines of when you'll, outside of premium, of when you'll get cases back. It's tough. That's a very frustrating part of it.
Okay. So, all right. Thank you so much for answering these questions, Erin. I think we have had a great show with you. We did try to cover a lot of questions, though still a lot of them are pending, but we still try to cover a lot in today's episode. So thank you so much for being here. And to our lovely audience, I would like to say that if you would like to get in touch with Erin, please give him a call on the number. I would like to display on screen, or maybe I would like to request a control to display on screen.
Yeah, 469-459-1771. That's the office. You can reach me.
Right. So please give Erin a call on the number if you're trying to get in touch with him. His number is 469-459-1771. I would like to repeat it, 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. And you can also visit his website, which is www.eeglawgroup.com. Yes, you wanted to add something to it, Erin. Please go ahead.
I was just going to say, if you're calling me, I can give you advice and help you. But if you're really looking for a job and you don't have an employer, we're a law firm. You need to,
Right.
find some recruiting companies. After you have an employer in place and maybe a job offer, and you need assistance or you have questions, I can answer those questions. But I can't. I sometimes we get questions where they're just looking for a job, and it's we're not in that business. So
If you're looking for a job, guys, you can get in touch with me. My email is rajni@staffingly.com. And if you're looking for any looking for a help related to your immigration related case, so for that, please get in touch with Erin. We have already displayed his information and also have read the information for you so that you can note it down. So make sure that you get in touch with Erin as soon as possible. And thank you so much for joining us today. Erin, thank you so much for being here. It was lovely having you. Maybe we can have you for another episode so that we can cover more questions in that show. But thank you so much for being here again today.
no problem. Good talking to you. Thanks for having me. Good to be here.
Thank you so much. And guys, thank you so much for your questions. Please continue posting them, because whenever Erin is going to be back, we are going to take those questions in that episode, or maybe we can directly ask him by writing an email to him asking for the answer. So we are going to reply to your questions in the comments below. So you make sure that you continue posting your questions in the comments below. But for now, that's it from my side. I'll have to take your leave for now. I'll be seeing you again tomorrow. But for now, thank you. Keep watching and keep subscribing to Immigration and Jobs Talk Show. Bye for now. Hello, everyone, and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host, Sam, and I'm back again with a very exciting episode that is lined up for you today. So, before diving into today's topic and announcing the name of our guest, here's a very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, once again, friends, welcome back to Immigration and Jobs Talk Show. And today we have got a very timely and crucial topic to discuss on. That is, how will the new J1 skills list transform your immigration journey? So, friends, if you are or someone you know is a J1 visa holder, then watch this session till the end, because this new J1 skills list could transform your immigration journey. So, today we are diving into the new J1 skills list and also understand what it means for your future in the US, how it could transform your immigration journey. So, it could be a game changer for those looking to extend their stay or transition to other visas. So, to break it all down and give us an expert advice, we are thrilled to have an experienced immigration attorney with us. Attorney Poonam Gupta, with over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation. She has become a go to expert in her field, and her deep understanding of US immigration makes her a trusted advisor for businesses and individuals alike. So, without any further ado, let me welcome our today's very special guest, Attorney Poonam Gupta. Welcome, Poonam. It's truly an honor and pleasure having you with the show again. How are you doing?
I'm great, Sam. Thank you for having me, and it's a pleasure being back on the show. So, looking forward to addressing all the questions.
Yeah, absolutely. So, Poonam, I would also like to know, before starting our today's session, that what our viewers can expect from today's episode.
So, the this is the first time in 15 years that the Department of State has updated this J1 skills list. Why is J1 skills list important? Because this determines which individuals from which countries in which area are subject to a 2-year home residency requirement. And identifying what that means changes what the immigration journey for an individual can be. Is it something that they can stay in the US from the time that they come here? Or is it that they need to take a break, go back home for a couple of years, and then come back? Or is it that they can stay here, but they need to apply for a visa? So, what path they take changes depending on what's on the skills list. And as I said before, this is the first time in 15 years that the government has updated this list. They are committed to updating this every 3 years. So we will see. Hopefully, they will keep up with the times going forward. This update has been a long time coming, for sure.
Wonderful. Thank you so much, Poonam, for answering this thing. And I hope our folks are also watching us on different platform from YouTube, LinkedIn, Facebook, and on X as well. So, friends, stay tuned, and I'm sure this is going to be a very informative session. So, don't forget to post your questions from whichever platform you have joined us. And meanwhile, I would also like to begin with my very first question. So, yeah, Poonam, the new J1 skills list has been updated recently. So, can you explain what exactly this list is and why it is so important for foreign nationals looking to come to the US?
Sure. So, J1 skills list, it's a list of countries
Hello, everyone. Welcome to Immigration and Jobs Talk Show. I'm Napasa Pradhan, your host for today, and I'm very happy to have you join us, for this very amazing discussion that's lined up for you. So, before we start off, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, thank you so much for joining us on Immigration and Jobs Talk Show. And our topic for this session is going to be all about family visas, how Trump 2.0 could change the future of family immigration. As we look ahead for potential shifts in immigration policies, it's essential to understand the stakes, challenges, and what might be on the horizon or on our plate for families hoping to reunite in the United States. So, to help us unpack this complex and dynamic topic, we have a very special guest who's going to join us for the first time here on Immigration and Jobs Talk Show. Please help me welcome him, Attorney John Q. Khosravi. And John is not only the managing attorney at the JQK law firm specializing in family, business, and talent based immigration, but also an adjunct professor of immigration law at Pepperdine Law School. So, as a first generation American with immigrant parents, John brings a unique and deeply personal perspective to his work. And his expertise is unmatched, and it's going to be great to have him join us today in our show. So, without further ado, please help me welcome John Q. Khosravi. Hi, John. Thank you for joining us.
Hi, Nipasa. Thank you so much for having me in the wonderful intro.
Thank you so much. But we'd love to get to know you better. So, anything else you want to tell us about yourself would be great.
Sure. I just happened to become an immigration attorney 15 years ago because it's just the first job I got. A lot of American lawyers don't go into immigration directly unless they're working with asylum applicants, but they fall into it and you kind of fall in love with it. The people you work with always have very interesting backgrounds. It's like reading the best biographies every day in a meeting. Everyone comes and has a exciting life, and it's a blessing to be able to do this work, and especially with the technology that we have nowadays, to reach out all across the world and talk to people. So I really enjoy it. I'm really happy I got this job, and it opens me to speak with people like yourself.
Absolutely amazing to have you. And you're a professor, you say. So, how long have you been teaching immigration?
So I started teaching immigration law first at Loyola Law School, then at Pepperdine there in Southern California. I don't know, it was like 7 or 8 years ago. And then when COVID happened, they had us all do our teaching through video. So I stopped that because the fun of meeting students in person was gone. But instead, I
Yeah.
started a different program. Instead of going for law students, I started a program called the Immigration Lawyers Toolbox, where I train other immigration lawyers, either new to the field or who wanted to learn more about certain aspects of immigration law. So now I have a program called the Immigration Lawyers Toolbox. This is intended for other professionals, other immigration lawyers. And so I do direct professional business-to-business training and business lawyer training more than students nowadays.
Wow, that's amazing. That's
Thank
amazing.
you.
So good to have you. And I think, yes, what can we expect in our discussion today on this topic, all about family visas, how Trump 2.0 could change the future of family immigration?
Well, when I first started doing immigration laws, it was really happy because always helping people, and we figure out the way to get them going. Since the Trump administration began last time and this time, I kind of feel like I'm a doctor giving people bad news because it's just going to be depressing to a large extent. But it's better to know what you're dealing with. Go to the doctor early to catch any issues is the main thing. The biggest problem is going to be delays. There's very few things we say for certain, because we don't know exactly which direction to go. The government is going to be sued and pushed back on certain things. And Elon Musk is helping the government. Who knows if he has a more pro-immigrant idea, and especially from large parts of the country, including India, a lot of his skilled workers coming. It might be different, but delays are going to be there for sure. There's numerous ways they're going to do that, and it's already evident it's going to happen. So that's like the thing to expect. And by knowing it, at least you can plan out your life properly. So if you don't quit your job or sell your property immediately, you know that there's going to be delays. So don't rush into things in this process.
Right, right. And we are going to unfold more under this topic for sure. And before we move ahead to our questions, I have this important thing to tell you, folks out there, you can join us also on call. The phone number is displayed on the screen. The number is 425-436-6335, and they'll ask for an access code, and that's when you dial in 988-888 and just say hello. After that, we'll be able to hear you. So yes, I'm excited. I hope you can join us. And otherwise, you can also comment wherever you're watching us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So please feel free to drop your questions in the comments, and we will address them today in our webinar. So, yes, John, coming back to our discussion, recently Tom Hooman suggested that, he said that he would deport families together as a way to enforce stricter immigration policies. So, John, how do you interpret this statement from a legal and practical perspective?
Well, I didn't hear the beginning of the statement. Who was it that made that statement?
Tom Hooman.
Tom.
The Baudazar.
Oh, yeah, that guy. So, I mean, a lot of his stuff is going on with what's going on at the border, the southern border of the United States, where millions of people have been coming the last couple of years. And essentially, they haven't been managing and organized really well. It's become very chaotic. And unfortunately, it's led to a lot of people, abuse happening, cartels running wild. So that's going to be a major issue on trying to figure out how to stop that. And the people who have already here, or at least create a manageable system, the people who are here, how to connect with families, do stuff. It looks like they'd be very harsh on it. But there's one aspect of U.S. immigration laws. Most will have to have a court hearing. And there's not enough judges to even handle the amount of court hearings. And it's very difficult to hire judges, train them, all this kind of stuff. So there's already delays in being, again, if they want to kick anybody out, they got to go to court first. And the courts are backed up like crazy, like 3 million cases right now backed up. If someone has an immigration court hearing today, or they get caught or something like that, they might say, come back in 7 or 8 years and we'll see your hearing. So if they get all these troops and amount of people try to, take people in the U.S. to kick him out, essentially, it's going to take 15 years for that to happen. So inevitably, a lot of this rhetoric has to be very harsh as a bargaining tactic, which seems like something Trump does, because to scare people, because I've had people call and tell me they're just going to leave themselves because they're afraid. It has a goal in it. Practically speaking, because of the way the system is designed, they can't really do much because everything is frozen stiff. It's just the system is going to break, and there's nothing you could do about it. But they could prevent people from coming in, adding to it, which is a lot is at the border, and then again slowing things down in the legal immigration end, and changing things up there, which we're going to get into. But I think a lot of the rhetoric is to scare people to kind of self-remove themselves, and to kind of set the tone so people are afraid, and that gives them more leeway in negotiations with Congress and new immigration programs. I think that's a lot of what's happening.
Right. Well, thank you so much, John, for giving us your perspective on this.
Yeah.
And now let's move on to our set of questions, and I have this first one. So, how could a potential Trump 2.0 administration impact the family-based immigration system in the U.S.?
Sure. So there's the family-based immigration programs that we have in America are several types. So if you're a U.S. citizen, you're applying for a spouse, a parent, or minor child. Those are called immediate relatives. If the child's in the United, or the family member's in the United States, the changes aren't going to be that different, other than some delays and forcing interviews for people to go to interviews. Where in the last 4 years, they would just approve the case based on paperwork back and forth. If they're outside the United States, and this goes to all family cases, those are probably going to see additional delays in processing for background checks. Last time around, we had a lot of consular officers, people who work at the embassy, who were against President Trump leave. So all of a sudden, they were understaffed. There's less funding going towards that, so they had less money to even hire people and staff. So you're going to see a massive slowdown. If you're overseas, it already takes a while. It's going to be even longer. Now, when it comes to other categories like brothers and sisters of U.S. citizens, adult children of U.S. citizens or green card holders, those are things that have been discussed to be on the chopping block, to get rid of them for many years for people that are against as wide of a family-based immigration system that we have. Those are part of the statutes. Those are the laws in the United States. So the president can't come directly and say, we're just going to cut this out. But again, that as I was talking about the rhetoric earlier, by having a position that's so strict, potentially they can negotiate these and get rid of them in the future. But right now, as it is you can't really change much other than just throwing wrenches in there and creating problems to slow it down, to just make frustrating for everybody. So that's the thing they're going to do. And then there's this other family employment-based stuff. Is if someone's in the United States, they got a green card through work, and while they're getting the green card, they go and get married back home. to bring that spouse here, that process is backed up because the bureaucracy, like a year or two, that's going to probably get backed up again. So it's like they're not going to stop that process. Someone's here, CEO of a tech company, they got a green card and they just went back home and got married. That the spouse could get a green card based on the employment, not even based on, it's not a direct family case. It's a family member of an employment-based person. That has slowed down with the forms and stuff that exist. And that's probably just going to get worse and worse the way things are going. Because in the last 10 years, it just, even under Democratic administrations, they've been slow. So it doesn't look good to a large extent. And again, it's going to be delays more than anything.
Sounds frustrating already, and I can only imagine.
Yeah, we've had
Do you think
couples
Sorry.
engaged and they decide, and I tell them it's going to be how much time, they end up breaking up. They're like, I can't wait 2 years. And if you're from Iran or Pakistan, you might have to wait 4, 5, 6 years to get your case through. And so people are even getting divorced or even breaking up. It's very sad that these delays are just tearing apart families. People are not seeing their children for 5 or 6 years because of it. It's terrible.
It's terrible, really. Well,
I'm sorry.
do you think that they're going to make it that frustrating that they would also give up on this situation? I mean, you've already mentioned, of course, the divorce and separations and everything.
Yeah, on the employment side, sometimes employers will be like, I can't wait 4 years for a guy to come or a gal to come here and work. So if that's a problem. And for couples, they do, because if they're planning on where to go, a lot of times they would say, I'm just going to go to Canada instead. But Canada is getting bad too. So people are kind of stuck. And when it comes to fiance visa holders, we got a question from Mango over there. Can you clarify follow-on benefits? You married a green card holder from India. What about K1? So we'll talk about the K1. The K1 fiance visa is if you met someone overseas, you're a U.S. citizen is the first requirement. You can't be a green card holder, be a citizen. And you met someone overseas in the last 2 years, physically met them. There are exceptions to that rule, but it's very hard. You could file for a fiance visa for him. And that process is already delayed. It's not much faster. People think it's faster than the marriage case, but not really. And that part's going to be delayed. And again, it depends on what country you're from. Pakistan cases could take extra years, for example. Iran cases, if there's a travel ban, it's going to be horrendous. And so you're waiting for a fiance to come for 4 years. People fall apart. So that's a major issue to happen. Now, when it comes to follow-on benefits or follow the joint, as they technically call it, this is the one I was referencing earlier. If someone, a person got an employment-based green card and their spouse and kids are overseas, follow to join is the benefit there. Those are already seeing massive delays, and they're just going to get more delayed. So I think I'm going to be repeating myself a lot here, but it's really important. Even in my consultations, I repeat myself a lot on this. Delay. You have to accept it mentally because it's so frustrating. I hear clients call me and they say, my friend got it done 3 months in 3 months. I'm like, maybe 5 years ago, or maybe they got lucky, but there's just delays. There's no way around it. So that's what we're seeing. It's going to continue to get worse.
Thank you so much. Thank you, John, for the detailed explanation and for taking up Mangu's question as well. Thank you, Mangu, for participating on YouTube. You can keep commenting. Let's move on to our next question, John. So this one is, what specific changes do you anticipate in the way family-sponsored visas are processed under the Trump 2.0 agenda?
Oh, great. Thank you, Shachi, for the question. If you have more specifics of what kind of family case you have, it'd be great. But you can expect processing delays on the first part of the case where we prove your relationship is real, whether it's like a family member or a marriage, being more strict on that and just delaying their review of it. And then secondly, if they're overseas, the embassy just having more and more delays just to schedule an interview for you. And those are just getting worse and worse. So for large parts of the world, unless you're from Europe or Japan or Australia, even Canada has delays. Canada takes a year to get an embassy interview for a marriage case. So it is a lot of times it's what they used to call first world countries. They're hitting them as bad too. But just the delays are going to be so bad, and them being picky about paperwork and just not paying attention to your paperwork and making mistakes, that stuff's going to get worse.
And Mangu says, thank you for the answer. By the way, you look like a Hollywood star and explain so well. That's so sweet.
Thank you so much. I get
There
that.
you
There's a Bollywood star that people always comment like, you look like this guy. I forgot his name. But everyone's like, you look like that guy from that actor from Bollywood. Yeah.
From Bollywood. Oh, wow.
I can't remember.
Is it? I don't know.
I can't remember.
But yes,
every once in a while I'll get that comment.
Oh, great. So, folks out there, maybe you can tell us who does John look like in Bollywood? Would be great to know. But yes, thank you, John, for that
explanation as well.
You're
And
welcome.
now let's take up this next one. How would a renewed focus on family immigration limits affect the wait times for applicants in the family preference categories?
Sure. The family preference categories is if a green card holder, I mean, so this could be citizens. So these are non-immediate. So preference there are the main categories, which are if you're a citizen, you're applying for a parent, spouse, or minor children. Those technically don't have additional delays. They're supposed to be fast, but they're still slow. The preference categories are preference because there's annual limitations on how many green cards could be issued in those categories. So I don't remember the exact numbers. Let's say if you're a U.S. citizen, you have a child that's over 21 and is unmarried child, there's only 40,000 of those green cards that they give out every year. And there's probably like 150,000 people asking for it. So that means it's going to be as soon as the 40,000 are done for the year, you have to wait till next October 1st to start again. And so there's backlog there. During it's just a mess. They'll intentionally find ways to not approve them, to say we just don't have the staffing for them, and just delay. And how they calculate the numbers of these visas being used is a system that they don't really let us know what's going on. So we really don't know how much the timelines are. For example, there's a preference category called F2A, spouse of a green card holder or minor child of a green card holder. Right now, for them to approve those green cards from beginning to end, it's taking 3 to 4 years. About a year ago, there was no extra delay. Then all of a sudden, one month, they announced there's a 3.5-year backlog in these cases. Like, what happened? 5 years, no backlog, then 3.5 years. And it was really bad because we didn't expect it. So we have green card holders here who had their wife and kid overseas, and they're like, well, wait 4 years. So, and the green card holder has to live in the United States and maintain their residence here. So they're not going to see their kid growing up overseas because they got to be in the U.S., work, and live their life here. They spend too much time outside. They could take away the green card if they want to bother them. So all of a sudden, families are separated, and you think they make an exception for kids and stuff like that. These are minor children, like babies. To at least, their green card holders, legit, everything, speed it up so that the family could be together. The kid could grow up with both their parents. But that's one of the difficulties we're seeing happening.
All right. Thank you so much, John, for that detailed explanation. And yes, we are going to take up questions from all you folks out there, from Ajay, from uh, Sachin as well, but a little later in the show. So please stay with us. All right. And also, you can call us on this number 425-436-6335. And when they ask for the access code, dial in 988-888 and just say hello. We'll be able to hear you. Thank you so much, John. And moving on, let's go on to our next question. And that is, what do you think would happen to the F2A category, spouses and children of green card holders under Trump 2.0 policy shift?
Yeah, so it's not clear particularly what will happen this category. This one has gotten really backed up that I spoke about a second ago, and it's been a big problem. This category, the delays are really being difficult. Now, during if the family member was in the United States, during President Obama's time, he changed the system up so it's easier for them to stay here while the case is pending. So if people are here, for example, a green card holder marries their spouse, comes on a tourist visa and decides to stay in the United States, potentially they could stay here while the process is pending. At least they could be together. But because President Obama just put that in on his own without any congressional work, this isn't publicly talked about. I probably shouldn't say, but it's a thing that President Trump and his people could just take away too, because it wasn't something by statute put in. It was just a presidential edict. This is how we're going to do it. So that could really shift. So for people that are in the United States doing it, that could be a problem. So because they'll lose the opportunity to stay here while the case is pending, being with their spouse and their kids together. And so that could be a shift. That's the easy one for them to get, and they might be looking to. But they might, what happened alternatively is all these groups would sue them on that, and it'll be stuck in the court for 2 or 3 years of fighting it. And then by that time, they'll either give up or new administration comes. So lawsuits are going to be a big thing that happened last time. People would sue, and the courts would stop everything and say, okay, don't change anything yet till we go to Supreme Court. That takes a lot of time. It also takes a lot of money. So these groups are spending millions and millions of dollars trying to support the community that's going through this process.
Well, it looks like it's just getting harder and harder in every step.
Yeah, essentially. More and more people are hiring us. That's for the immigration lawyer. I was interviewed by the New York Times during last administration, and I said it's almost like it's being an eye doctor, and you're getting a lot of business. Like, oh, my business is good, but the reason I'm getting business is because there's a crazy person poking people's eyes out, and so I prefer have this business. I prefer people would not terrified and could just live their lives, and even they don't need to knock on my door or my business door. But if it is what it is, and we're here to support people that are going through this process.
Right, right. Well, now let's take up this next one. How might the current proposals, for limiting family reunification impact U.S. citizens seeking to sponsor their relatives?
For sure. So U.S. citizens could do several kind of relative cases. As I mentioned, the parents, spouse, and minor children. The administration has been talking for years of people that are supporting Trump to get rid of the option to have parents be able to be part of the case. That requires, and everything I'm about to talk right now requires Congress to act and change everything. But yes, stopping parents of U.S. citizens from coming, brothers and sisters of U.S. citizens from coming. That's the F4 preference category. There's a backlog for that. It takes 15 to 20 years to get a green card, maybe longer for that category. But and adult children of U.S. citizens coming. So they'll say, okay, a citizen can bring their spouse and minor children, but they don't need to bring their parents. They don't need to bring brothers, sisters, or their adult children. Adult children can figure out a way on their own. That's what their goals are. And that would be something that would be negotiating in any immigration reform. That would be like the law that the Congress would change, the official law. But changing that kind of stuff is so difficult. But there's negotiations that could possible. Every day as I get older, all these things I never thought were possible are becoming possible. So I can't put it. We have AI talking to me on the computer. It sounds like a human being. We have all sorts of wars going on with technology. That's crazy. So at this point in life, I just say, this world, every day I wake up, there's something new, and I can't put anything past anything. So that's all these are possibilities, really.
Yes. Yes, and I guess we have Mangu back with the correct guess. You do look like a Ranbir Kapoor, actually.
It might
I
be
think
Ranbir
this is
Kapoor.
yes, yes, you got it right. Our team was like, you also look like Akshay Khanna, but I guess Ranbir Kapoor is the right one.
Thank you.
Well, yes. Getting back, in a scenario where family visa caps are reduced, how would it affect individuals currently in the queue waiting for a family visa?
So, it's not clear how that's actually going to happen because these people already paid money for this and it was the law. So for them to change it, it'll be kind of like there'll definitely be lawsuits against it, which would stall things. One option they would say is the people who are already in queue would get certain additional benefits in the new system. So if they change it, they'll say if they create a point system like in Canada, where like if you're a relative and you have education, you speak English, you get more points and it's faster. They may give you benefits that way. Or they may say like whoever's already in the system, you'll go in the old system, but then from today on, it's the new system where it doesn't work or something like that, and they'll just finish off what's going to happen. That's probably a more practical way of doing it, but it's going to be a problem. People are going to be suing, and it's going to be caught up in court and litigation. And so a lot of these lawyers who go to court, I don't go to court and do lawsuits myself, but those who are going to have a busy 4 years, just going to court every day, fighting this stuff out.
Right, right. And what do you have to say about, outdated rules or laws? Do you think some of these laws may be changing soon?
Some of them, if they want to, it's so hard. I mean, right now the Republicans control all the aspects of government, but even then, it's when it comes to immigration, it's not always clear cut black and white. So we might have a Republican who's for certain immigration and another one who's against it. You never really know. And one main problem is the way immigration regulations are written. Language is so technical that you have to be an immigration expert to write it the proper way. And the problem is most of the time, inevitably, these laws get written by people who don't practice immigration law and don't know all the aspects of it. So even when we've had situations where someone's anti-immigration, they wrote the regulation, the law, made it the law, and then they didn't realize how they wrote it. Actually did the opposite. It created more immigration because the language has to be so technical and you have to be so aware of it. And they just mess up. So changing anything with regards to how the laws are and this and that, it's just so hard. First of all, getting the political will and the people together to approve it. Even if it's approved, we never know how it's going to actually be until it starts coming out, because the way these things are worded and the technical legal language has certain meanings that there are certain different ways. And there's errors in them constantly. You think they would have teams of lawyers to analyze this and talk, but there isn't. And they just make things up as they go along. And as I get older, I had a professor in law school who used to say, when you're a kid, you think there's this big dad in the world that's going to take care of things and is going to fix things. And you get older, you're like, no, it's just a bunch of kids running around. They have suits on and they make money. And you think they're very sophisticated because they have PhDs, but it's just a bunch of kids running around making things up. And that's the way the world is running. and it's pretty much always been run. So there's going to be a lot of unknowns. So whatever rules change, we won't even know what the rule is until 6 months, a year go into it and realize, oh, it doesn't play out the way they thought it would, or the rule they made, it goes against another rule, so it can't even be valid in the first place. And there's another aspect that a couple of years ago, the Supreme Court, let's put it this way, in the 1980s, there was this court case that was unrelated to immigration, but the Supreme Court of the United States said that if American agency, so America passes laws based on the Congress, like the Parliament in many countries, and they have the final law. But because essentially people in Congress who pass laws are lazy and they just don't want to do much work, they'll say, we made a law that says help brothers and sisters of immigrants. And then they'll say, let the agencies, these people that the president picks in the bureaucracy, let them figure out how it actually works. And the Supreme Court said, yeah, that's fine. Just let other people who are not elected make the laws and decide what it is. Congress just kind of gets paid and just speeches, but they don't do anything really. It's just corruption, essentially. So they let this happen for 30 years and then 40 years now. And Supreme Court finally, 2 years ago, made a decision to undo this, where the agencies can't just make up the law. If it's a law, the Congress has to vote on it, and then it becomes law. They can't vote on some general statement and then see somebody else who's not elected make a decision. And this affects immigration hardcore way, because most of immigration law is agencies. They just kind of say, well, we're the agency, we say this is the law. And they wouldn't let us challenge it because they would say, oh, the agency made this rule. And based on that court decision in the 1980s, Chevron deference is what they call it. We're going to defer to what the agencies say and let them be the Congress that is making the laws. They finally, Supreme Court say, you know what, that's not right because they're not Congress. They're not supposed to be making laws. They're supposed to be carrying out the laws. But as this system has developed the last 40 years, they're making up the laws too, which is unconstitutional. It's not, we're voted, a democracy allegedly, so we got to vote for people who do it and not have these agencies make things up. And so that's going to have a massive change in the entire system of America, frankly. This is what Elon Musk and Vivek Ramaswamy of the DOJ, the Department of Government Accountability Office, or whatever they named it, are going to be using a lot, because they'll say pretty much all of America is being run on agency actions, not the law itself. So that means they could undo everything, essentially. And that's going to have major effects in the immigration system. Like, it's going to affect environmental laws. It's going to affect all these kind of stuff. And immigration, it's been kind of a unique point that a lot of immigration lawyers are frustrated because the agencies, USCIS, and they just mix up stuff. And you're like, wait, that's not the law. And they fight us on it. But we're going to see what happens. It's Wild West. Anything's possible in the next 4 years with all these changes.
Absolutely. And friends, I'm sure you are also, you probably need professional help with regard to your immigration case. And why not contact attorney John Khosravi himself? You can even call him up on his number, 818-934-1561. Otherwise, you can email him. His email address is info@jqqlaw.com. And you can go visit www.jqqlaw.com to get to know more about him and his firm. Well, thank you so much, John. So far, so good. We also have Willie Haggins on Facebook. We are going to address your. Okay, let's take it up. So, John, how may this impact someone already in the U.S. with active status who may be getting married soon and planning to file I-130 and I-485 to adjust status?
Well, thanks for the question. This is the main type of case our office works on. I love helping people in this situation. One thing that'll happen right now is you have to do a medical checkup before you file the case. That's an update they just did last Monday. And you still have to get a COVID booster shot. We're realizing now they keep updating the medicals without even telling us. But I just found out this week that you have to keep getting COVID shots, vaccines. But it depends on if your spouse is a U.S. citizen or green card holder. That's going to affect the filing and how that works out. So, Willie, if you can, let me know if the person you're marrying is a U.S. citizen or green card holder. But what you could expect under Trump administration is to finish off what he tried to do last time, which is a portion where they want to make sure the person coming here is not going to become a public charge. That means the government doesn't have to take care of them. They can support themselves. So they're going to go hardcore into your credit history. They're going to go hardcore into your education. They'll want language exams to show you speak English to the extent that level that they want. They're going to go into your finances, your debts, all this kind of stuff. And most people will be able to still get the green card, but it's going to create tons of work, essentially doubles the work that we do. And it was one of the worst parts of last administration, filling out this doubling the casework. And, there are people here who have to get credit reports, but they have no security numbers, no credit history. So we have to figure out how we could ask credit reporting agencies to even give a credit report to somebody. And that would take so many hours, and it causes more expenses and everything as well. So Woolley replies saying, spouse U.S. citizen, if you're planning on getting married and things are close, just get married now. File it, contact their office for a consultation. But it's the number one thing we know was delays I spoke about earlier. Secondly, interviews happening. There have been waiving interviews for the last 4 years. You'll probably have to do an interview. And third, if you don't get the case in time, you're going to have probably more hardcore background checks when it comes to public charge, financial issues, which you'll probably still pass. But it's just going to create so much more paperwork, headache, and delay and be able to get your case in. And the more paperwork there is, the more chances that something's going to be missed, or the government's going to make a mistake, or just problems come because just more to deal with. And I had a consultation the other week with somebody who got their green card like in 1990, 30 years ago. I'm getting old, and these years things seem so far away. And we did what's called the Freedom of Information Act request, a FOIA request. We asked the government for a copy of the person's file. They wanted to get citizenship. And I'm like, let me get a copy of your whole immigration file to see what happened in the past if you filed your paperwork correctly. And we got it back in just one application from I-485 adjustment of status that's for applying for a green card. Back then was 4 pages. Right now it's over 20 pages, and it's probably going to be 25 pages next year. So it's just, it had like 10 questions about your background. Right now we have 90 questions about your background on the form. It's just, they keep adding, maybe it was 105 or something like that now. So it's just, the more you delay, the more questions they're going to ask, which leads more errors happening and more things that it just makes it difficult. It just makes it difficult. So when you have a good case, if you have no criminal history, your finances are good, your relationship is real, you want to just get it in sooner rather than later, because in these kind of cases, waiting longer is just going to create more problems for yourself.
Absolutely, yes. Thank you so much for addressing that to John. And folks out there, it's really important to stay updated because there are updates every now and then, just like John mentioned about about medical reports, right? I mean, updated.
Yeah, out there, because when you get a green card, you have to file, you have to do a medical checkup to make sure you don't have tuberculosis, gonorrhea, or syphilis, and make sure you don't have any mental health disorders, you don't have any drug abuse issues, and you have to get a list of vaccines. And these vaccines, like especially with COVID, you think that if you got the initial one, you're fine, but now they're saying, no, you have to still get an updated booster shot still in 2004, coming in 2005, where really the whole situation is not on anyone's radar. And it's hard to tell a couple, you have to get these vaccines, who knows who's making them or what's in them, what in the world's going on with these things. Essentially, we don't need it. If it was pandemic, still, okay, I'd be scared. Okay, let's do it. But at this point, forcing people to get this, and one of my clients said the doctor's charging $200 extra for it. And it's like, well, $20. We have to work to make this money just to get some vaccine that doesn't make a difference. So it's just annoying, and it brings the costs up. And people, the economy is all over the place. If you're making money in foreign currency, $200 is a lot of money. Even in the U.S., a lot of money, but let alone if you got to translate the money and bring it from overseas. It's just, and this is during the Biden administration. This isn't even a Trump thing. This is a Biden administration thing. So it just, it's sad, and just it's sad to have to tell people this stuff, that they're just being annoying about it. That they're not being easygoing. It's very annoying, obnoxious. The best way to put it at least.
Yes, so much to do just to get your permission for the visa, the green card for that. Yes. Let's go on, John. Now, my next question to you is: if the new administration pushes for stricter public charge rules, how might that complicate the process for families applying for visas or green cards?
Yeah, that's going to be a big problem because a lot of people, not making enough money. And right now, the standards for the income aren't too high. For example, if you're a person who's married, no kids, no dependents, or something like that, to bring the spouse, I think it's like 27,000-ish you have to make. Some people make much more than that, but some people barely make that amount of money, so it's hard. But the other end of the public charges, what I spoke about earlier, is not only will they look at the U.S. citizen's income or the green card holder's income, they're going to look at the ability of the foreign national to make money in the United States. And sometimes you might have somebody who's 18, just out of high school, who got married. They don't have any education history. Their language skills might not be that good. They don't have any particular skills or certificates. And how strict they're going to be. Because last time Trump came and they made these rules more strict, they said we want to see all this, but they never create a standard. So it's like, what is the line? How can I tell my clients you're good or not good? They're saying, we're going to ask for this, then feel it out. And I'm like, what kind of laws is this? It's feelings. It's like, One person may get approved with nothing, and one person has everything get denied. And so that's going to lead to lawsuits because of the inconsistency of how they'll deal with that, which creates another problem. I talk about the agencies have discretion too, even despite that Supreme Court rule that I said. The Immigration Department has discretion to make decisions with who they think is good to come to the U.S. is not. At the end of the day, they have a background. Essentially they can do whatever they want. So usually they're not as strict and they're cool with it and everything. But especially if you're dealing with the U.S. Embassy, those people have all the power in the world. If you're doing your case in the U.S. with USCIS adjustment of status, getting a green card, even a work visa, because you're here, you have extra laws and lawsuits you could do. But if the person at the embassy says something based on the fact that 100, 200 years ago, every country had embassies overseas, but there's no communication ability because everything was far away. So they put the rule back then where they say if you go to the embassy or a consulate and officer there is making a decision, just let them do what they want to do because we don't have the ability to check what they're doing. So we give them all the power, just make the decision that you want to do. Fast forward 150, 200 years later, they still have this policy called consular non-reviewability, and Supreme Court said it's okay. So they said, if consulates make a decision, we're not going to review what they're saying. So even if they make mistakes, which they do pretty frequently about the law, about the person, they'll say, well, consular non-reviewability, we'll have to do what they want to do. So it's a big, major disaster if you're going through consular processing and you're outside the United States because you never know until you get the green card in your hand. You don't know what in the world's going to go on with it. Whereas in the U.S., if you're doing it here inside the U.S., if they make these major mistakes, we could sue, we could complain, we could show up at the office and say something of a worst case scenario. But that's going to be a big issue about how they're going to handle that.
All right. Thank you so much, John, for taking that up, for addressing this issue as well. And we have Willie saying thank you for addressing replying to Willie Haggins himself. And we also have ZQ with a question. So, Mr. Khosravi, is it going to get better under the Trump administration by removing these unnecessary tests and vaccines, even after one is vaccinated?
I highly doubt that. We have RFK, that was the nephew of President Kennedy, who was assassinated, and son of the former Attorney General, was assassinated as well. And he's famous for being somewhat skeptical of a lot of the vaccines. And you think that would come on here, but I don't know. This the vaccine situation is based on the CDC mandates and things that the Center for Disease Control in the U.S. and the health agencies, which he's going to oversee if he's if RFK Jr. is going to be in that position. I don't know if they're going to be getting into the immigration aspect too much. Maybe maybe depends on what RFK Jr. is going to do. He's going to actually be the person inevitably in charge of hiring who's the people who are going to make the decision are. And so potentially they'll say, immigrants maybe don't need to get boosters at this point. We shouldn't make that requirement. That's really depends if he gets elected and if he wants to use his time to focus on the immigrants as opposed to other communities. But that's maybe a bright spot in there to kind of ease up on all these vaccines. There's 10 or 12 vaccines you got to get. A lot of times people have the vaccines already. Sometimes the doctors say you don't need it, but there's a lot.
Yes, that's a lot. Just to immigrate to the U.S., right?
Yeah. And my client the other day, he's like, I got 2 on his shot, 2 on this elbow, and they're all swollen. He's like, we have to get the booster, but I can't really take it. My hands hurt. My arms hurt too much. So I'm like, okay, wait till Monday to see if you feel better, if you get the booster. If not, we'll figure something out to do it later somehow.
Whoa, you can only imagine. $200 for a booster shot. That bites. Ouch. And imagine how many? 13. Well, thank you so much, John, for taking that up for ZQ. And ZQ, thank you for your questions. Let's move on now to our next. So how could a potential Trump 2.0 policy shift affect applicants who are facing delays in consular processing for family-based visas abroad?
Yeah, it's going to make it worse. One thing that happens is when a lot of times people are facing delays in getting an interview, even though they should be getting an interview, or after they had an interview, the government just doesn't make a decision. 3 months, 6 months, a year, 2 years go by, they don't make a decision. What has become mainstream now is to sue the government for the delay once this is happening too much. Probably more than half the time, the government, once they get a lawsuit, they don't feel like dealing with this, so they just give in and issue the visa or do the interview. But we're seeing more and more judges, especially judges in Washington, D.C., denying these cases, saying embassy, that's up to them. They want to do what they want to do. And potentially the Trump administration's lawyers will fight this more and say, well, these delays are necessary and it is what it is. We're going to do it. So we're going to have to see, but potentially they might fight the lawyers who are suing the government delays much harder. And when they fight him, increases the cost because they got to go to court, this and that. A lot of times right now, the government just gives up, it gives in, and just says, okay, we'll schedule the interview or give the visa. So the lawsuit is just the first step of lawsuit. But if they want to go and litigate it, fight it out, that's just going to hit fees. So it comes like a very expensive filing fee for families. So it really hits disproportionately people who are lower income, and those with a lot of money could pay for it, but they're out $5, $10, $20,000 on litigation, and it's not clear which way it's going to go. It's a lot of money just to be able to get an interview or get a visa issue that's going to be issued anyways.
Right, right. Thank you so much, John, for the detailed explanation. I think we should address some of our questions from our audience. Let's take up Ajay's question. I've been hearing a lot about potential changes to family visa policies under the next administration. In your opinion, what do you think will be the most significant impact on individuals trying to bring family members into the US? I think we've been talking a lot about this, but yes, a few more points.
The delays that'd be one. One thing I forgot to mention are the potential travel bans because we have an international audience here. Last time around, now this is kind of controversial, and then a lot of my colleagues don't agree with me, but Trump instituted what's commonly known as a Muslim ban because there's a lot of people from Muslim majority countries. But in practice, that list of countries who were part of the so-called Muslim ban were created under the Obama administration for a different situation. If someone had visited this list of 7 or so countries, they wouldn't be able to use what's called the visa waiver program. So if you're German, you could just come visit the United States with what's called a visa waiver for 90 days. But if you visited Iran or Iraq or something like that, or Syria, you have to apply for a full tourist visa. So they could ask you why you went to these countries and check you out first. And so that list was created during Obama administration. President Trump just made that list part of the travel ban. But when you look at it, the Muslim majority countries in the world, whether it's Saudi Arabia, Lebanon, these are the countries that are associated with the 9/11 terror attacks, Pakistan, Indonesia, these are the majority Muslim countries. They were not on the list. It was primarily a list of Iran and its colleagues, and essentially in the Cold War that we have between the U.S. and its allies, and Iran and its allies. And you can probably throw Russia in on that too now. So it is really more of a strategic defense maneuver that doesn't really, to my opinion, it wasn't based on Islam. A lot of my colleagues don't agree, and they sued saying it's discrimination. But I think it was a strategic thing against certain countries that potentially are rivals to the United States. But that's going to probably be instituted very quickly, and they have full right to do that. The courts have said that, and they can add people. So on the one thing that is, President Trump first created a travel ban on certain countries like Iran, and then he increased it and added countries like Nigeria, for example, which has a lot of Muslim people as well. And the requirement, one of the main requirements, is that these countries share their information that they have on people with the United States databases. So essentially, you open up the books and make yourself a vassal of the United States. Say, here's my books, and it are people. So it is an issue of sovereignty and stuff. But putting that the political science stuff aside, Nigeria opened its books and they got back on the list. Now, if you are going to go through visa processing in Nigeria, Kenya, you might be experiencing 3-4 years of wait time just to get an interview. Same with Pakistan or Iran too. A little bit less than those. Those are terrible in Nigeria and Kenya and a lot of parts of Africa. But the delays are out of control, and they're just probably going to get worse and out of control, like years. And just to get an MC interview, once everything is almost at the end of the line, you're almost at the finish line. So bans and delays, that's what's going to be happening for all cases, really.
Right, right. Thank you for addressing that. Yes, that was another important thing to keep in mind, travel ban from various countries, Muslim countries especially. So, folks out there, you can also join us on call. You can call us on this number 425-436-6335 and dial in this access code 988-888 and just say hello. We'll be able to hear you. I mean, you can just join this discussion. Thank you so much, John. Now, moving on, let's take up Sachin's question. With the possibility of policy changes under Trump 2.0, how likely is it that my family's immigration process could be delayed or complicated? Are there any steps we can take to prepare for this?
Well, I got to see what particular kind of cases that you have, what kind of family cases it, what are the relationships, how many family members, their ages. One thing that's going to pop up with these delays, which is a problem potentially, is people who have kids that are nearing the age of 21. So for a lot of cases, if you're getting a green card and you have a child that's under 21, they could get a green card with you as part of the case. Depends on what kind of case you have, but most of them. but the kid starts going over the age of 21, they could fall out of that case. Now, there's regulations that help potentially, a couple of years, 22, 23, 24, you're a little bit older, you still stay in the case. But if certain delays happen or the government messes up the systems, makes it hard to function, to find out how to do, especially if you don't have an immigration lawyer, finding out how to lock in the kid's age in different ways is very complicated. I've done videos on YouTube explaining it, but it's very complicated. And for most people, they can't figure it out. So what happens is you got to spend a bunch of money hiring a lawyer, essentially, and hire a good lawyer that knows what they're doing and is going to pay attention to you, as opposed to get some money and disappears. That's a major problem too. Putting aside the Trump administration, finding good help when it comes to doctors, lawyers, plumbers, whatever it is in life, more and more I'm seeing it's hard. It's hard because people are too busy with their own lives. They don't care about their work or the people they're working with. They'll get the money and run. So finding good help to guide you through it, and the cost of it is going to be a major problem. If there is even something that could be helpful, that could help this kind of stuff. So doing your own research, studying, and be able to judge. If you talk with a lawyer, you really always should. It's hard. It's annoying and it's potentially costly. Talk with 5 different lawyers. What you'll see is if you talk with 4 immigration lawyers, you're going to get 5 different answers. And half the answers will be the opposite of what the other lawyer said. Now, how is that possible? It's a mess, but it's possible. So you got to be able to talk with those people, have discernment to see, are they making sense or not? But before any of that, go and study, watch these videos, come to these Q&As, ask your questions. So when you go to the actual lawyer to talk with them, you have good questions to ask. You don't waste your time on simple answers or something like that. And you can tell this person knows what they're talking about, if they're being honest or not. You got to do your homework to protect yourself. Even if you hire a lawyer, you're paying all the money, you think you just hand it off to them. Nothing in life. You got to keep your hands into it. You can't rely on other people. This is such an important thing in your life. You can't just take one person's. You got to get a different opinion, study for yourself, and be ready to fight it out and be prepared.
Absolutely, 100% agreed. So do your research, friends, and absolutely get help from an expert and an immigration lawyer, that is, and do your research properly. And yes, you can also contact Attorney John Khosravi himself. You can call him on his number and even email him. And his number is
So it's 818-934-1561. Now, it'll be an answering service. You give your info. Probably the simplest way for you to do it is just go to our website, jqqlaw.com/contact. Put your name in there. Briefly describe, your situation, because we don't do every case. We don't do asylum, for example. If you tell me you're doing an asylum case, I'll say, no, I just can't help you. But if it's something we do, I'll reply back with information on scheduled consultation. We do have consultation fees, and we decrease it for certain cases to make it easier on people. So we always want to know what is the case, so you see if we give a lower fee if possible, and we'll respond to you within 24 hours and get you on the way of what you need to do.
Yes, and please don't forget to let him know that you are joining him from Immigration and Jobs Talk Show. Just to
Yeah, I
know.
would love it.
Yes, for sure. And Sachin, if you have more details about yourself and your family, it would be great so that maybe John can give you better answers as well. Thank you, John, for addressing that. We have more questions. Let's take up a few from our Facebook groups, if you don't mind.
Sure.
But before we move on, I think we can address one more. So what changes, if any, could be expected for US citizens sponsoring parents or adult children for green cards in the event of stricter family visa policies, John?
Yeah, so the income requirement for the U.S. citizens to have more ability to show, because that's a flexible one I work always push against. Back in 1880, there were a lot of Chinese people coming to the United States. The numbers were less than from Europe, but there was a lot of discrimination happening against the Chinese people coming here. So they started the first public charge rules that say if you're coming in and we don't know if you're going to be able to afford to live here, what's going on, we're not going to let you come in. And the law is in the statute, the Immigration and Nationality Act. It's very vague and open-ended about what they could do about that issue. Currently, what you have to do is just show you make a bare minimum amount of income, and that's enough, and it's really easy to get through. There are issues if you've been in the United States and you get long-term institutional care. For example, you didn't have status, but you're getting health care long-term. You have a disability that requires, nonstop medical attention. They won't give you a green card because it's going to be too expensive. But most people are not in that situation. But that regulation is very vague, so they could up the ante and make it more difficult if they want to. And so they're probably going to do that to show that the U.S. citizen makes more money, and also the foreign person to support themselves here is not going to be a public charge. That's definitely something that they could easily, just turn the knob on and switch it off. And that's something that we can see happening for people in that situation. It's still a lot of people could get it past it, but the paperwork becomes tremendous after that point. And for people doing the case on their own, that's when a lot of problems happen because they can mess up. They don't understand the forms. It's badly written. The rules are badly written. And so the thing is, if they change these rules, no one even has experience on it. So even the lawyers are doing it for the first time. And the government's doing it the first time. So they'll make up a new form for this stuff. We'll send it in. And because the government officers, it's the first time they're seeing it, they'll make mistakes. They'll read it differently than we read it. And there'll be lawsuits. So it becomes a mess. It's like a complete unknown of what's going to happen. It's going to be difficult. That's the easiest way to say it. But the simplest way to say it, it's going to be difficult. So you got to be prepared. Make more money, get more education. That's going to help. But inevitably, just talk with experienced people and just be mentally prepared for what's that the thing's going to go difficult, and that kind of sets a tone so you don't get your hopes up, you get too excited thinking you're having fast. And be careful for people that give false promises. There's a lot of people that lawyers that just tell you, yeah, we'll get your case in a week, we'll get it approved in a week. They'll tell you like things are too good to be true. You got to be skeptical. There's a lot of people act like lawyers online or on WhatsApp groups to say, hey, pay me extra $2,000. I'll have somebody, I'll hook it up. Don't trust these people. Talk to different people, get different opinions. I was doing a consultation yesterday, and the person, it was a marriage green card case. And I was a third lawyer they spoke with, and they're saying everything I said was the exact opposite of what the other two lawyers said. Well, I'm like, well, here's my proof. My Instagram page, here are my approval notices I put there that show the timelines we have. And I cited the statute. This is what the law says. So, I put in the email I sent to them. I go and tell those lawyers and get a different opinion. If you think I'm wrong, this is what the statute says. This is what the regulations say. This is my approval notices. I block out the people's names in the case numbers, but I have the proof out that what was happening. So if some people are saying differently, I don't know, maybe, the government's crazy. They do opposite things at the same time. So maybe they had different experiences. But from my experience and what the law says, this is how it is. So you got to, talk to different people and get, get the real proof and evidence and feel comfortable with who you're going to be working with.
So, John, would you suggest, waiting for a couple of months maybe for these changes to get settled and for folks, dealing with these kinds of changes, get familiar with the changes? Would you suggest
no, if
them
you got a
waiting?
good case, do it as soon as possible before they have the chance to make these changes. A lot of times when the government makes these changes, they have to announce it and give at least 60 to 90 days for people to have time to adjust to it. And so if you have a case, get it as soon as possible. We're inundated with work this month, December, because everyone wants to get their case in before January and when President Trump comes in. So we're slammed, and we're probably not going to take a break for the end of the year because we're just going to be filing stuff before that happens, because the day he comes to the office, there'll be different bans, there'll be different issues, there'll be this and that happening. People are going to quit in the government, so it's going to slow down. There's all sorts of problems that are going to happen. So if you have a good case that's solid, sooner you don't put it off. We have people who have been married for 20 years, could get a green card. They're living in the U.S. without permission, without status, but they could fix it, but they're just putting it off. Just now calling me and saying, oh, Trump's coming back, I want to fix it now. I'm like, well, you've been doing it for 20 years. You could have got it 20 years ago. You start now, but there's a lot of people like this. They got to get off the chair and in the car and or get up the phone to figure this out. Just to live in peace, not have to deal with this stuff, live above board. So a lot of it now starts to happen. People a lot of times have problems they're not even aware of. They made mistakes in the history that they didn't even know was a problem that an immigration lawyer would be able to understand. So talk with a couple of qualified people. You get a feeling for who you trust and who seems most competent.
Right. Thank you, John, for taking that up and for
You're
the detailed
welcome.
explanation.
You got it.
Let's go now with our Facebook question. So this is from Khosravi. Willing to relocate from current country to USA family-based immigration program for advanced degree and exceptional abilities. We are okay.
So this is the
I
kind of thing
think
you got to be careful of. When people say this kind of stuff, this is exactly the kind of thing you see online. And they post this and people, fall prey for it. This person, we don't know who they are. They're going to get, they're making up a case probably. They're saying we do the forms and stuff like that. Okay, like, did you ask, this is an immigration lawyer, a lawyer in general in the United States is not allowed to solicit and say, hey, come and I'll I can say we do this work, but they got to be careful how they word it. So if some random person tells you like this, you got to be very careful. So I'm glad you brought it up so people see this is not something
yes,
you should respond. There's,
all for it.
there's a lot of lawyers. They should be very careful of this kind of stuff.
Yes, thank you so much. Thank you so much. Let's go on with Ankita's question now. Hi, I'm single. I'm a single mother and have recently got my permanent residency through family-based immigration. I'm originally from Fiji. I went to USA for 3 months and now I'm back in Fiji and waiting for my daughter's visa. I filed for a I-130 petition for alien relative for my 2-year-old daughter. I just wanted to know approximately how long will it take for her visa to get approved?
Thank you.
So that's a big problem there, because if you go by the way you just did it, it's going to take 3 to 5 years. It's going to be pretty bad. And you might lose your green card by not living in the United States because you want to be with your child. Now, we'd have to have a consultation because you have to know how you got your family-based green card anyways, because your child should have been part of that case in most instances. So there's a major problem, a major error that happened in your case, that your child was not part of it, because they could have got a visa some way or another, expediters based on the original case. So the fact that your child was not included in your case seems like 90% there's a major problem, a major error happened in your case. And now if you don't fix it in time, or if it's not fixable, you're stuck. It's taking 3 to 5 years for the F2A preference category on what you're dealing with. And since you're a green card holder, you have to be living in the United States. These absences, although they'll probably be lenient about it, but the more you're absent, it's going to delay getting citizenship in the U.S. But more importantly, next time you come in, if it's long enough absences, at the border, they might try to take your green card away, and that'll cancel out the daughter's case. So this is 100% the kind of case you want to have a good immigration lawyer talking with, at least a consultation to figure out what happened that your child doesn't have a green card already or is not already in line for a visa, instead of you having to file an I-130, which is the last thing you want to do with the current delays they have. Plus, it adds doubles. I mean, you just added a bunch of costs and expenses that weren't needed potentially. So, I mean, in the thousands of dollars. So, you definitely should consult with a couple of attorneys to figure out what happened, have a copy of your file and what you did, so we can figure out what went wrong there, because that doesn't seem right that you needed to do that.
Right. Thank you so much, John, for taking that up for Ankita. Let's go on to our next one. Control, if you could display. This is from an anonymous participant. Hey, my boyfriend waited until way past the expiration date to try and renew his work authorization in DACA. Would applying for asylum be a good move? He came to the States when he was a baby and doesn't know any family from where he's from. Please help.
Well, that's a big problem. DACA was a special program that President Trump, Obama did to help people who came as kids to be able to live here and work here. And you have to renew it. If you didn't, it's a major mess up. You could try reapplying late if it's less than a year. Sometimes they say they may approve it as a discretionary matter, so that'd be one thing to do. But if you're dating and you have a serious relationship, potentially looking to getting married, if your boyfriend entered the U.S. lawfully and you're a U.S. citizen, potentially that could solve things. They'll just get a green card. If again, marriage is in the plans, it's a legit marriage. If not, they may need what's called a waiver, a 601A waiver. If they had DACA and they entered without permission and they had DACA, they could have got a special travel permission that would fix a lot of things up called advanced parole. But this kind of scenario, I wish they had a lawyer they talk with, a family lawyer, someone in there that they could tell this stuff to. It could have saved you a lot of headache and saved your life from issues that's going to happen. So then I would just consider consulting, schedule a consultation time, thoroughly talk to an attorney, know exactly what happened, and know all your options. Asylum is a problem because you should be able to file for asylum within a year of entering. They have exceptions where if you file asylum later, but it's a complicated case. There's backlogs. It could take 3 months to get the case decision. It could take 10 years. And it's an expensive, complicated process. You have to have a valid asylum claim. And so I don't even know if there's a valid asylum claim there. And we don't do asylum, so we don't consult on that. But these are exactly the scenarios. Now, immigration lawyers, some have consultation fees. We do. It's pretty expensive. Some don't. So first, contact people, 2 or 3 people who do free consultations, see if they're worth it or what kind of guidance they give. Then save up money and talk with 2 people who do charge. Compare those 5 people. Spend the time on it. It's your life. And your boyfriend's life is your future. It's worth the investment to get down to business and see what's going on to help save yourselves.
Thank you, John, for addressing this one as well. Let's go on to our next one. We have a couple more minutes. Yes, this is from Maheen. We are a British family currently living in London and want to migrate to US. My husband is IT consultant, works with big firms here, making good money. My husband wants to look for jobs in US now, so we can be close to the family as both of our families reside in the US. Please suggest which visa category is best for us other than H1 as it requires job offer and lottery system, which is not guaranteed. Any other visa category we can apply so that he can get working rights in the USA and start applying for IT jobs there. Yes, any UK based. Okay, forget it.
Yeah. So in the UK, so there are immigration lawyers in the UK, are friends of mine that could potentially help as well. The H-1B problem, yeah, it's a lottery. It's a limited number of people who get those work visas. You have to have an employer. The EB-2 and EB-3 green cards normally require employers as well. There's an exception called the national interest waiver, EB-2, which is if your work is in the national interest of the United States and you're very successful, you get a green card based on that. Depends on your background. Now, there is an E2 visa option, as you kind of referenced there, that the listener referenced there. That's an investor visa. If you start a small business in the United States or buy a small business, you come here and run it if you're from certain countries. And UK is one of, if you have a UK passport. So that may be something to look into, especially the spouse of the E2 investor gets a full work permit, can work wherever they want. So maybe one partner, husband or wife or whatever partner, takes their money, invests in a small business, and their spouse gets an unlimited work permit. They can work wherever they want. And as long as that business is operating, making money and growing and everything, you stay in the United States with your family members under 21, your children under 21, and your spouse. So that may be an option, but you got to look into investments, starting a business. It's not a small affair. It's your life savings potentially. You want to make a right choice on that. But that may be an option for a UK citizen to open it up to come over here and take their life to the next level.
Thank you so much, John, for addressing that for Maheen. Now let's go on to our last question from Facebook, if that's fine. This is from an anonymous participant. Control, if you can display it, please.
Okay, so
All right, so I guess we are done then. Thank you so much for that, for addressing all of those Facebook questions and questions from our audience. And I think it's now time to almost wrap up our show, John. So, what would you like to say to our folks out there as an end note on this discussion today?
I'd say thank you for listening. The first step is to get the education, knowledge of what's going on, and just being open to it. Many times people will have the cases destroyed, and then they start calling me, asking up. I'm like, well, if you called me yesterday, I could have done something, but at this point, it's too late. So if you're listening to this, is the first thing is seeking and to have understanding and seeking wisdom, and that's the number one thing in life and outside of immigration you got to do to have a better life. Seek wisdom and understanding, and this is a part of the process, and continue it for your future well-being, especially if you're in this field that you're trying to go on the immigration side. So I really appreciate it that you're watching this, and definitely reach out to, if you want to reach out to us, our contact information, jklaw.com/contact is there. But keep studying. YouTube is wonderful. Has all these videos. Now, note that there's a lot of immigration lawyers that I know say wrong stuff on YouTube. Who knows? I may be saying some wrong stuff too. You got to do your homework, talk to different people, and get down to the bottom of it to make the best decision for you and your family.
Absolutely. Thank you so much, John. It was really enlightening, the session. We learned so much. I'm sure all the viewers out there also gained a wealth of knowledge really today joining us here. And thank you so much for doing this, really.
I appreciate it. Thank you for having me on.
I'm really looking forward to have you join us again, maybe in the coming week or the coming weeks. And also, we have our show, Daily Immigration Dose, folks out there, 4 p.m. Eastern Time. So if you can join, and maybe even John, if you can join, it would be great. It's a an open discussion. Anyone can join. So anyone, if you're free, please feel free to join. But thank you so much, John, otherwise, for doing this today. It was really great having you.
I appreciate that. I wish you the best.
Have a great day. Bye-bye.
Thanks so much. Bye-bye.
Thank you, folks, for joining us today on YouTube, LinkedIn, Facebook, or Twitter, or X. Thank you so much for your questions, and I hope that you enjoyed this discussion. Please do not forget to like, share, and subscribe to our channel, especially if you resonated. Don't forget to like this content, and of course, don't forget to also contact Attorney John Khosravi and go check him out at www.jqqlaw.com, and you can even call him up on his number 818-934-1561, and his email address is info@jqqlaw.com. Thank you, folks, for joining, and stay tuned on Immigration and Jobs Talk Show, because we are going to be back with more. And yes, 4 p.m., we are going to join you with Daily Immigration Dose. So stay tuned. Bye-bye for now.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic: EB2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
Happy to be here. Thank you for the invite, and we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Dos Rodriguez PLLC and brings 13 years of stellar experience to the table. He's represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB2 NIW visas. Yes, EB2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. You know, while I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you. But Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, listen, there's 3 people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All 3 of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for like the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB2 NIW. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in, maybe as kind of I don't know, retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB2 NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified. And I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB2 NIWs because it's been a rough year. And that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section, and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question, but I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM and cases where we can make a really good argument that in addressing a very specific national interest for the United States. All right.
Philip, what about you? Because, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB2 NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB2 NIW petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB2 NIW under the New York State Department of Transportation, and that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB2 NIW now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology, which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB2 NIW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? these are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB2 and IW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye. And I think it's going to influence them. Yes. I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. It's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the U.S. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times, the wait times for India specifically are very long. So why do you think that happens? If Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. Mm-hmm. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression of decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah, so that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the U.S. lawfully, keep you working. Let's look for other options, because the EB-2 visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB-2
Okay, and Ram, okay, so now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB-2 is still going to be that golden ticket, you know, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H-1B program, the CAP H-1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H-1B over to EB-2 and I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H-1B, because people have been gaming the H-1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB-2 EB-2 is definitely the golden ticket. I mean, same with EB-1, but you got to have a good package, you got to have a good plan, and you have to be qualified. It's not the golden ticket for everybody. We usually can knock out the first part relatively easy, to the EB-2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB-2 NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away, because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4, because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal, to the substantial merit piece, and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. Before, well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client still, we do that to, and try to file as quick as we can to, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, golden visas like Dubai or maybe, other countries. They offer golden visas, right? So maybe US can also come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB2 NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? And has been since, what'd you say,
2016.
So that standard hasn't changed. The way they implement the standard, that's changed. Couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled, garble, repeat boilerplate clauses just that maybe don't even apply to the same case or the same subject matter. That's a problem. We also saw the recent article did. They've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB2 NIWs, but by the RFEs we've received, it wouldn't shock me, because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say, of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you maybe it's not such a good idea to file premium processing, because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing, but again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only, I mean, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, I mean, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? A lot of people don't respond to the RFE on time, or it's much more work or much more cost. So they just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, like, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay. As they say, nothing comes easy, and especially, if it is something really good. So I think those EB2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Robin Phillip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We have had any number of applications, but also the EB2 NIW. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB2 NIW petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the U.S. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB2 NIW, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so. And we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, I mean, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So if you can please tell us about that too.
Yeah, I mean, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. I mean, really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And I mean, new cases come out every day. Every week you get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security scrutiny during Trump's first term. So do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history, and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months, they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer and I've got a great there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, I hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term contributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Raji, is that we've kind of taken a tact on our EB2 and IW cases, treating them almost as if they're EB5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB5 world, implement that into our EB2 and IW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon. So I really hope that, he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Raji. Believe me, I was inside the belly. That could be helpful to us in our interest in your clients. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you. But what about the applicants? In the fields outside STEMs, like maybe arts or social sciences. How can they stand in their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB-5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB-2 petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB-2 petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's a major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, yeah. Sciences, yeah. So you got to think about how you're going to tie what would otherwise be, hey, this is just a great artist, this will improve our culture. If it was me, I would say, yeah, we're going to do that. But they're also, like, I'm just making this up, we're also going to help all the veterans with PTSD because we're going to go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian. And he says, hello from Brazil. And he says, this rule is not God or good. I'm not sure what he means by that. But Okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB2 NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Well, like we said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating, not just your cases, not just Rob and Philip's cases, but the whole nation of cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah. We've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB2 NIW is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. Mm-hmm. And so if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay, thank you so much for that great answer, Rob and Philip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, colleagues or people highly positioned within the government, business or academic sectors, as high up as they can, but they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they're from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I had a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, yeah. I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He is completely against it, right, Rob? Especially with the EW20 visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. Mm-hmm. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Raji's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards. And no longer because you are applying and because you are in the wait lines, you'll be able to get the green cards. Only you are skillful, and if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I mean, I just read an article, it was a Politico, right?
Mhm.
Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM. And sorry, I got a little off track. What was the question? Rajni, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But I was saying, actually, is that the reason why actually Trump endorsed, the skills,
More of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah, so the article was saying, look, Trump is an Indian national's best friend because they have the skills, they have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or, irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
Yeah, and the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is, at least under the administration. Is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. But then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, complete against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Robin, Philip, I mean, I know that's a conversation for...
Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for this is actually for an H4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their. If you want to speak generalities, it's fine, but maybe this one's not the greatest one. Yeah.
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB2 and IW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
Well, I'll start. So sure, as far as the new cases, and so the biggest case that we've seen come out with EB2 NIW is the matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, U.S. New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB2 and IW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB2 qualification part, you may have a case to go forward. But the NIW piece itself, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in the adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consular decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting administrative, the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us. So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your.
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB2 and IW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB2 and IW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what DataSAR has done is it's created a clearer path to the EB2 and IW visa.
If there's one thing I can add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number for the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer. But that's not the biggest issue. The biggest issue is it's got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in India at the embassies or consulates there, but in general, I think they're taking low priority on scheduling interviews versus the relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them.
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB2 and IW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they can do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable, like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S., thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB3 and IW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB3 NIW.
EB3. EB3. Yeah, we assume she meant. I'm going to assume she means EB2 and IW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB2 NIW. However, what we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We'd have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest. So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you could easily weave that into a strong national interest argument. Because of the just like Philip said, the segment of our country right now of the Latino segment is humongous. Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and I that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And we are also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. Rob Melvin at melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. 1325. You can also email him. His email ID is Philip, PHILIP at dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa. And she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB-2NIW visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamer says, does the premium processing affects the approval percent in the EB2? What do you have to say?
Back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB-2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks. And what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down to that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, "Yay, I'm so glad I chose premium processing because it was so wonderful, and it was so beneficial to me. Not once.
Mm-hmm. But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE, they panic and go into that chaotic zone and chaotic mode. So, but RFEs can sometimes also be helpful for their cases, right? So, in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come, just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is, in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB2 NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode. Or maybe we can get in touch with them, write to them, and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I am Rajni Bharara, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
All right.
Bye.
Good afternoon, everyone. Thank you so much for joining us. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be your host for today. And it's lovely being here. So, sorry, it's not just good afternoon. It may be good morning or good evening. So, thank you so much wherever you've joined us from whichever time zone. So, welcome to Immigration and Jobs Talk Show, and I'm really happy to be here. We are streaming live right now on YouTube, LinkedIn, Facebook, and X. And I'm really glad that you have joined us. And before we proceed with today's webinar, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, yes, and you can also participate, by the way, in this session, friends, by commenting whatever questions you have, especially with regard to today's topic of discussion. And that is Trump's new team, a fresh start or a nightmare for immigrants. I'm sure all of you folks have many questions and are probably in a dilemma whether it's going to be good or it's just going to get worse for you. So today, here in this webinar, we are going to discuss this further. And joining me is someone who needs no introduction, who has been a part of Immigration and Jobs Talk Show, makes it a point to be here. So I'm very happy to welcome once again none other than employment-based immigration law attorney, but also a true advocate for the immigrant community, from defending H-1B RFEs and NOIDs to guiding students on F-1 OPT visas and offering expertise on TN and E3 visas. Justin has been a beacon of hope. So please help me welcome him back to the show. Hello to Justin Rivera from Wasden Immigration Litigation. Thank you so much for joining us.
Thank you for having me. That was a very nice introduction. I appreciate it.
It's been a while, I mean, I take it for granted sometimes, and maybe I don't say good things about you or let folks out there know. So maybe we have new friends. This is none other than Attorney Justin Rivera, today's special guest, and he's going to help us today on this topic. We're going to talk a lot on Trump's new team. So before we head start, Justin, what do you have to say to everyone out there?
Well, anybody that's here that's celebrating, an early happy Thanksgiving to you, because that'll be coming up this week. If you're here in the U.S. celebrating that, happy Thanksgiving. I hope you have a short work week. But yeah, in regards to today, we'll just try to delve into, I think, a lot of what many people are doing right now, which is trying to kind of wrap our heads around what a new administration is going to look like and the impact that it's going to have on immigration in the country. And you can do that kind of by looking at who's being put in influential positions within the administration, and what have those people said about immigration, and what that possibly means they'll be actually doing moving forward.
Absolutely, friends. Thank you so much, Justin. And yes, don't forget to participate. And before that, if you have friends who would be interested in getting to know this more about today's topic, Trump's new team and its effect on immigration, please feel free to share this link with everyone or your friends out there and ask them to join in this discussion. So, yes, thank you so much once again. And let's go ahead, Justin. I have this first question. This is regarding Pam Bondi, and she has a history of aligning with Trump's agenda, including her role in his impeachment defense and her work with America's first policy institute. So, how do you foresee her policies impacting immigration cases, especially regarding federal prosecution priorities?
So I think, obviously, it's a fortune teller argument here of what are you predicting or what can be done. But I definitely think that, there is an avenue to go after criminally, go after people that are, found to have committed visa fraud. Usually that's something that's applied to companies, organizations, usually the higher up individuals within the organization. And so, could they use that avenue moving forward more liberally than they have in the past? I definitely think it's an option. In regards to Pam Bondi, just kind of reading up on her and looking at kind of her record, I think she's probably going to be basically doing what Trump is asking her to look into. And from her perspective, I think the immediate things are probably not going to be immigration and that enforcement of, maybe fraud allegations against individuals. Now, that's not to say that couldn't happen, because honestly, it would be a pretty interesting tool for them to try to utilize if their goal was to actually start trying to crack down on the companies rather than the individuals, as a method of kind of limiting how some of the organizations that have been able to get away with using H-1Bs would be able to use them moving forward. So I definitely think it's something to look into and think about. I do know that, from my understanding of Pam Bondi, her relationship with Trump had something to do with I guess the fact that he gave a donation to her of like $25,000 or something like that to her reelection campaign, and not as a direct result, allegedly, but maybe the fraud investigation into Trump University in Florida was no longer something that was being discussed or put on the docket. So that's on the Washington Post. You can see the inference formed there. But what that really kind of tells me is it's like you're going to see with a lot of these appointments, it looks like it's more of a loyalty issue rather than a skills issue. It's, is this person willing to carry out what it is that he wants to put forth with his administration? And so, yeah, I would say, would it shock me if there were more cases brought against people for visa fraud, especially the employers, the people who are actually signing the H-1B forms? No, it wouldn't shock me at all. And honestly, if I were them, it would probably be something I would utilize.
All right. Thank you so much, Justin, for giving us a sneak peek into your thoughts about Pam Bondi, and thank you so much. You can also go check out the post on Washington Post, and the news is out there already. So thank you on that note, Justin. We also have Amay on YouTube asking a question. Amay, please stay with us. We will take up your question in a bit. Hang on. For now, I have another question, and this is about Matt Gaetz. Although he withdrew his nomination, the controversy surrounding his potential appointment raised concerns. So, does the consideration of such a figure indicate a shift in how the administration might handle immigration related ethical and legal matters?
So yeah, I mean, I think I don't know really if we're going to be able to frame it specifically through the prism of immigration, but I think what we saw with Gates's attempted appointment was the fact that there are still guardrails in place, regardless of how tenuous those guardrails are. There's still going to be some level of qualification required for these people being put into these positions. And the fact of the matter was that Matt Gaetz, he wasn't really qualified for the position that he was going to be put into. That being said, as well, would he have gotten the position were it not for his ethical issues? It's very possible. But what it really kind of does show me is that there is still going to be pushback on appointments, which is a positive thing. That people still should be held to a high standard. But in terms of immigration and kind of how I think it's kind of interesting, you could maybe draw this small parallel from it. But the fact that Trump was even willing to try and appoint Gaetz in the first place, it's not that surprising, and it's a bit indicative of his strategies. A lot of times they just kind of throw stuff at the wall and see what sticks. So if I'm looking at it from that way, I wouldn't be that surprised if you see a lot of quick changes to immigration that come in, and a good amount of them end up being invalidated by the courts. Just because they don't hold legal muster. So that wouldn't shock me. I definitely think that they are more willing to act and then just kind of see whether or not the court will let them act, rather than make a prepared, concise, well-researched change that's going to stick. So that would be my thought process, would be don't be surprised if you're seeing, within that first month of the administration handover, changes, fairly drastic changes in proposals that may or may not actually hold up in a court, but are still going to cause hiccups in the immigration system.
All right. It's scary how the situation is for many immigrants out there, I think. And with all these new picks, I think the situation is getting even more tensed. What do you say, Justin?
Uh-oh.
Can you hear me?
Yeah, sorry. The quick little hiccup right there.
No worries.
I'm here.
Yeah, I was just saying, like, with these new picks, it's just getting scary. So, what do you think?
Actually, someone just commenting about, I think it's Dr. Oz was allegedly being given an appointment. No, I know, Sakshi. I know. Yeah, it's not ideal for me. I think for a lot of people who are looking at the individuals that are being named to these positions, there is a little bit of a wow factor to it, because I think in the first administration, I think Trump was a little more reeled in just by the nature of the fact that, like, it was fairly surprising for most people that he won. And I think there was a little bit of period where the Republican Party was kind of like, we're going to put we're going to put guardrails up. We're going to have people appointed, Rex Tillerson. There's going to be people put in positions that are experienced and qualified and know what they're doing. What we did learn, though, from that administration was there was a pretty high level of turnover, and that turnover basically correlates to, if you're not doing what he wants, you're going to lose your job. We saw it with Jeff Sessions, and then he even ended up having problems with Barr, which was, another person he had appointed himself for the AG spot. So the other thing to think about, too, with this is kind of a shelf life. How long are these people actually going to hang in these positions? And actually stay and deal with kind of the turmoil that this administration is inevitably going to bring. So that'll be something I think we're going to have to consider as well.
Right, Justin. Thank you so much. That also was a very good insight, I would say. And we have Malutek USA and even Sakshi joining us with their questions. And I think that we can take Malutek's question for now, if you don't mind.
Yeah,
so
sure.
He's asking, Canada, Australia, and UK reducing temporary issues and student visas. Why Republicans act more left than Canadian Trudeau? 10,000 of American tech workers are unemployed, desperately need job. Okay, what do you have to say?
I okay. I think so. I've been kind of monitoring the Canada situation pretty closely because I found it very interesting. So during the initial Trump administration, Trudeau, who is still in a position of authority, Trudeau was very open to immigration. He was basically saying, like, oh, if you're not wanted in the United States, come to Canada. We want you here. We're more than willing to take people on.
Yeah.
They looked into expanding their immigration regulations to bring in a higher influx of people. That may have come back to bite them. About probably around last year, the middle of last year was where I started seeing it. That's not to say it's not something that's been existing before, but I did start seeing a lot of attention on it in the middle of last year, and it's at the forefront this year. Trudeau's already made statements that he's reversing course. They are taking steps to curtail and limit immigration moving forward. He has made the spigot argument, which he's claiming that the spigot, the water spigot, has been turned too far one way and needs to be turned back the other way. That's his stance. I've been playing through my 34 years. What's up?
Sorry.
Oh, it's okay. But anyway, that's he's a politician. He's dealing with the vibe of what's going on in his country presently. But as a result, yes, I think you're seeing Canada move towards more restrictive immigration policies. Australia, I think I've also seen is possibly trying to reduce immigration. I'm not as well up on the UK. Why Republicans would act more left than Canadian Trudeau. If you're saying why would the Republican Party embrace immigration, legal immigration in the United States? Because legal immigration in the United States is beneficial to the United States economy. It's been well established. So there wouldn't be really any valid justification. I think that the whole point of these programs like the H-1B program are to create the necessary guardrails that prevent U.S. workers from being kind of left out in the cold by, allowing there to be people who are going to be able to do the same job for less money. That's why you have the labor condition application that establishes the wage levels. These things are stringently enforced, both when someone applies for the H-1B and through FDNS's site visit systems when they actually go out and make sure that the person's complying with the conditions of the H-1B. So that all being said, it would not shock me if the Republican Party acts differently than the Biden administration. I know people are very quick to jump the gun and say, well, what has Biden actually done for legal immigration? Like, how is it that different than it was under Trump? I will tell you firsthand, as someone who practiced under the Trump administration, it was significantly different. You were dealing with an entity in USCIS that was borderline adversarial. It wasn't more so our job is to process these applications. It was we're looking through these applications almost with an assumption that there's something deniable in what's being presented to us. And I think that's what you're going to see as the biggest difference. And it will show you that the Republicans are not more left than any of those other countries. They are going to seek to draw out the time it takes for an application to be processed. They're going to do that using requests for evidence that I'm sure will become more detailed and require more information than is currently necessary. They're going to do that by attempting to limit validity periods any way they can, meaning, they're going to probably go back to trying to find ways to cut down people's requests for 3 years. Whether or not that will hold up in court, we will have to wait and see. But I'm sure that they'll be taking from the pages that they've used previously in order to grind the system as slowly as they possibly can. On top of that, yes, it's completely possible that they're going to be introducing new ideas and new ways to try and make the system even more difficult than it is presently, with the underlying goal being that they want employers to just not have to deal with the program, and if they do things like increasing the wages, making it to where you have to pay even more to have someone employed on an H-1B. That's one avenue that they may look at. They may look at curtailing the definition of specialty occupation, making it more stringent to where it's more difficult to qualify for the position. They might make it harder for the employees to qualify with their degrees. unless the degrees are absolutely one-to-one correlated to the job duties being performed. So these are all things that they're going to do. And if they didn't do them, it would surprise me. But these are all things that I definitely think they want to do. And with Stephen Miller, who I'm not sure if we're planning to talk about today or not, but with Stephen Miller in probably a more influential position in this administration than he had been previously, all of these things are going to be on the table. And it's not really, to me, a matter of if, but when, and whether or not they've now also decided to find new things that they're going to be putting forth. I believe I saw last week, towards the end of the week, something about the dismissal of a case that had been backed by a Miller group where they were going after, once again, the H-4 EAD. So it was another attempt for them to go after some part of immigration to curtail it, to make it more difficult for people that are here on that H-1B visa if their spouse can't work. That didn't hold up in court. But you got to remember, they were challenging something. They're moving into a situation where they're going to be taking part in the rulemaking process. And that's going to change how they're approaching it and what they're trying to do. So all of that is to say, for Malutech, I don't think that the Republicans are going to be acting more left than the Canadians. I don't think that that's going to be the case at all. I think you're definitely going to see them crack down on legal immigration. It's not going to be the forefront of what gets people's attention, especially initially. Where everyone's eyes are going to be drawn is where the election seemingly was decided on in a large part, and that's the border. And the actions that are taking place at the border to curtail entry. And I think that's going to be what gets the headlines. But at the same time, it wouldn't shock me if they're able to walk and chew gum at the same time and also move forward with making those changes to legal immigration.
Right. Thank you so much for taking that up for Malutech USA, and thank you, Malu, for participating with your question.
Yeah,
But
no, I
Justin,
think it's a good question. I think it's also indicative of, in a lot of places, you're seeing a protectionist shift. I think you're seeing people in countries that are moving more so towards not maybe being outright anti-immigration, but being more selective in their immigration process. I think to say that is something that's moving forward in Western countries, I think to say that it would be realistic.
Right. But yeah, coming back to Stephen Miller, I mean, talk about his first family separation, including travel ban and all that. So, what do you foresee? I mean, this could also, influence this term as well. So, how's it going to be, you think, for immigrants?
So I think, I apologize. I think we have a question on him. I don't remember the name of the border czar that has been appointed, but I remember. I've heard about him, Tom Homan. Thank you.
Tom Homan, yes.
So Homan has really talked about his ability to enforce actions at the border, right? And it's when you really think about it from an immigration perspective, when you're reviewed for admission to the United States, that's a pretty big part of a process, because at that time, you're being, assessed by an officer who makes a determination as to whether or not you are admissible to the United States, right? So for most people that are legal immigrants, this is a very quick part of a process. If you've been in before, you come in, you know what you're doing, you go through CBP, it's no problem, right? It wouldn't surprise me if the enforcement activities being promulgated at the border begin to bleed out into other facets of entry. And so what I mean by that is this: I've already actually seen it. I was reading about it before our discussion today. Homan has already come out and made a point about illegal immigration at the Canadian border. Basically saying, there's problems at the southern border, but what about the northern border? We have issues there too. We need to be, we need to be more stringent in how we're reviewing people there as well. And so I think for a lot of people that are, that travel between Canada and the US, maybe people that are on intermittent L visas, TN visas, things of that nature, I think you're going to see a heightened level of scrutiny. I think it's going to be created initially under the guise of trying to curtail illegal immigration. but it's going to bleed into the other facets of immigration as well. And I think that that's going to be, it's going to create a difficulty where one previously hadn't existed. So I would say it's pretty imperative for people moving forward when you're getting ready to really consider traveling and how you're going to re-enter, where you're going to re-enter, what documents you're presenting when you re-enter, and being prepared for detailed questions being asked in relation to not only that, but any of your previous immigration history in the United States as well. Because, I mean, we've already seen things that are popping up under the Biden administration that have been popping up for a while now, but issues with, you know, people who have been on their H's for years that are now being questioned about F1 employment with, you know, companies that have been blacklisted, basically, that USCIS has now come out and basically said, if you worked with this company, if you worked with this company, then you're basically de facto fraud. Like, you've committed fraud based on the connection to the company. So I think that is something that's going to need to be like very well thought out by people when they're immigrating or coming into the US, looking at what is it that you could be asked about in your immigration history or about your current job or any of those things that could lead to additional questioning or additional scrutiny. Because all of that, I think, is going to be on the table. Because if you're not readily prepared, you put yourself in a bad situation. You put yourself in a situation where you're going to be questioned by an officer. You may not remember some of the facts. You may misspeak one time. That's really all it takes. Is one misstatement or one slip up, and it's enough to put you in a circumstance where you could be an expedited removal and end up having your visa canceled. So I don't say all of this through the desire to fearmonger. It's not my intent to make people scared to travel. I've also seen, you know, people online already are starting to get upset. They're saying, "Oh, my attorney's telling me if I have any travel, it needs to be done before January." Mid-January, you know, because they don't want people stuck by any changes that are made. This is ludicrous. I've never done anything wrong. You have to understand that as an immigration attorney, our job is to advise. And usually when we're advising, we're trying to take the most conservative approach or strategy possible, because what we want to do is minimize risk. That's our goal. We minimize the risk that an individual has either when they apply for something or, you know, they go to a visa interview or they re-enter the U.S. That's the goal, not to make you scared, just to make you informed. And I'll put it this way. If we didn't say these things and then in the middle of January you travel and something happens and you're stuck out of the U.S., who are you going to blame? You're going to blame us for claiming that we didn't tell you not to travel. And so that's why that's happening right now. It's really not because we want to make people fearful. It's more of we don't know exactly what's going to happen. And the best idea when that's the circumstance is to just minimize the risk as much as possible. But yeah, to just kind of button that question about Homan's leadership, the border policies, I think you're just going to see a lot more difficult issues with entry that you probably weren't dealing with in the past couple of years. I just think it's going to be a lot more scrutiny. They may bring back some of the issues that had existed beforehand, which were things like, you know, did you do a second master's degree and do day one CPT? Did you go to some of these universities that are looked at as you know, maybe less than compliant with F1 requirements, just things like that. And then there, you know, obviously employer issues and stuff like that. So I just think all of that's going to be on the table.
Yes, absolutely. And talk about the borders are. We can expect a lot of difficulties for sure, as we've already spoken about. Maybe RFEs getting more and more. Maybe they would want more evidence than already required. So, stuff like that is what we have been discussing. And I think there's more to discuss on this. There's so many new picks. And well, I would just like to say thank you to Pavan also for joining us with your questions. Just stay with us. We will take up your questions. All right. And yeah, Justin, getting back to our questions, you know, earlier I had asked about Stephen Miller also, like, because we have seen a lot of family separations and also, you know, travel ban as well. So I think this is going to be a little more tough on immigrants now, right?
Yeah, and I mean, obviously, I think if you're sitting on this call and you're somebody that's on, a non-immigrant visa, you're sitting there thinking, well, what is the applicability of that to me? I'm not entering the country illegally. I'm not doing anything wrong. I'm not doing anything illegal. Okay, so that's fair. It's a fair assertion. But aside from the fact that there's a whole human rights issue regarding the family separation issues. I think it was Tom Herman is his name. I think Tom Herman, when he was asked about family separation, he said something along the lines of like, "Well, no, we're not going to separate them. We'll make sure they're deported together."
Together,
That was the solve to the home and thanks. I'm gonna see what's gonna suck is that I'm not gonna remember his name, and then he's gonna be the bane of my existence for the next 4 years, and so he's gonna make sure I remember it. But yeah, so I get that, like, okay, well, maybe it's not applicable to me, but I'll have you look at it from this perspective. From this perspective. I remember during the last Trump administration, something that they had tried to do at the outset was deny people's extensions and then say you're now unlawfully present, which means you're subject to, you can be deported basically. Yeah. And then there kind of became a quick run where we were kind of running around like, are they issuing notices to appear for these people? Are they going to be coming after them to put them in deportation proceedings? Because people need to understand this. If your status, let's say your H-1B extension gets denied and you're no longer lawfully present in the U.S., you can depart. You have an opportunity where you can leave the U.S. You have a timeline where you're able to leave. And, outside of having to admit that you had a prior denial and maybe explain the denial, there's not going to be that wide reaching of a problem that comes back to bite you on that. If you were to get placed in deportation proceedings, that completely changes the game. That's a situation where if you leave without appearing in court, there's implications, and then there's implications of how long do you have to stay while everything is waiting? How do you sort things out? Can you apply again to get yourself back in status? So I do understand people being like, I don't know how that's going to affect me. It can affect you because the policies, like I've kind of been reiterating on this call, that are initially utilized for people that are illegally immigrating, they can bleed out and subsequently be used in the future against people who have come into the country legally and then lose their status because, they've had a denial or something like that. So while I'm very hopeful that doesn't happen because it would just really complicate our jobs even more, it's not to say that they can't utilize that. And so just thinking backwards from that, I just think that, if it does happen, it's horrible, but I hope it doesn't. But I think people should be aware that it's something that I know they have on their table. It's in their arsenal of things that they might want to do.
I mean, imagine being like the second or the third generation in the country, and suddenly, like, you and your family are having doubts if you can still be in the country or not. So,
yeah, I mean, all that stuff's frustrating. I mean, especially I would not be shocked for a second. During the last administration, they really cracked down on the F1 program. They did. They went a lot harder at STEM OPT than they had ever done before. It wouldn't surprise me at all if they went after that again. I think that it's something that because you got to think about it this way. If they want to curtail immigration, what's one of the easiest ways they can do that? They stop people from coming in and doing F1s and working in the U.S. on OPT and STEM OPT. If you cut that out of the process, then those people have to leave the country. And yes, they may still go into the lottery, but it's probably going to be harder for them to get sponsored because they're no longer working in the U.S. They're working overseas in their home countries. So yeah, I think that's definitely on the table. It wouldn't shock me at all if they tried to come out with basically new enforcement mechanisms for the F1 program.
all right, let's just hope for the best and look forward. All right. Well, now, Justin, let's take up Rag's question. He's here on YouTube. He's saying, "Hi, Napasa and Justin. With a flurry of cases coming in, will the attorney's efficiency be compromised, resulting in more RFE or rejections?"
So I don't know if it'd be the attorney's efficiency that creates the issue with RFEs. The issue with RFEs are you prepare a petition as best you can. You try to cut off all lines of inquiry where they reasonably exist. But if you're dealing with a circumstance where the goalposts are being moved constantly and in real time, it's going to create problems. And that's what creates the increase in RFEs. Things like changing how you look at specialty occupation or how you make that definition. Things like how you look at how someone qualifies for a position, trying to reintroduce things like, project documents or proof of specialty occupation work. Those are all the things that are, in my opinion, are going to lead to an increase in requests for evidence. That's really the big issue with it. I think that the goal is not only to just increase the probability of denials, it's to increase the time that it takes to go through the process. It's to draw this out and make it more difficult so that it becomes a circumstance where employers just don't want to deal with it. I think that's really the underlying goal. And that comes from mucking up the system by making things harder when they shouldn't be. When it comes to, rejections, rejections are circumstances where when you're filing a case, there's something missing in the case or deficient, or it's sent to the wrong location. Those are things that typically an attorney should be able to deal with, regardless of what administration is in a position of authority. Where that could become problematic, just speculating here, because we've already seen it with Biden in some regards, is just changing things. Making quick changes to forms and saying, actually, you know what? You got to use this form edition. And we're not going to backdate it, so you got to start using it as of December 1st. And the form came out on November 26th. Well, if you're a normal, business immigration attorney, you've probably got X amount of cases pipelined that have already gone through that process, went to the client for signature, and they're in line to be filed. If you don't catch those before they go out, those will be rejected. So that's definitely something that could happen. Just making constant, updates and alterations to the forms. But at the same time, if that's going to be something that they do, then it's going to become incumbent on the attorneys to make sure that they're doing their due diligence at the time of filing, to make sure that everything that goes out is correct and proper. Because that's really the only way you're going to combat it. The other thing they can do too is they can move around the mailing locations, which is annoying, but we do try to stay on top of that as much as possible. That's a lot. AILA deserves credit for that. AILA does a lot with making sure that any of those changes that happen are kind of blasted out to the attorney so that we're aware of it. But those are avenues that they could take to increase rejections.
Yes, I mean, changes and updates, these are very, very important things, and it's very important to stay updated. So, folks out there, just keep on researching and keep looking out for new changes. Because, I mean, I remember we had a lot of fee changes, and like you said, address changes, Dropbox location change, and stuff like that.
Right.
And this led to a lot of, cases becoming invalid because of the wrong fee and etc.
Right. And so that's another one too, that obviously, like, when you talk about mechanisms to make the process more difficult, fees are such an easy one. Fee increases are always a great way to hit the bottom line of the sponsoring petitioner. So if they're able to kind of combine increasing fees with shortening validity periods, that's a win-win for them, because it puts them in a circumstance where they're really making it harder for the employer. But yeah, that would be my answer to that, Raj. Thank you for your question. I appreciate it.
Yes, thank you so much, Rag, for participating. And if you have any more questions, we're still here. So, Justin, my next question, this is about Pete Hexet's political appointment as Defense Secretary. This brings attention to his hardline stance on national security. So, do you think this could lead to increased militarization of immigration enforcement, and what might that mean for immigrants at the border?
So I will say this is actually something I've really been thinking about. Maybe not necessarily for the border, but it's something that has been crossing my mind, and that is, what is the impact on legal immigration of increased conflict abroad, whether that be in Europe or in the Middle East? Do we see some sort of proclamations coming out as a result of those conflicts, limiting immigration for people from those countries, or limiting immigration overall? I say that as someone who, we had a discussion before this call, for something I had just been dealing with, where it looks as if that there are people from a certain country that's engaged in a conflict right now that are basically just being denied U.S. visas under a very interesting strategy, where they're being told that they cannot overcome a presumption of immigrant intent. And by doing this, it's kind of almost become this blanket justification for a denial where they're just saying 214B, no presumption of, you have not overcome presumption of immigrant intent. Therefore, you are not able to qualify for, let's say a B visa to the United States. My wonder is that a strategy that could potentially become weaponized moving forward as the conflicts in the Middle East increase? Hopefully they don't increase, obviously, but it's pretty hard to watch the news every day and see what's going on, and think that the next 4 years are going to be really chill and not involve more foreign conflict. But does that conflict create an even higher inclination and desire in the United States for this protectionist nature, where you're basically saying like we're severing ties, we're keeping Americans in their bubble, and we'll let people in from a couple different countries, but other than that, we're just staying with what we're doing. Maybe, I don't know. We'll have to wait and see. But that's something I've now been worried about. I'm starting to think about. Right. What is the impact specifically of what country you come from and your immigration? Not even how you qualify for something, or is it a valid petition? That I think is going to be on the table as well.
Right, right. And I mean, we've seen a lot of cases and a lot of announcements about becoming anti-Muslim and not allowing, countries with major religion as Muslim, not to allow them to come in to the country.
Right.
So, and plus, like what you were saying about the case, I mean, imagine, you being denied a visa in spite of doing everything right, having all the documents.
Yeah, I
correct.
mean, I'll just come out and say it. It's pretty much being talked about already. I'm talking about people from Russia, just specifically.
Yes.
There's been a big increase in 214B visa refusals, specifically for people from Russia. It's a blanket denial, basically, that's being issued. And I'm kind of wondering, how is this strategy employed moving forward with other countries in the event that those people from those countries, their countries embroiled in a conflict? So we'll have to see. But like you said, the so-called Muslim ban is another issue that's something that's probably going to get attention coming in day one. So we'll have to see the impact of that as well.
Right, Justin. Thank you so much for taking that up. I think we should get back to Malu because he has another question for us on YouTube asking wage levels won't get enforced for H1B. I know H1B visa employees working for $70,000 per year, whereas citizens working for client for same position has double the salary.
Yeah, so I mean, if you're asking about wage levels being enforced, the wage levels should be enforced because you have to pay a specific wage level based on where somebody's working and residing. Where they sit is what's going to dictate the amount of money that they're paid for the position, based on what kind of position that is in the labor condition application. There's really two ways that USCIS and DOL can attack and attempt to undercut wage levels. The first of which is when you apply for a position, you have to determine what the wage level is at the outset of the filing. There's 4 wage levels. Wage level 1 is entry level, experienced, quasi-managerial, high level, four across the board. USCIS has the ability to question whether or not the position qualifies for the wage level provided. They've done that pretty stringently when it comes to what's called level 1 wages. So that's the lowest wage level. Basically, that level 1 wage level is only applicable at this point to absolute entry-level positions. People just out of college with degrees that are maybe just now starting to work in their specific industry, they maybe have internship experience or something like that. But as a result of that, you can't use level 1 to go in and undercut a position that doesn't meet that standard. So that's the first way in which you're really not able to game the system as much as it could have been gamed in the past. The second issue is if the company is actually paying someone under what's in the labor condition application, that's a DOL violation, and that can be reported. So not only would I tell you, Malu, if you see this going on, not only would I say feel free to report it to the Department of Labor, tell those people that are employees, if they're being paid under the amount of money that's in the LCA, to report this to the Department of Labor, because this is a violation. And those companies should be held accountable for what they're doing, because what they're doing is illegal. So that's kind of my opinion of how you fix a system that even has like some small issues in it, rather than just kind of make this blanket proclamation that like the H-1B system is bad. understand that there are ways that you can work within the confines of the system. I will tell you this, I file H-1Bs all the time. It's been very rare for me to see anybody getting paid $70K a year. I think that is a tough beat at this point to find people that are going to be getting paid around $70K. Even when you're paying on the lower end of wage levels, I think that obviously location matters. If you're in California, you're getting a very high salary. If you're in Iowa, the wage levels might be a little bit lower. So it does depend on where you're located. But that being said, yeah, I think I've done 4 or 5, maybe 6 LCAs last week. And I can't remember one of those LCAs being for $70K. I think probably the aggregate among those was close to $115 to $120. And some of those were even higher. So yeah, I mean, look, is there a notion that the H-1B is utilized as a way to undercut wages in the US? I think that, yes, that's an assertion that's been made. Can you do that now in the current 2024 iteration of the H-1B? I don't think so. I think it would be very, very difficult to do. And I'll do you one more, Malu. I will definitely tell you this. On top of that being reported to the DOL if someone's violating and paying under that wage level, I definitely think you're going to see a big increase in FD&S visits. I think you're going to see people coming in now. I think you're going to see more officers getting paid to do site visits all across the U.S. to go to client locations or employer locations or even home locations if they're on the LCA. And they're going to be asking those kinds of questions. Things like, what are you being paid? Seeing if that complies. All of that stuff, if it's a violation and the company is violating the conditions of the LCA, they need to be held accountable. They absolutely need to be held accountable because that should not be the underlying purpose of why someone is utilizing an H-1B.
Right. Right. Thank you so much for taking that up. And I'm sure Malu is very happy with your answer, very detailed. And thank you, Justin, for taking that up. See, he has something to say already. Many of us have been replaced by H-1B visa employees. So H-1B wage level need to increase to 120,000 to minimum.
Okay. Well, I mean, that's what you're asking. You're asking me, you're saying, do H-1Bs undercut the wage level of U.S. employees? I've come back and said no. And now you're saying, well, the wage level has now gone up to 120K minimum. Well, that means that the wages are higher. So I'm sorry, I don't really know how else to answer your question. The underlying purpose was to prevent wage abuse, right? By hiring people that are paid less money to do the same job. So if that's no longer the case, then it seems that the program is being implemented in the way that the people wanted it implemented in.
They say they need to increase it to 120K minimum. So, okay, I think that's what he... But yeah, thank you so much, Justin. And I hope that, Malu, you have your answer to your question. But anyway, Justin, I have my next question. And I think without discussing about Elon Musk, this wouldn't be complete. So with Elon Musk advising on government efficiency, do you think his involvement would lead to changes in how immigration processes are streamlined? Or do you think his focus will be on wasteful spending, which will result in reduced resources for immigration service?
So I would definitely say this, USCIS is fee-based, meaning that the money that they get is generated by fees that come into them. So in that regard, I don't think you'd see much of a change because they're just going to basically do the same, pardon my language, but they're going to do the same crap they always do. If they're going to say, we don't have enough money. And then, we need to raise fees because we need more money. And then processing will stay almost exactly the same. And we'll wonder where the money's going. But in that regard, I don't foresee it being that big of an issue. Musk, I'll be honest with you, he confuses me to a little bit because I don't really know what his long-term goal is. For example, my understanding was that the Trump administration wants to get rid of electric vehicle incentives, which would seemingly be directly harmful to his own organization. And then I've also seen that, one of the agencies that they want to cut funding from is NASA, which I think, again, would negatively impact his SpaceX program. So I don't know if his goal is to somehow put himself in a circumstance where like his companies benefit from these changes, but then other people don't. I'm really not sure. Yeah, I mean, maybe he does want to be president. Who knows? Well, I don't know if he can be president. I don't think he was born here.
Yes, I don't think.
So I don't know, maybe, but I definitely think that he's enjoying the amount of sway that he has presently.
Attention, yes.
Because he's in every picture, basically seated at the right hand of Trump. So yeah, I think he's enjoying that. I think him and Vivek, what they're actually able to do and what they say they're going to do are probably going to be two different monsters, because this really kind of gets back to the whole appointment issues with Trump. It's almost never a matter of just if that person's going to quit, it's a win, Eventually it's a situation where the person gets worn down and just leaves. So we'll see what he's actually able to do versus what the impact of it'll be. When it comes to like immigration, I've never really heard Musk come out and have any sort of anti-immigrant sentiment. I mean, I can definitely tell you through the grapevine that Tesla utilizes a lot of employees that are on NIV visas.
Yes.
So I definitely think that he's, someone that benefits from the H-1B program. So it'd be odd to see him kind of, bite off his nose to spite his face or whatever the term is. But yeah, we'll have to kind of wait and see. I would be surprised if it has long-ranging impact on immigration. The things that could have an impact on immigration for him from a business immigration perspective are what are the implications of these kind of cuts to government contracts, and government projects, because I will say that I've worked with companies that, there may be a consulting company who the third party is actually a state agency, and what is the impact of that funding that's coming from the federal level to the state level for that project? And does it mean that they cut employees or whole cloth, get rid of that whole project in the first place? That's something that I think could be a problem. But it's going to have to just be kind of wait and see. I mean, I know that they introduced a couple of policies that they want to talk about, but it's all broad strokes. There's no actual how-to of it. And until that really comes forth, we're not going to have the full scope of the picture. But yeah, I mean, hopefully out of everybody, Elon's at least the only person in Trump's ear saying, hey, immigration's a good thing.
Yes. Thank you so much, Justin, for that view. Well, I have a few questions on, our Facebook groups and also our YouTube channel. So let me see.
Yeah, I could try to do like one or two, but I am
Sure.
cutting time pretty closely, to be honest.
Sure. So let's go with quickly. I mean, these are just comments. Maybe you can just tell us your views on these. So this was on our channel saying, so conservative Republicans support people immigrating legally, but the border has been invaded by unwanted and the poor. We cannot financially support people who never put into our tax system, but want the financial benefit as a welfare recipient. Yeah.
I think there's a pretty easy way to just say what this person's saying. Trump wants to block illegal immigration from coming in. People validly understand that undocumented immigration is a problem in the United States. The system does not operate efficiently, and it doesn't operate the way that it's supposed to. I personally will even go one step further and say when people that are immigrating to the United States come in and they're working on work visas, I think that it's a little bit ridiculous that part of the employer's job now is to throw an extra $600 into their petition, specifically to deal with issues at the border. The so-called asylum fee that has been added into these employment-based applications, I think is unfair. I don't think that it's necessarily appropriate for legal immigration for people who are sponsoring people here in valid non-immigrant statuses to have to take on the additional burden of dealing with problems that are occurring at the border. I understand that frustration. I also think that it must be incredibly frustrating for someone who has been in this country legally for 10 or 15 years that is still sitting here waiting for an opportunity to apply for a green card, be told that, the big issues in this country aren't you. The big issues in this country are people coming in from the southern border and, claiming asylum. And that's really where everyone's attention is going to lie. So I understand that anger. I get it. What I don't understand is this disconnect that seems to exist for some people that are here legally, that have immigrated here legally, this disconnect that Trump only has issues with illegal immigrants and Trump's only going to be creating enforcement activities that only goes after people that are in the country illegally. Donald Trump may believe that in his heart and soul. Stephen Miller doesn't. And Stephen Miller is the person that's going to be architecting the policies that are going to dictate the next 4 years. Yes. That's where the disconnect I see gets frustrating for me, because I really don't want to hear people complaining when we're a year and a half into this process and legal immigration has gotten more difficult. I don't want to hear the complaints about, oh, well, I didn't think this was going to happen. We were telling you it was going to happen beforehand.
Yes.
So I don't want this head in the sand crap that is inevitably going to spew up as a result of that. So yes, to this person's point, I get it. The southern border is a mess. It needs to be addressed. Honestly, it looks like it was pretty high on the list of reasons why Trump won. And that's something that he's going to be tasked with fixing over the next 4 years. We'll see how he does. I hope he does well. I hope that we're able to create avenues that create positive results where we're able to curtail this problem and make it better. I also hope at the same time he does things that benefit legal immigration. But we will see. Is it likely? No. So yeah, that's kind of all I have to say in relation to that comment.
Thank you so much, Justin. That was really valuable. And this next one is, I hope Trump bans sanctuary cities and ban illegal immigrants from getting any benefits from America.
Okay, we're kind of we're spinning on the same wheel that we were on previously.
I hope so also.
And look, I get it. Like, there's definitely going to be a lot of showdowns that happen over the next 4 years with illegal immigration. There's going to be issues related to state government versus federal government. The enforcement of immigration by local officers, I've already seen as an issue that people are bringing up. The idea of sanctuary cities being challenged or being brought up as well. All of this, in my opinion, really comes back to this notion that all of this comes back to the notion of people who came here the right way are frustrated that people who didn't come here the right way are getting benefits. And they're getting, it's a feeling of animus that I'm trying to do things correctly. I see people not doing things correctly, but those people not doing things correctly seem to be getting more attention and a better break in terms of benefits than what I'm receiving. Okay. I hear that frustration. I understand it. All I can say is what I do professionally, and what I've done professionally over the past couple of years, dealing with this exact administration and what we're going to deal with its new iteration. You're not going to just escape the impact of immigration policy changes merely by virtue of entering the country legally. It's not going to mean, do I think that Trump's going to hunt down everyone that's on an H-1B and deport them? No, of course not. That's not going to happen. But we are going to see a tougher 4 years play out than we have seen under the Biden administration. And that's just a fact. It's going to be what we deal with. And that's regardless of what they do with illegal immigration. So if you are happy that these changes are being made in relation to illegal immigration, okay, that's great. But do understand, if you are an immigrant and you are in the United States right now, or you want to immigrate to the United States, the world that you're going to be looking at by the middle of next year is going to be very different from the world as it is what we're speaking about presently.
Mm-hmm. Right. I think, thank you so much, Justin, for that. Last but not the least, if you would just like to take up this last comment from Rag, will legal immigration get a day one surprise, or could there be a bit leeway?
I genuinely don't know. I mean, I don't think it really makes sense for them to come out and make drastic policy changes in relation to legal immigration on day one. I think they're going to want to serve the master, which is the masses in their desire to make changes at the border. So I really think that's going to be what policy A is for them, is going after making whatever changes they think are necessary. I think they're definitely going to reinstitute the Remain in Mexico program. I have heard that they are trying to institute a similar program in Canada. So that'll be interesting. Because I didn't know that there was a lot of people trying to come in through Canada to claim asylum. Usually you hear about it coming from Mexico. So I know that those are going to be things that they're probably putting in at the outset. I definitely think that, the family separation thing is going to be big. And then how they handle different policies with removals and stuff like that. That's all going to be big. That's going to be, like I said earlier in our call, that's going to be what gets the eyeballs. What's not going to get the eyeballs outside of the immediate community that handles immigration on a day-to-day basis are going to be the policy changes that they implement throughout the duration of the 4 years that they're in. Because I think obviously don't agree with the things Stephen Miller does, but have to give some level of credit where credit's due. He's had 4 years to sit on the things he did last time, and he's had an opportunity to probably make changes and corrections to things that he was not able to get done before. So you're going to see, you're going to see somebody that's coming in with plans and ideas that he's going to want to implement. But yeah, maybe day one, will there be 150 RFEs issued the day Trump takes office? No, I don't think so. I think you're probably looking at more of a slow burn.
All right. Thank you. And Rag already says, thanks to Pasa and Justin. Great updates. Thank you, Rag, for participating.
Thank you for your time. I'll try to come on next time we get together with just something more positive.
Sure.
That
Justin, it's really, but it's seriously always a pleasure to have you here. Thank you so much. Today was great. I mean, it was a great and interesting discussion about all these picks that Trump has made in his new team. So thank you so much for doing this today.
Absolutely. Thank you very much for having me. You guys have a great week. Have a great Thanksgiving. And I'm sure I'll talk to you soon.
Yes, me too. And here's wishing you and your lovely family a very happy Thanksgiving as well. Happy holidays.
Happy holidays. Bye.
Bye-bye. So, folks out there, thank you so much today for joining us in this very important discussion. And it was great having you. Please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and also on X. So thank you so much. And stay tuned because we have more webinars lined up. And I think in just 15 minutes, we're going to have another. So yes, watch out. Immigration and Jobs Talk Show. It's Napasa saying bye for now.
Hello, everyone. Thank you for joining us once again here on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and it's seriously an absolute pleasure to be here once again with another very insightful webinar lined up for you. But before we move ahead with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you once again for joining us here on Immigration and Jobs Talk Show. And this is a great place for you to be in, especially if you want to know more about U.S. immigration and business opportunities, because we are going to dive into a topic, that has definitely sparked significant interest. So, how entrepreneurs and investors can be on the ground doing business in the U.S. in under 6 months. And yes, to help us, dive deeper into the key insights on E2 and L1 visas, we are going to be honored by the presence of none other than our guest for today, um, Mr. David R. Fulmer, an exceptional immigration attorney and a leader in his field. So, Mr. Fulmer is a partner at WR Immigration with over 2 decades of exclusive practice in immigration law. He's been recognized as Immigration Lawyer of the Year and is celebrated for his expertise in assisting companies, entrepreneurs, and even entertainers, navigate immigration challenges. So, for all our viewers, whether you are an entrepreneur, dreaming of setting up a shop in the United States or your business, or maybe an HR professional overseeing visa processes. Well, thank you so much, all you immigration enthusiasts, for being here. And without further ado, please help me welcome our guest, Attorney David Fulmer. Thank you so much for joining us.
Thank you very much for having me, Napasa. I'm thrilled to be here.
Absolutely lovely. And I'm so excited because this is the first time you're here. And we would love to get to know you better. Maybe tell us more about yourself and anything else is something interesting to share if you have any.
Well, I'm lucky enough to live in Los Angeles, and it's an amazing place to live. Our offices are steps from the beach, and I also live about 5 minutes from the beach. So it's an amazing place to be. It's an amazing place to welcome immigrants from other countries, and I think it really exemplifies the best that the United States has to offer. So I'm really happy to be here.
It's an absolute pleasure to have you here. And I can only imagine what a great vibe you must be surrounded with. I mean, the beach always gives you good things, I think, the sunshine and a lot of palm maybe. But yes, I can only imagine. So thank you so much. And well, with regard to today's topic of discussion, how entrepreneurs and investors can be on ground doing business in the US in under 6 months. So, what can folks out there who have joined us or will be joining us in this session, what can they expect from us today?
Well, today we're going to talk about e-visas and L visas, and these visas really do present an opportunity for people to kind of direct their own destiny. A lot of times people think about coming to the United States on an H-1B visa, which is amazing and it's great, but it requires them to find a job offer. Or they think about maybe being petitioned under EB2 or EB3, and those are amazing as well, but it requires both a job offer and a very long wait. But E2 and L1 are really opportunities where if you're from the right country, in the case of an E2, and if you have the funds and if you have a business plan, that you can actually direct your own destiny and move to the United States, bring your family to the US. It's an opportunity for people's spouses to work or for their kids to be part of the US education system, all based on their own funds, their own business plans.
Absolutely, friends. Today we are going to discuss about E2 and L1 visas, and especially all you folks out there who are businessmen and who want to maybe expand your business or go start a business. Great place to be in. So, yes, I think without further ado, I have my first question for you, David. And this is with regard to this change of administration. How might President Trump's immigration policies impact pathways for entrepreneurs? and the processing of L1 and E2 visas, considering the administration's historical focus on stricter visa regulations?
That's a very good question, and the answer is not necessarily straightforward. There's two things we can look at. First of all, we can look at the prior Trump administration and what they did, and then we can look at some other issues relating to the incoming Trump administration. So first of all, looking back historically, the prior Trump administration implemented a policy called Buy American, Hire American. And the idea of that policy was that in relation to any visa or any immigration process, they wanted to make sure that issuing a visa for that individual would not hurt the wages and working opportunities for U.S. citizens. So it was always a part of, during the Trump era, we always had to demonstrate that jobs would be created. With E&L visas, that's already part of the program. So that's one thing. Next, over the last few years, a lot of U.S. consulates have been waiving in-person interviews. And what that's done is, I wouldn't expect that interviews would be waived for E&L visas, but waiving of interviews for, say, people who are getting extensions of their H-1B visa has kind of opened up resources for quicker processing of other visa types like E2s. And so getting rid of interview waivers will probably cause some delays. If you'd want, I can talk a little bit about another interesting aspect of it, Napasa, which is
Sure.
Everyone knows that Donald Trump has been very close to Elon Musk. Now, Elon Musk is a business leader from Silicon Valley, and so we're also hoping that Elon Musk will have President-elect Trump's ear, and he might influence him to be a little bit kinder and gentler and a little bit more efficient when it comes to visa issuance. So on one hand, we can expect things to be stricter and slower, but we're hoping possibly that Elon Musk might have some influence and might be able to influence things in a positive way.
Absolutely. And looking at how close they are, I think he might as well. And both of them business minded, they would love to soar with regard to business. So I'm sure this is going to be good. And right. Right. But yes, on the other hand, like you were saying, like stricter rules, and maybe they are going to just make the situation even harder, that they, finally drain out or give up and just go away to their own countries. Who knows?
Absolutely.
So,
I mean, I think that we will have more RFEs. Normally, when you file an L1 petition, there's always going to be a chance that you could have a request for additional evidence. During the prior Trump administration, there were a lot more requests for evidence. And so I think we can expect more requests for evidence, which will cause processing times to extend a little bit.
right. All right. So, folks, we have mixed things to look forward to, but I think it's always best to stay on the right path and do the right thing and keep your documents right. And there is no limit to your dreams. So keep dreaming high and work for it. Yeah.
Absolutely.
All right. At this moment, I would like to say hi to Sneha. Thank you so much for joining us here on YouTube. I can already see your comments. Stay with us. All right. We are going to address your questions a little later in this webinar. Now, moving on, David, I have the second question, and this is, for entrepreneurs looking to establish their presence in the United States, quickly, especially, they don't have time to wait or don't want to wait that long. What are the critical steps to secure an E2 or an L1 visa within 6 months? Is it possible?
It is possible. So first of all, the key point with relation to an E2 visa is the individual needs to be from a treaty country. And the U.S. has E2 treaties with many countries, but not every country. We have E2 treaties with about 85 countries, but we do not have them with the BRICS countries. So not Brazil, Russia, India, China, or South Africa. But if you are from an E2 country, then the E2 is a possibility. Otherwise, you have to go through an L1 visa, which has additional requirements. So if you're from an E2 treaty country, the first thing you'll need to do is really set up a business plan, decide what type of business you would like to be in the United States. Then you'll have to set up an entity in the United States. You have to set up a corporation or an LLC, register it with the Secretary of State in that state, get a tax ID number, set up a bank account, and then you can fund the company, and that's really the first step.
All right. Thank you so much. Thank you so much, David. I think that makes us hopeful at least. And maybe, are there any tips or maybe additional things that folks can keep in mind when they are in a hurry to be out there in the US?
Well, I think it's good to be in a hurry, but more importantly, to be in a hurry is to make sure that they're in a business that's going to be successful in the United States. So first of all, I recommend that they look at themselves, look at their history, look at what they're good at, and look where they could be competitive in the United States, because the business environment in the US is very competitive. And so rather than being in a rush, I think people should analyze where they think they can have an impact, where they can be successful in the United States. Once they've done that, yes, then they need to connect with advisors in the US, both an immigration attorney, a business attorney, to set up the US entity. And then another key thing is to find a general manager in the US that can kind of help them be feet on the ground, because there's a lot of things that they may not be able to do from overseas before they obtain the visa. And even if they come to the United States, they wouldn't be allowed to work until they obtain the visa. So hiring a general manager to be really feet on the ground will also be very, very key thing to help them to be able to move this ahead quickly.
Right. Thank you so much. Thank you so much, David, for, walking us through and giving us tips on how to quickly, get yourself ready for an E1 or an L1, for an E2 or an L1. Thank you. Thank you. So now moving on to my next question is, how can, a startup entrepreneur from a treaty country, demonstrate a substantial and non-marginal investment for an E2 visa while meeting current USCIS standards?
Definitely. So really, that's two questions. There are there are several requirements to obtain an E2 visa. One is the investment needs to be substantial, and then the regulations say that the business cannot be marginal, which is kind of a strange word. What does marginal mean? Well, they go on to explain that a marginal business is a business that only generates enough revenue to support the investor and his own family. And so the rule says the business cannot be marginal, which means that it needs to be successful enough and generate enough revenue to hire US workers. So really what it should have said is that the business will support US workers. And so I believe that goes back really to the business plan. The government needs to be able to review the business plan and see that the business plan makes sense, see that it's logical and believable that the company will be able to generate revenue so that it can employ US workers. So that's marginality. You asked me about substantiality. The regulations also say that the investment needs to be substantial. And I have my clients all the time ask me, David, how much is substantial? And I wish that the government would tell us exactly what they want. In another context, in the EB-5 program, the law specifically says 800,000 or 1,050,000. But in the E2 context, the rules only say substantial. So what is substantial? It really goes back to the same thing that I said relating to marginality. And that the investment needs to be enough so that the government believes that the business will be successful and generate revenue both to support the investor and the US workers. However, I think there are some limits to what is substantial. Sometimes I have people asking me, David, can I apply for a visa with a $20,000 investment or $50,000 investment? Lately, I haven't seen E2s being issued with under $100,000 investment. And I'm often seeing people investing around 200,000. Again, the law doesn't say, doesn't give a specific amount. But usually lately I'm seeing people investing at least a couple $100,000.
Right, right, David. And that's a lot. I mean, for folks out there who were just expecting to start something within 20, I mean, they have to go 5 times more. So
Well,
there you go.
I
And
think we're gonna get
yes,
to that
it's
later, I believe. But sometimes if somebody doesn't have that type of funding, then an L1 visa would probably be a better route.
right. So we're getting to that. Thank you, David. Thank you for, telling us about USCIS standards and the E2 visa bit. And also, Vikas has joined with a few questions. Vikas, please stay with us. We are going to address your questions a little later, but thank you so much for joining. And now moving on, David, what are the key industries or business models that are currently seeing faster approvals for E2 and L1 visa applications?
So, what I can't tell you is what models are being approved or being approved more quickly because it's really wide open. What I can tell you is models that won't work. And models that won't work are the passive businesses. I have a lot of people telling me, David, I want to buy a house. I live close to Malibu. I want to buy a house in Malibu. It's going to cost $10 million. That's a substantial investment. Can I get a visa with that? The answer is no. It is an investment. It is substantial, but it's not going to meet the marginality requirement. It's not a business at all. It's not going to generate income for anyone. I have other people asking me if they can be passive investors in minority interests in companies. So can they be essentially investors and get visas? And the answer is also generally no, because that is not an active business that generates employment for U.S. workers. So what we're looking for is active businesses. Some common ones are restaurants. Restaurants require a lot of human capital and require a lot of funding. So that's a very common business. But I've seen people obtain visas from almost every industry. It simply has to be an active business and not a passive investment.
Okay. Okay. Thank you so much for telling us about that as well. And anything important about USCIS standards to keep in mind? Maybe something, when people out there are trying to fit themselves within E2 or L1. Anything else to keep in mind?
There are a lot of things to keep in mind. The focus really is on will the business support the U.S. workers? That's a very key point to always keep in mind. A lot of people think, yeah, they can invest and get to the U.S. and kind of figure it out from there. But when they invest, they need to, when they apply for the visa, they need to submit a pretty detailed business plan. And the business plan needs to spell out, their business model, how they think they're going to be able to generate business, what they're going to do in the U.S., and how they're going to, generate enough revenue to create and maintain U.S. jobs. So I think that's a really key point, and it's going to be more important during the Trump administration.
Right. So the question is it going to benefit the United States? And
absolutely. I mean, I know that it will benefit the foreign investor, but what does the U.S. government care about? How it's going to benefit the U.S. They want to see that those funds have been put into the U.S. economy and spent. So it's not just that they take that 100 or 200,000 and put it in their U.S. business bank account. They want to see that most of that has been utilized and spent and pushed out into the U.S. economy, and that U.S. workers are going to be hired. So it's a win-win. The foreign investor will be able to live in the U.S. Their spouse will be able to work. Kids will be able to go to school. They'll be able to do business in the U.S. And the U.S. will benefit quite a bit from each E2 or L1 that comes into the U.S.
Absolutely. Thank you, David. Thank you so much for the detailed explanation. And now moving on, if a new entrepreneur already has an operating business abroad, what documentation is critical to establish the connection needed for an L1A visa?
Absolutely. So if they already have a business operating abroad, that's a huge head start. And so they will be able to obtain what we call a new office L1. But before they can apply, they need to set up their U.S. Entity. And the U.S. entity has to have a qualifying relationship with the foreign business. So that can be that the U.S. business is a wholly owned subsidiary of the foreign business, that it's a sister company of a common parent, that it's at least a 51% subsidiary, or that the U.S. business has the exact same ownership in the same percentages as the foreign business. So we call this a qualifying relationship, and this is a very, very key initial issue that needs to be addressed each time.
All right, David. Thank you so much for that and for the detailed explanation. I think now we should move ahead to our next question. And That is, what factors should an entrepreneur consider when selecting the US location for their new business under an E2 visa?
Absolutely. So a lot of people just want to do business in the United States. Other people understand that the US is a very large, very diverse country with really 50 different jurisdictions inside of it. Each of the US states have their own cultures, their own laws, and they even have their own taxation systems. So before they set up business in the US, I believe that people should talk to a tax advisor to determine if one state will be better than another. I have a lot of people that want to do business in, say, Florida or Texas because there is no state income tax. I have other people that don't really care about taxation. They want to be by the beach. And so they're going to live in Los Angeles or Florida, some even in Hawaii. And so really it's a personal decision taking into consideration the business climate, taxation, and personal preferences.
All right, David. Thank you so much for, getting us through, for establishing a good connection that is required for an L1A visa. Now, moving on, I have another question, and that is about E2 visas. So, how can small businesses, now, especially after the pandemic, I think we see a lot of new businesses coming up. I think during that time, almost every household, or many households, they started their new businesses from home, online and everything. So I think that trend is still on. And nowadays, everybody shopping online, I think it's become a very big thing, startup businesses and everything. So how can small businesses, and first time investors overcome the common challenges of proving their business viability for an E2 visa?
That's a very good question. You talked about people doing business, kind of side gigs from home. The new E2, the Foreign Affairs Manual relating to E2 visas says that an E2 visa can't operate out of a home office. But how can they do a good job of establishing that they are a viable business? I believe number one, even though the regulations say they can have a home office, they need to have physical presence. Next, a lot of businesses nowadays are service businesses. Even me as a lawyer, this is service industry. It doesn't take a lot of capital to set up a law practice. It takes a computer and a good connection to the internet. But many other businesses are like that. They don't require much capital investment. But to be a good E2 business, in order to obtain a visa, it has to be the kind of business that does require capital investment. So it has to be the type of business that requires an office or a plant or a facility and inventory. So these are some key points. That physical space, and it has to require that investment. And it has to be invested in the right thing. Yeah.
Okay. No, you were saying you can continue.
Okay. Yes. I was contacted by some people from Canada, and they had invested about 100,000, and they wanted to open up a business where they were going to set up Airbnbs. And it sounded good because I know in order to set up Airbnbs, they have to either purchase or lease a property. They have to outfit it with furniture and technology. And so I thought it could be good. When I looked at what they put their money into, they put their first 50,000 into courses on how to be successful in the Airbnb industry. And while those might be tax deductible according to the IRS, I didn't believe that those would be considered to be proper investments for the E2 visa. So the investment has to go into the right area.
Right. And well, when you say right area, like that has to still benefit US, and only then they can be considered, right? So if in case they do not benefit the US, or there is like a chance that the US does not need this kind of business, there are chances that they can never start that business, right?
Well, so first of all, you ask, what if the investment does not benefit the U.S.? So I've seen some scenarios where somebody sets up a business, so they make an investment, they set up a storefront, and they purchase supplies and equipment, but then they purchase the inventory from a foreign country. And I'm asked, well, does that purchase count as part of the investment. It does, but I believe that it might not get full credit. I believe that the U.S. government will probably favor purchases that come from the United States, especially under the Trump administration, where we're going to have the Buy American, Hire American policies. And so, yes, if the government, if the U.S. consulate does not believe that the investment is substantial, and this is, again, the numeric number is not set in stone. They don't feel like it's enough. If they don't like it, they can deny it. They have a lot of discretion to deny the visa application.
All right, David, thank you so much for, walking us through, L1A visa and how important is it, for an entrepreneur to prove that they are going to benefit the US, and of course that they are doing the right kind of business and maybe they are very innovative. So yes, thank you so much. And now moving on, I have sorry, yes, David, please say.
If it's okay, one other quick point. The business that they're in the United States needs to be legal according to US federal law. And I've seen a few people from countries like Canada operating in an area that's technically legal in some other countries and legal according to some states, but not legal according to US federal law. What I'm talking about is anything related to cannabis or marijuana. In California, according to state law, it's generally legal to purchase and if you have the right licenses to sell. But according to US federal law, it's not legal. So people, if they want to obtain a US visa, they should stay 100% away from any industry that has the taint of being connected to something that's illegal, even according to US federal law.
Right, very important thing to keep in mind. So folks, thank you so much, David, for highlighting that. And folks out there, that's a very, very important thing. So Vikas, thank you so much for more questions. We are going to come to that. But I think at this moment, it's time for a short break. So folks out there, you can also have a one-on-one discussion if you're loving David's ideas, advices, and knowledge, and maybe you want to consult him with regard to your case. Why not contact him as well? You can call him on his number, and his phone number is 310-570-4065. And you can even email him dfullmer@wolfsdorf.com. DFULLMER@WOLFSDORF.com. And yes, go visit www.wolfsdorf.com. Don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Well, I'm Napasa Pradhan with none other than attorney David Fulmer. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is the second half of the webinar we are having, and I'm Napasa Pradhan with today's guest, none other than attorney David Fulmer. Yes, he is an amazing immigration attorney who is based out of Los Angeles, and it's such a great honor and a pleasure to have you here with us. Today, we're discussing about how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. So it's been a great discussion so far, and we have a lot more questions to cover. And also, folks out there who have questions for us, Vikas and Sneha, we are going to take up your questions. And I would also like to ask you folks to also join us in this conversation. You know, you can participate by asking your questions in the comment section wherever you've joined us from. We are streaming live on YouTube, LinkedIn, Facebook, and X. And yes, David, it's been a great discussion so far. Thank you so much for doing this.
Thank you for having me. It's been a lot of fun.
Thank you. So I have another question, and that is what are the primary differences between E2 and L1 visas that we are discussing today? You know, both for entrepreneurs, and how should one decide the best fit based on their business goals?
Absolutely. So first of all, the first thing to look at is whether or not an individual is from a treaty country. So if they're from a treaty country, then both possibilities are on the table. But if they're not from a treaty country, then the E2 can be dismissed. Secondarily, the business needs to be majority owned by individuals from the treaty country. So if we have a transferee from a treaty country, but the business is majority owned by his partners who are from another country, that's not going to work. So first we look at the treaty country. If the individual is from a treaty country, then E and L are both on the table. Next thing we would look at is whether or not the investment is substantial. As I mentioned before, E2 does require a larger investment. And so if the investors were thinking that they were going to set up a business with a lower amount, let's say $40,000, $50,000, then they would definitely, they should definitely go toward an L1 instead of an E2. Now, if the investment is substantial and they're from a treaty country, then which is better, E or L? There's some factors to consider. First of all, for a new office L1, they're only going to get a 1-year visa, where with an E2, depending on where they're from, they might get a visa that's valid for up to 5 years. And so if they're looking at saving costs and kind of getting it done and not having to worry about it in the future, then perhaps an E2 is better than an L1. However, with an L1, the L1 new office rules do allow them to apply essentially based on a business plan. And so theoretically, maybe it's a little bit less work in the business setup to obtain an L1 than it is to obtain an E2. Now, the other big difference is that an L1 visa is a dual intent visa, where an E2 is not technically a dual intent visa. That means that when you obtain an L1, you can have the plan and intention to obtain permanent residency in the United States. Where with an E2, you need to have the plan to depart from the United States once you're done doing business in the United States. That's a big difference. Finally, an L1 visa allows for an opportunity for applying for immigration or green card under the EB1C category, where E2 does not necessarily present that opportunity. So these are some factors to consider when you're trying to determine which is better, E2 or L1.
Thank you so much for highlighting the differences, David. And I'm sure, I mean, folks out there who are in a dilemma where to categorize themselves, they have a clearer picture now. Thank you so much. And moving on, now I have another question, and that is, if an entrepreneur's visa is tied to a new business that faces unforeseen challenges or restructuring, what options do they have to maintain compliance and their immigration status?
That's a good question. And this comes up a lot because plans are great. But once they obtain the visa and arrive in the United States, sometimes business does not go according to plan. In fact, maybe it never goes exactly according to plan. But what happens if, they get to the United States on their E or L visa and it's really slow. It's hard to get customers. And so First of all, on an E2 visa, if they obtain a 5-year E2 visa, they do have a little bit longer to turn the business around. Maybe they can't maintain all of the employees throughout the whole 5-year period, but they need to make sure that they have been able to turn the business around by the time it's time to renew the visa. And secondarily, they cannot close the business. So let's say that somebody has an E2 visa and it's tough and they can't maintain all of their employees. If it's a retail store and they close the store and they're no longer in business, then they're no longer in status. So they need to keep on trying. Sometimes that means reinvesting, investing more capital. It might mean changing the business model slightly. It might even mean changing the location slightly. But they need to stay in business, to stay in status and stay in compliance in the United States. If somebody gets a new office L1, they only get a 1-year visa. And so the pressure is on to be successful and to step up within the first year. And if business is tough, if the contracts aren't coming and the money isn't flowing in, they do have the option again to invest more money to maintain the business and to be able to get that extension after the first year.
Okay. Thank you, David. Thank you so much for, walking us through. And now moving on, I have this next question, which frequently comes in mind, and we find them a lot in our groups also. And, folks out there have this question. So how can entrepreneur, transitioning from a visitor visa to an E2 visa ensure that they meet the strict timeline requirements for operating the business in the US?
That's a good question. So first of all, I would hope that if someone is entering the US as a visitor with the plan of obtaining an E2, that they enter on B1 instead of B2. Because usually when people obtain a B visa, it's B1/B2. So if they enter the US on a B1, then they're going to have 6 months to either depart from the US, or technically they may be even able to file the change of status in the US from B1 to E2 status. So if they know what they're doing, and if they have 6 months, that should generally be long enough to go through the steps of, again, setting up the entity, registering with the Secretary of State, getting a tax ID number, opening a bank account, transferring the funds, and then setting up shop. So if they know what they're doing, 6 months is long enough. If they have no idea, then it's going to be more difficult. If someone has no idea what they're going to do, they should probably look into a franchise, because a franchise will kind of have the business plan spelled out. So they should probably talk to a franchise broker and see if there's an opportunity that they're interested in an area that they're interested in, and that's within their budget. And then a franchise should offer a way for them to be able to kind of roll forward pretty quickly, even if they don't know quite what they want to do.
Okay. All right. Thank you so much, David, for that advice and tip, I would say. So now moving on, I have this next question, and that is, for investors planning to use an L1 visa to expand their company into the US. So what strategies can help them build a stronger case for a new office, for a new office petition while ensuring the timely approval?
Absolutely. So first of all, it's really important to look at the foreign business and the person's role within the business to make sure that they're going to be able to be categorized as a manager. So, the L1A visa is the visa for foreign executives or managers that are transferring into the United States to be managers or executives in the United States. It's very important to kind of look at the position abroad first before you launch the case into the United States. So is the person a manager? A manager has 3 subcategories. It can be an executive in a large company, a C-suite executive. It can be somebody who is what's called a personnel manager, who manages 2 levels of staff beneath them, or it can be a function manager who doesn't necessarily have direct reports, but who manages a very essential function of the business through indirect reports. So first of all, do they qualify based on their current position? And that's really the first step before even thinking about launching that business in the US. If they don't qualify, they need a year of qualifying time. Maybe they should adjust their position and wait 1 year so that they qualify, and so they will not have any problems when they launch the business in the United States.
All right. All right. Thank you so much, David. I think that would really help all of us, and it has definitely given us a clearer picture on how to go about either E2 or L1, or where can they actually fit themselves in. And I think now we should definitely go address these questions we have from our viewers. And I will take up Sneha, our first viewer, and her questions. So she says, I've already set up a business in my home country, but I want to expand to the US. How quickly can I establish a US branch under the L1 visa? And what steps should I prioritize to ensure a smooth application?
So, first of all, again, it's great that she has her business set up overseas. That's excellent. The question is there enough going on in that business to support an L1 visa? So, it's going to have a number of employees in order for her to be deemed to be a manager. So I would, in an ideal world, I'd like to see it have 10 or 12 employees at least, and a structure that's with a hierarchy where she's at the top, there are mid-level managers beneath her, and then the workers below her. That would be what's called a personnel manager. So before she thinks about setting up in the US, make sure she's built up her foreign business. Also, the foreign business needs to be strong enough that when she transfers to the US, it continues to be in business. Because if she gets the L1 visa and the business outside of the United States, winds down, then the L1 visa is no longer valid. So it needs to be really built up and strong enough to be able to support the transfer. Next, the procedure of setting up the entity in the US is really quite easy. But the first thing she should do is talk to tax advisors and see if they have any suggestions on the structure and the location. There are a couple of ways it can be done. It can be done as a subsidiary of the foreign business, as a sister company of a common parent, or the shares could even be owned by her individually, as long as the foreign business and the U.S. business are owned by the same shareholders in the same percentages. So strengthen the foreign business, get tax advice, and then get an attorney to help you set up the U.S. entity.
There you go. It's always best to have a U.S. attorney, to help you navigate or, guide you through any of your visas, because they are the experts and they know that each case is different and every case is special and every case needs special attention. So, yes, thank you so much, David, for taking that up for Sneha. And, I would like to share my screen now because we have more questions in our groups. So, I think I'd like to take them up first before we take up Vikasa's question. So, let's take this one. This is from an anonymous participant asking, my L1B petition was approved on 15th of August in premium processing. Still, I have been waiting for the approval petition, and my company visa team is saying they are yet to receive the petition documents from attorney. Usually, how long does it take to receive the approved petition? That's the question.
So the question says that the application was filed through premium processing. And so when something is approved through premium processing, generally the attorney who filed the petition will receive the approved I-797 within about a week. And if it's not received within about a week, then the attorney or the petitioner should contact USCIS. Because premium processing was utilized, there's a little bit more customer service. And so the attorney or the petitioner can email premium processing to tell them they have not received the approved I-797. It should not take long. If it was approved in August, here we are in November, that's a problem. And that should be aggressively followed up on because there's no reason for that to happen these days.
Right, that means that is not a good scene. But thank you so much, David, for taking that up and for the answer. Now I have this next one. This is also from an anonymous participant asking, when looking at the wait times of interview waiver for L1 visa, it doesn't give any information on wait times. It's just blank. Also, when looking for an appointment for Dropbox for L1, it doesn't show any slots. Are there any changes to the process for L1 visa renewal stamping? Also, did anyone get it done in Mexico instead?
Okay, so we have a few questions here. First of all, I think first of all, they're asking about interview times for an L1 under visa wait time. So the Department of State has a web page that's called Visa Wait Times. So you can Google it, you can find it. It says Visa Wait Times. You type in the city, and it will tell you the common wait times for each different type of a visa. And for some, and from consulates in some categories, it'll tell you the waiting time for interviews and interview waivers. So if it doesn't list it for interview waivers, sometimes what we have to do is kind of analogize it. So if it doesn't say L1 interview waivers, perhaps you can look and see what it is for H1 interview waivers and get a general idea of what it's going to be. Napasa, can you bring it up on the screen so I can see the rest of the question?
Sure.
When looking for an appointment, Dropbox L1 doesn't show any slots. It could be that they're not allowing for Dropbox appointments for L1s. If it's not showing any slots, or you may have to email the consulate and see if they'll respond to you about that. Processing in Mexico. So processing in third countries may be a possibility. I can't say I have done too many in Mexico lately, but it may be a possibility. What you want to make sure is if you're processing in a third country, you have a visa to get into that third country. That can be an issue sometimes. And you may want to contact the consulate to make sure that they're open to processing the visa there if it's a third country.
All right. Thank you, David. Thank you so much for that insight. And that was really helpful, I'm sure. Now, moving on, I have this next one. This is from Naluri asking, is it okay to apply L1A extension in premium now? Bunch of thanks in advance for your response here.
There's no reason to not apply for an L1 under premium processing right now. It's available. And generally these days, people utilize premium processing whenever it is available. Sometimes there are strategic reasons when you won't want to, but in most cases, people are utilizing premium processing on any category that's available, and I don't see a problem with it in general.
All right. Thank you so much, David, for taking that up. Now, I have another question, and this is also from another Facebook group, from an anonymous participant. What are supporting documents required for converting L1B to L1A category?
Okay, so that's a good question. L1B is for someone with specialized knowledge. L1A is for a manager. And so the assumption is that you were probably in your home country were working in specialized knowledge. When you transferred to the US, you were working specialized knowledge. And now you've been promoted into a manager, or you will be promoted into a managerial category. And so you'll have to prove that the employer does have a position for you that fits the managerial category. And so what does that mean? Usually you're going to have a detailed job description. You'll have to have an organizational chart to show the people that are going to report to you. And you usually have to demonstrate what titles and what duties those people have so the government can see that you really are turning into a people manager from a specialist.
All right. Very interesting. Thank you so much for taking that up, David. And thank you, anonymous participant, for the question. Well, I have another one. This is also from another group. Another anonymous participant asking, has anyone recently got their L1A extension stamped in Canada? Please share your experience. We don't want to travel all the way to India. So this person is from India originally.
Absolutely. Canada and Mexico technically have jurisdiction over people who are physically present in the United States. And so it is theoretically possible. I'm not seeing it happening a lot these days, but it is possible. Obviously, it's a shorter trip. A lot of people still want to go back home because if they stay in Canada, they're going to have to probably get a visa to get into Canada. They're going to have to stay in a hotel for a week or 10 days. And there's usually a longer wait time if you're applying in a third country. So people from Canada will have priority over people who are third country nationals. So even though it's theoretically possible, a lot of people would rather go back to their home country.
Oh, that's very, very interesting, really. Maybe could you tell us more about it?
Well, yeah. So, if someone's on assignment in the United States from India, they're away from their parents, their siblings, and A lot of times there's a need to kind of go back and see family. So if they go back home to India, they're going to be able to see all of their family, kind of check that box off, and they're probably going to be able to stay with their family for free. But if they're applying in a third country, again, they're going to have all the expense of a trip, and they're not going to be able to see family. So a lot of times people prefer going back home instead of and kind of making it into the annual family visit while they're getting visas stamped, as opposed to doing it in a third country.
Right, right. Very interesting. Thank you so much, David, for taking that up. And moving on, I have more questions. So let's take this one out. Another anonymous participant is asking, hi everyone, I'm heading to India for my L1 blanket visa stamping and currently see Chennai as the only available option for scheduling. Has anyone managed to book appointments at other consulates recently? Also, is it possible to schedule both for OFC and consular appointments on the same day since I see that option in the portal? Thanks in advance for your help.
So I can't say I have all of the information on exactly what the appointment booking is in India.
Yes.
Yeah,
But I
so
think we
maybe
didn't speak about the blanket visas, no? L1 blanket. So maybe if you have anything to say or especially highlight the important points about blanket petitions, it would be
absolutely.
great.
Yeah, I mean, blanket petitions are an excellent tool. Employers should definitely obtain a blanket if they qualify, because they don't have to submit every single application to the USCIS. Instead, they can apply directly at the US consulate. However, at the US consulate, there will be a little bit more adjudication, and the standard for adjudication of an L1 blanket at a consulate is a little bit higher than it is at the USCIS. And so you want to make sure you have a very strong case if you're utilizing the blanket.
All right, that's very important. Thank you so much, David, for taking that question up and also telling us about blanket petitions. Now, moving on, I have another question, and this is from another anonymous participant asking, hello, this one we've taken actually, right? We just took it. I think that's it. Okay, this is one last one. Hi guys, I need help. My husband's L1 extension petition and my L2 extension I-539 have been filed together on October 2024, while L1A extension is filed in premium processing, mine is not. So it's still under process. My I-94 is expiring on December 20th this year, but I have a valid stamped visa till 2027. My husband received his approval notice. My questions are, if I travel outside the USA, will my I-539 be abandoned given it's the extension of the same visa category? Let's take
So
this
the
one
answer to
first.
that is yes. The I-539 is abandoned when you depart from the US.
Okay, and the second question is, can I re-enter USA with my husband's L1 approval notice and current visa?
Yes, you should be able to. You have a visa, you have your husband's L1 approval notice, he's still employed, you're still married. There shouldn't be a problem with that.
All right. Now, the third question is, if my I-539 is abandoned, do I need to apply for extension again with USCIS?
No, you do not. You will be admitted on a new I-94, so you do not need to file a new I-539.
All right. I think the last question is, I heard about flag polling where I get my I-94 extension using my husband's L1 approval. That's right. Will
Correct.
it affect my I-539 if I cross border to extend my I-94 based on my husband's approval notice?
So I think that's really a combination of questions 1 and 2 and 3. And so,
Right.
yes, I-539 will be abandoned, but yes, they should be admitted on a new I-94.
All right. All right. Thank you so much, David. I think with that, we have covered most of the questions from our groups. And we have another live audience who has joined us on YouTube. This is from Rajesh. Hi, Rajesh. Thank you for joining us. He's saying, I am a Canadian and would like to know if I can apply for E2 visa based on my rental properties in USA and start a rental and property management business. Does this business apply under E2?
Yes, it could. So while just owning one rental property probably would not qualify, if someone had a number of rental properties and perhaps contracts with other companies to manage their properties, and if that business, again, meets the other requirements, substantial investment, if it had employees, so it met the marginality requirement, absolutely, this could be a valid E2 business.
Okay, there you go, Rajesh. I think that's good news for you. All the best. Now, let's take up Vikas. I'm so sorry, Vikas. I kept you waiting for so long, but here we are now. Let's take up your questions. He has a series of questions actually. So Vikas is saying, if I already have a tourist visa and want to explore potential business opportunities before applying for the E2 or L1 visa, are there restrictions I should know to avoid complications during my transition? Let's take this one first.
Absolutely. So number one, as I mentioned, they should enter on B1. So when they get to the airport, they'll be asked business or pleasure. They should say business. And if the government, if the customs officer asks them what kind of business, they can be honest and say, I'm thinking about applying for an E2 or L1 visa. I'm here to explore the opportunities. Next, if they get here and if they find the right business opportunity, they can do things like meet with a lawyer, meet with a corporate lawyer, meet with an accountant. They can do business meetings in relation to setting up the business, but they cannot work in the business. So once they've set up the company, if they want to do a soft launch before they obtain the visa, which is a good idea, they need to hire a general manager to perform the day-to-day management until they obtain their visa. Getting that first key employee to manage is very important in obtaining the visa. It also keeps them in compliance because it shows that they're not working illegally in the United States.
Right, right. Thank you. Thank you for taking that up. And he has more questions, so let's address them. If I apply for an L1 visa as an executive, how do I prove my role in my current company and show that my position in the US branch is necessary? And can you give examples of supporting documents that work best?
So it's really two questions. So first he's asking, how do we prove that the position in the US is necessary? The government is generally not going to ask you to prove that it's necessary. If the company wants to launch an office in the US, obviously it has to have a genuine, profit motive. And if you have a business plan that shows that it will be profitable, that's all you have to prove. You don't have to prove that it's necessary, only that it appears that it'll be profitable and that it will be able to sustain business in the United States. So the next question you ask is examples of documents. Can you read the question again, Nipasa?
Can you give examples of supporting documents that work best?
Mm-hmm. Well, again, I think that the question might not be accurate, but the main supporting document to show that the business in the U.S. will be, again, generate profit will be a business plan. So that's the key document. It should be pretty detailed. And in the business plan, there'll be sections that will spell out, who the principals of the business are, who are the founders, what history they have, what plans they have in the United States. That's where you really make the sale to the U.S. government that this business will be successful, will be sustainable, will hire U.S. workers.
All right. Thank you for taking that up for Vikas. And Vikas, I think we've covered all of your questions. But if you still have any more further questions, you can keep commenting. And now let's take up Ganesh's question. So, what are the most effective and cost effective visa options for entrepreneurs and investors seeking to establish a business presence in the US within a short time frame under 6 months? And what are the key requirements? I think we've covered this in this
I think
entire.
that's the whole topic, right? But I think the
Exactly.
answer is this. There in the U.S. there are two investor visas. First, we have EB-5, which is an excellent program. It requires a minimum of $800,000 investment, and if somebody's not already in the United States, it's going to take them a number of years to get to the United States on the EB-5 program. So the cost-effective option is the E2 because it does not necessarily require 800,000. It could be 100, 150, 200,000. So that is the answer. It's E2, which is the topic of our discussion today.
Absolutely. And I think with that, it also helps us wrap up a bit and probably summarize rather in a nutshell this whole topic for today. But before we go, David, I would really like to say thank you first. But also, if you could, end this session with an end note and maybe some key pointers to keep in mind so that you can leave folks out there with some bullet minds they can think about as they leave this session.
Absolutely. Yeah, thank you very much for having me. I think that the key point is that, you don't have to beg a friend for a favor or for a job in the United States. Sometimes it's very hard to search for jobs from overseas. So if you have the funds and or if you have a business, then you can kind of you can direct your own fate. You can make a plan to be able to move you and your family to the United States within a reasonable amount of time using either an E2 or an L1 visa. And it's not going to cost 800,000 like the EB-5 program would. Now, if you have the 800,000, EB-5 is definitely a wonderful route. And if you're in the United States already as a foreign student or on an H-1B visa, and EB-5 is a great route. But if you're not, then you might want to look at an E2 or L1 as a way to move you and your family to the United States within a reasonable amount of time.
Wow. Absolutely. Thank you so much, David. And I wish we had a lot of audience. I mean, live audience, I would say, like, please give a round of applause for our guest today, none other than David, our filmer, who joined us from WR Immigration and also like folks, to add to how incredible David is. Well, he's a top-rated immigration lawyer and the past immigration section chair of the LA County Bar. So he was selected for inclusion in 2023 edition of the Best Lawyers in America, and in 2021 he was recognized as Best Lawyers Immigration Lawyer of the Year in Los Angeles. So I think that is a very great achievement, and thank you so much, David, for joining us and for sharing your very your time with us and all this knowledge that you could impart in this session. I'm really looking forward to have you join us again very soon.
Thank you very much.
And here's wishing you a very, very happy Thanksgiving, happy holidays to you and your family out there. Thank you so much for joining us. All right, so friends, thank you so much for joining us in this session. It was really great. Do not forget to check out David Fulmer and contact him if you want to have a one-on-one consultation, and also visit his website and send him an email. Yes, and these are his contact details. You can call him in this number, 310-570-4065. You can also email David. I think it would be best to email. So note down this email address, dfulmer@wolfsdorf.com, and go visit www.wolfsdorf.com. Thank you for joining us today. You can also email me, by the way. You can contact me if you have any questions with regard to immigration or jobs in the United States. And my number is 408-335-6444. You can email me, nipa@staffingly.com. And I have another great news, and that is Monday to Friday, 4 p.m. Eastern Time, me and my co-host, Sam, we join you with daily immigration dose here on Immigration and Jobs Talk Show. So I would like to say, please join us there in less than an hour. And until then, of course, don't forget to like, share, and subscribe to our channel. And also hit that bell icon so that whenever we have discussions and webinars like these, you are notified and you can join us. Thank you so much once again. Here's wishing you a good day ahead. Bye-bye. Hello and welcome back, everyone, to Immigration Talk. I'm your host, Pastor Pradhan, and today we have an exciting and highly informative session lined up for you. But before we move ahead with what our topic of discussion is going to be, and I even introduce you to our guest for today, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided to you by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook. And let me tell you that you can also participate in this session by commenting. So, whatever questions you have, especially with regard to the topic of discussion for today, it'll be very nice if you can comment them. And we will definitely make some time later in this session to answer to your questions. So, thank you so much for joining us. And definitely, I mean, the 2024 US presidential elections have really stirred up a lot of discussions, and people are really anxious also, especially when it comes to immigration policies. So, with potential changes on the horizon, many of you are wondering maybe what will happen to US study and work permits in 2025. So, to help us, navigate and dive into this really very critical topic today, I'm really thrilled to introduce you to our esteemed guest who is going to join us today for the first time on Immigration and Jobs Talk Show. None other than Attorney David Garson. David is the founding partner of Garson Immigration Law, one of Canada's premier immigration firms, and he is a certified specialist in citizenship and immigration law, recognized by the Law Society of Ontario, and is ranked among the top 9 immigration lawyers in Canada by Chambers and Partners. So David's extensive knowledge and expertise and experience in this field definitely makes him the perfect expert to help us in this topic today. So without further ado, please help me welcome David Garson for the first time on Immigration and Jobs Talk Show. Thank you so much, David, for joining us.
Thank you so much for having me. It's a pleasure to be here.
Absolutely lovely. And maybe you would like to tell us a little more about yourself, something you may want to highlight or tell us about yourself, anything at all.
Sure. I've been practicing immigration law for over 30 years. I'm dual licensed in Canada and the United States. We help individuals enter Canada and we help them go to the United States. So, I mean, we've seen a lot of what has been going on over the years, and immigration as it's been influenced by politics, and frankly speaking, politics has been influenced by immigration. So it's a very interesting time that we're facing right now, without a doubt. There's an old curse, though, may you live in interesting times. So I imagine that there's a lot of anxiety and a lot of questions that people have, including me, because I know we're going to get into questions, and you may hear this a lot from me going forward, but we really don't know much yet. We know what the intent is. We know what this administration had done previously when it was in power, or this president, but we don't know necessarily what is going to happen in the next 4 years. But there have been some indications. There's been some statements on the campaign trail, and I think we can try to piece together or guess, prognosticate as we go. So I look forward to it.
Me too. And definitely with your expertise and experience, I'm sure your perspective is going to add a lot to the viewers out there. I mean, who are all anxious, want to know more, what is going to happen. And some of them are even maybe, fired up to even acting quickly. So maybe you might want to warn them or give out some tips to relax them. So thank you so much, David, once again for joining us. And as we already have said about the topic of discussion, today's topic is U.S. study and work permits, what to expect in 2025 after the elections. So I'm sure folks out there are very, very excited. And I can already see some comments popping up. So thank you so much, Supriya, our first viewer who has commented with a question. Please stay with us. We will address your question a little later. So, David, are you ready for our questions now?
Sure, let's go.
Let's go. So, how do you anticipate changes in U.S. study and work permits under the new administration, particularly for international students and foreign workers?
Well, it's an interesting question because, as many people may remember, under the last administration, they did try to enact legislation or presidential orders stopping people from coming or stopping students from coming and regarding work permits, but the courts overturned them. on various occasions. So whenever they were attempted to try to sort of enact things or move forward, the courts sort of made them take a step back. So in the end, they didn't really get a lot done legislatively, meaning they didn't pass a lot of laws with regard to be restrictive. But what they did do, and what they can do again, is you can work within the system to make things more difficult if you're so inclined. I'll give you an example. If somebody makes an application for a student visa, as many people who are watching probably know, you have to satisfy the State Department or the consulate of a few things, one of which is that you have temporary intent. Now, that's a very broad concept, temporary intent, right? You have to show that you are willing to go back to your home country at the end of your studies. So to do that, you present a lot of documentation. You show you have bank accounts, or you have ties, you have family, you may own property, job offers, things of the sort. So you keep doing this, and you go to the consulate and you say, okay, I've been accepted to for University of Pennsylvania. And here's the proof that I've been accepted. Here's my I-20, which is the document you have to present. And here's my proof that I have ties. A consular officer can look at it, because it's very discretionary, and say, okay, I'm satisfied with those ties. Fine, we're going to give you the student visa. Or a consular officer can say, no, not satisfied, not good enough. Now, if an administration wanted to curtail the number of students that come into the country, then what they can do is simply tell the State Department, which tells its officers, perhaps look at these applications a bit more critically. Maybe there may be another set of criteria we want you to examine in that regard. So they can make things more difficult without changing any legislation for people from getting student visas. So let's say that somebody does get a student visa and they come into the country and they go to school. As many people know as well, at the end of their schooling, they can get something called an OPT, optional practical training, for a year. And then subsequently, under the Obama administration, they said they can extend that by 2 years, okay, if you're in a STEM field, okay? They could take away that. That was something that the Obama administration put into effect. That's not something you have to have. And certainly that means that in terms of being able to work at the end of your studies, they could make that 1 year, they can make it shorter, they could play with the STEM time frame, they could play with the OPT time frame. So I guess what I'm saying here is, what do we think is going to happen? I think that if they want to make it more restrictive, they can do a lot just with what the legislation and the rules that are on the books. And then subsequent to that, in terms of working afterwards, they can make it more difficult based on how they want to work the work permits after you graduate.
Okay. So we can definitely expect another layer of scrutiny, or maybe tightening of.
I was going to say, and there may be a question going forward that we want to, yes, I think based on previous experience. But remember when I started, I said that politics play a huge role in immigration, meaning especially the people that advise the president with regard to this. In his last administration, there was a fellow named Stephen Miller who was advising President Trump on immigration. Now, Stephen Miller was a pretty restrictive guy with regard to immigration. He had thoughts and policies that meant you couldn't, he wanted to narrow the ability for people to come to the United States. I don't know, or I haven't heard that he's advising President Trump this administration. In fact, he's taking a lot of advice from Elon Musk. Now, I'm a guessing man. If you guess, Elon Musk would know the value of foreign workers, and especially people in STEM fields, with regard to what he does. So if he's advising President Trump and he says, okay, listen, we need people, let's say, with regard to the H-1s or OPTs, because these are the individuals that we need in the tech sector or the manufacturing sector or the innovation sector. And so maybe let's not be as harsh as we were previously.
So there we go, friends. And I think along these lines, we are going to definitely dive deeper. And we have more questions and more people joining us. So I'm really happy. Hello to George, if I'm pronouncing it right. Hello, George in LinkedIn. And we have Namrata, Reddy, Jayakumar. Please stay with us. We are going to take up your questions for sure. So, David, my next question is, what specific policies do you expect Trump administration to implement in 2025 that could affect students applying for F1 visa or those already in OPT?
I'm thinking, as I said before, that they are going to be more restrictive with regard. This is what I expect. Everything I'm saying here is I'm just guessing the same as you, but based on what I've seen and based on what I've heard, I do expect them to be somewhat more restrictive with regard to issuing F1 visas than they have been. I also expect them to be somewhat more watchful. I mean, I don't think they enjoyed seeing, and especially they spoke out on the campaign trail, all of the occupied at the universities in terms of the encampments. I think that was something that was not something that this Republican Party, or certainly this president, wants to see going forward. So I think there may be somewhat more restrictions and or variations that are imposed on individuals with regard to what they do when they do come to the United States, if they get their F1. And if they do act in a certain way when they're here that doesn't exactly or expressly have to do with going to school, then there may be further actions that can be taken against them with regard to leaving the United States. In terms of work permits, you know, as I said, they got slapped a lot last time they were in power with regard to changing the law. So they acted or created situations that gave them what they wanted to do. They slowed down processing. They made it there. The amount of denials increased in terms of the percentage. So they can do things like that. I would guess, based on what they've done before, that that's what they'll do again.
Okay. Okay, but it's really nice to have, your point of view, your perspective on this. So thank you so much, David, for doing this with us today. And also, since we're talking about students, maybe you could tell us what challenges should students be prepared for, especially student visas on F1 and work visas H1B.
So when you're coming in, and as I said, when you're asking, I mean, if somebody's applying for an F1, you know, the easiest way to refuse a person, if they have the money to pay and if they have the money to support themselves and if they have been accepted to the school, the easiest way to be refused is on temporary intent. So if you are applying for a visa, to document yourself with regard to temporary intent and your ties to your home country, I think is going to be crucial. I think you have to have as much documentation as you possibly can with regard to your case and with regard to your ties, so that when you go to the consulate and you apply, that you are able to convince the officer that you do have that temporary intent and you can come to the United States and you will leave. I think that's going to be paramount with regard to that. In terms of the student visa, I mean, once you get a student visa and you get your OPT at the end, the issue is that, of course, with the lottery on the H1s, and it makes it difficult to get an H1 in any event. And we are, for instance, contacted by companies all the time that have an individual who is in OPT status and has applied, and they've tried to get that person in H1, and they can't. They've not been picked. And a year goes by, and if they're on STEM, they have the extension, but they don't get picked. And so the company is looking to see if they can go work in another place for that company elsewhere in the world or something of the sort. So the advice I would have, realistically speaking, is that once you're here on the OPT, I mean, it's not, you don't really have control of this situation. And unless they expand the number of H1s that they're willing to give in a year, realistically speaking, I would probably look at, on practical advice, working for a company that maintains as a multinational corporation that can send you other places if they need to, if that's at all possible.
That's good advice. I think that we should consider for sure, folks out there. I think you should look onto that too. And, David, I think we'll quickly take Jaya Kumar's question, if that is fine.
Sure.
So let's go with it. I got 221G issued with white slip, and after a week got an email that intend to revoke from consulate in India. What are the chances of getting approved if my employer responds back?
Oh, that's a very good question. So first of all, for anyone that wants to know, 221G means they need more information. So there's various ways that a consulate can refuse you. It could be under a section called 214B, which is that temporary intent section. The one you don't want is something called 212AC, because that's misrepresentation, and that's horrendous. 221G means that they need more information. So they're refusing the case pending more information coming in. it's a refusal, but it's kind of not a refusal because it means that they're still considering the case and are okay to get more information. Now, I don't know the background of this case in the sense, why is there an intent to revoke? Is there an intent to revoke because they came upon other information that sort of speaks against what was previously submitted? Have they perhaps done an investigation and figured out that there isn't something here that they need that didn't occur or something of the sort? So in answer to your question, what are the odds? It depends on why they're going to revoke. If they're going to revoke because they have definite objective information that's not good, then the odds may not be that high. But if the intent to revoke is based on a misunderstanding or information that they didn't get or thought or they misread, then it could be fine. Realistically speaking, I mean, whatever you do, when you file that information that is supposed to that they want, please make sure it's as fulsome as possible because you're going to get one crack at this. So if you're filing that information that's in addition to what they want to try to address the revocation, make sure it's as fulsome and as packed with whatever you need as possible. Don't play games with it. Because also, and again, I don't know the background, if you submit information that isn't helpful and they are looking at it and saying, well, we're revoking this because we think there is misrepresentation, then you could get slapped with that 212A6C, which is never a good thing. And it could be very deleterious to the case.
Right, David. Thank you so much for taking that up for Jaya. And Jaya, thank you for your question. Really great question. If you have any further questions, you can keep commenting. And we have Jorge saying hello, and he has a question. What can an experienced engineer in the IT industry that is a non-US citizen do to get a working visa, any type?
In the US or anywhere, I guess, in the US?
Yes, that is a non-US citizen, maybe in the US. Yes, in the US.
Yeah. I mean, realistically speaking, it depends on your citizenship, of course. If you're Australian, for instance, you may be able to get an E3 visa. Or if you are, let's put it this way. So there's different types of visas you can get depending on citizenship as well. So if in the normal course, everybody knows about the in the US. Okay, good. Everybody knows about the H1, right? You have to have an employer. The employer has to register. You have to register that expression of interest. The rates of acceptance haven't been that high. They've had a lot of applications and a lot of people have not been chosen. But that is the normal way that most people do get visas. There's something called an L1, an intercompany transfer. So if you, for instance, are an engineer and you go work for a company overseas for a year, and that company then wants to do this L1 intercompany transfer, they can do that to send you into the United States. If you go work for a company that has your nationality, there's treaties of navigation and trade. It's commonly called the E-visa. So if you have the same nationality as the company ownership, then they can try to get you a visa under the E-visa category. If you're Canadian, then you have the free trade agreement that you can look at, or Mexican for that matter. So there are various possibilities. That being said, the most common way an individual gets to the United States, all things being equal, is if a US company petitions for them under the H1 category. Actually, there's one more as well. If you are a person of extraordinary ability, and in that you are one of the top individuals in your field, you've written articles, there's been news about you, all that kind of thing, then you could apply for something called an O1, which is extraordinary ability. You have to be a very high level though. It's not, they realize with the cap on H1s, a lot of people are going to try for O's. So you can't do it if you don't have at least, unless you've written a lot of articles or some scholarly, and unless you've been featured in a lot of different ways, it probably wouldn't be relevant.
Definitely. And by free trade agreement, you mean NAFTA, right?
Well, it used to be NAFTA. The US calls it the USMCA now. Canada calls it the CUSMA. And to be honest, they have no clue what Mexico calls it at this point.
Okay, but Jorge, you have a lot of options out there. Depends where do you actually fit. So you might as well go consult an expert. And I would always say, yes, you need an attorney. So it'll be good to be guided by an expert. Thank you so much. And now going on to our next question. And definitely, if you want to have a one-on-one consultation with David, you have his contact details on the screen. You can email David at garsonil.com, and you can go visit www.garsonil.com. Thank you so much. And let's go to our next question, David. And that is DJ4496 asking, hi, my husband is primary. We are from India on EB2. We got our green card EAD for 5 years. Our priority date is September 30, 2014. So my question is, when can we expect green card?
It's going to be a long time. It'd probably be within that 5 years. Well, right now, I'll take that back. Right now, it could be within the 5 years, but it is taking 5 to 7 years in that regard. However, that is also something else that may change come the new administration. These things could get elongated out. As you probably know, many people find themselves in a priority date that is current, or you think it's almost current, and then it doesn't move for a long time. The issue is that come the new administration, one of the things they can do as well is slow down the priority date processing. So that takes a while. I mean, the fact that you have a green card EAD for 5 years is good news. I mean, that keeps you there for a long time, and hopefully, there is also the president-elect did go on radio and talk about the fact that people that graduate from U.S. universities should be eligible for green cards as long as they do everything right and they've done everything that is appropriate. So, you can't always think that he's going to, or they're going to do anything that's that detrimental. It could be that if he's looking at who is applying and that they need individuals in that field that are applying, and I mean, he may speed up green card processing in certain situations. He may be tougher in others, but to your point, your husband has the EB2 approval. You have a 5-year work permit. Hopefully, within the next 4 years or so, you should be able to get a green card.
I think 4 years is not so bad. I mean, for many folks out there, it's decades.
But again, we don't know.
We don't know.
That's the problem with having this in November when a new president is taking office in January, and you have no clue what he's doing. Somebody asked a question about Tom Holman being appointed today as the new border czar. Yeah. I'll answer. I was just looking at that. What do you view as Tom Holman being appointed as a border czar by Trump administration? Should people be scared given his known stance on immigration and mass
deportation? Drive 10, yes.
Well, he was the head of ICE before, and he is a tough guy on this. In terms of being scared, I think that Trump is sending a message, certainly. One of the cornerstones of his campaign was talking about deportations, right? I think Vice President-elect Vance talked about deporting 1 million people a year. I don't think they're going to be able to do that. Let's be blunt. They're not. First of all, how are they going to find them? I mean, where do you, if they're out of status in the States, where do you go? I mean, you have to locate people. But I think Mr. Holman is a very tough guy. I think that it is sending a message. I think that if you're going to look to deport people and you're going to look to be restrictive, he would be the man for the job. Yeah, I think that's what he's doing there. That all being said, the courts are there for a reason. And like I said, in the last Trump administration, a lot of what they wanted to do was thwarted by the courts. So once somebody is taken into custody and they move towards deportation. I mean, I'm not a deportation lawyer, an enforcement lawyer in that regard, but there is access that a court can comment on with regard to any of this. But yes, I think sorry to go on, but I think having Mr. Holman as the border czar will mean that the Trump administration is going to try to do what they said they were going to do.
Right. And this could be one of the biggest mass deportation in the history of the United States, I guess. Let's see what it holds. I
think that he wants to try.
Betsy.
Yeah, and then somebody said they were talking about deporting illegals. If you're there illegally, there's nothing to fear. I agree with that.
Right.
I agree with
Yes.
that. I think if you're
Jorge.
in the United States legally, I don't see anybody wanting to deport you. I don't think they can. To be good, they can't if you're there legally. The question is that they could create situations where you can't extend your status, or that it would be too difficult to extend your status. And in those situations, then you have to leave. But in terms of being gathered up by ICE and deported, no.
True. Thank you so much. David, for taking that up for Drive 10, and even Jorge, thank you again. So we have our next question. This is Akshay. Akshay is on YouTube asking, would the consulate officer check my past employment history after my MS? Now, if I am applying for a PhD, what should I be careful about?
So they're going to check my employment after my master's degree. Well, yeah, if they have information. I mean, realistically, when you fill out, when you're at the consulate and they're asking you questions, after you got your master's degree, I'm assuming you did your OPT. If that's the case, then they may look at that, certainly, yes. If you're applying for your PhD, if you're not extending status and you're going to a consulate and apply, then it pretty much is what I've just discussed, and that is the temporary intent issue and the fact that you're transparent with regard to what you're going to be doing and what you're doing and how you're going to be doing it. The fact that you're going for your PhD should, by practicality, make it easier to get a visa, because it does show you have certainly serious intent towards your education to get a PhD. And it's normally, when you get higher in the educational sphere, it normally would make it not easier per se, but the officer would understand you've had, especially if you've had visas there before, that you've adhered to U.S. immigration policy, and that you've been someone that is credible. Okay, and I think that has a lot to do with it, credibility, when you're applying for any visa. Because if you do things that they don't particularly care for, or have done things they don't care for, then you lose your credibility with immigration, and that's when things go awry. And that's good. You did your OPT in STEM and then return back to your home country. I think that's very good. It shows that you adhere to U.S. immigration, that you follow the rules, and that they can count on you to follow rules. And I think that having a track record like that is important.
True. And I think that is a plus point for you, Akshay. Thank you so much for your question. And if you have any more questions, you can keep commenting. Well, he says, yes, I did my OPT in STEM and then returned back to my home country. Very nice. Following the rules. There you go. And thank you so much. Even DJ4469 says, thank you for answering the question. Great. Well, David, now I have another question, and that is, if an F1 student's OPT is set to expire in 2025, what options do they have for extending their work authorization, especially with the potential changes in U.S. immigration policies? What do you suggest?
Yeah, this is an easy answer, not much. There isn't that much to do. In the sense that if your OPT is expiring, and you don't have, my phone's going up here, sorry. If your OPT is expiring and you don't have a STEM OPT extension that you can look at, or you can't get another type of work permit based on nationality or a treaty or something of the sort, then there really isn't that much for you to do. As I said, though, we have seen companies, multinational companies, where somebody has an OPT and they're with them for a year. And then the company says, you know what, we are going to put you and you're going to work for our subsidiary or our parent or our affiliate in another country. Then that being the case, if they do that and you're with that company if you're with that company in another country, then if you work there for a year, they can then look for an L1 intercompany transfer to bring you back to the United States. By the way, that is another possibility where they may be more restrictive going forward. There's such a visa called an L1, and an L1 is an intercompany transfer. And you can do an L1 for a manager or executive or a specialized knowledge person. And specialized knowledge usually means a unique knowledge. It's both proprietary to the company and a knowledge of the field. So if they wanted to slow down people who are coming to the United States in specialized knowledge L1s, they could do so, again, not by changing legislation, but simply by making the criteria more rigorous and saying it's going to be harder for you to get an L1 because we want to see a lot more within what you've done and your history and your experience and things like that. So that could be something else that they look at. But if you're in OPT and you don't really have any, you can't extend it, and you can't qualify for another type of work permit based on, as I said, other factors, and unfortunately, there isn't really much that I can see that you can do.
Well, thank you so much for that, David. But I think that's all we can do for 2025 then. And I'd quickly like to say hello to Jemshid. Thank you so much for joining us on LinkedIn. And then we also have Ezzy Lydia. Lydia, thank you so much for joining us. Hello, everyone. I am Lydia. She says, hello. Now I have my next question to you, David, and that is, what impact will the expected changes to work permits and student visas have on industries that rely heavily on international talent, such as technology and healthcare?
That's a good, well, and this is what I was talking about before, that it would be very, I think it could be pretty detrimental in those situations, which leads me to believe that there will be individuals surrounding the president-elect that could talk to him about this, i.e. Elon Musk or someone of the sort. I mean, he doesn't want to, cut off his nose to spite his face necessarily. He understands that there are areas where people need employees, and if you don't have them, then things are going to not be as I guess you could say, they won't be they won't go as well as they should for that industry and for that company. So realistically speaking, I think it will have a deleterious effect on those companies and that industry, which leads me hopefully to believe that they will see that and make allowances in certain areas.
Okay, but definitely, I mean, people, especially where US needs talent from, different countries where, US may not have theirs. And I think this is something that is going to be affected for sure. So, David, thank you for highlighting that. Now, I have another question, and that is, if a university student on an F1 visa receives an unexpected job offer before graduation, what immediate steps should they take to ensure compliance with the new work permit regulations under the Trump administration?
Yeah, well, they won't be able to do, again, they'll have to, realistically speaking, they can do their CPT, which is part-time work within the context of when they're studying, and that's fine. But and they have to be able to do that and get approval to do that. But realistically speaking, if you, under this administration, we don't know what they're going to do with the OPT and what they're going to do with regard to the student visas, because in the normal course, you can't work. If you're on a student visa, you have to go to school. In certain circumstances, a spouse may be able to, if things go very bad and in hardship circumstances, there may be ways for a person to get a EAD. But in the normal course, they can't do much in that regard. They have to be compliant. I think that is the lesson that going forward is going to be as important as anything. And that is, under this administration, you have to remain compliant to the letter of the law. Because I think that if you do anything that's not going to be completely by the book, you could find yourself in a situation where you will be removed from the United States, or put yourself in a position where you could be removed from the United States. So in any event, if you get an offer of employment, you can't necessarily you can't necessarily start working. You have to wait until you're eligible to work. You wait for that, then you can start to work. And any employer that is interested in hiring you, and frankly speaking, has worked in the system before, will understand that. Remain compliant. More than anything else, remain compliant.
Thank you, David. I think that is a great advice. And folks out there, you definitely need to stay vigilant, compliant, go by the rules, be on the right track, and stay hopeful. I think that is what I can say for now. And yes, absolutely. Go contact Attorney David Garson, and he's definitely going to direct you at least how to go about it if you have any confusions, or especially that every case is different and you might need special attention. So why not email David? His email address is david@garsonil.com. And you can also go visit his website, www.garsonil.com. Thank you, David. And okay, Akshay is back saying, I'm sorry I missed the first 15 minutes of this session, but I wanted to ask about the implications on OPT and STEM OPT going in the future. Do you want to say that?
Sure. As I was saying, we don't know. There's been a lot of discussion regarding it, to be honest with you. In fact, this is probably the area that has been focused on the most by pundits and newspaper reporters and things to sort of what is this administration going to do with the OPT and STEM OPT? The STEM OPT was established by the Obama administration. I think that the Trump administration in this first go around tried to get rid of it, as I recall, or tried to limit it, and they weren't able to do so. That doesn't mean they aren't going to try again. The OPT, I don't see them stopping the OPT. I really don't. I don't know why they would. I think that it's helpful to employers, it's helpful to the individuals, but I don't know that it would be expanded in any way, shape, or form. Unless, and I mentioned this at the beginning, as I said, under the last administration, the person who was responsible for advising the president was a fellow named Stephen Miller, who was pretty restrictive. I don't know that this person is advising the president under this administration. I think Elon Musk is having a lot of say in this. And that being the case, if he listens to that kind of individual, then he may understand the importance of people who are in STEM or technology or even trades, to be honest with you. I mean, let's be honest, a lot of people, they say there's 11 million people who are out of status in the United States. I don't know. I haven't looked at the statistics, but I'm kind of thinking that a lot of them are in construction and in trades in places that need them. So for instance, there was just a hurricane in North Carolina. There's always hurricanes in Florida, things like that. They have to rebuild their infrastruccore. And I'm not sure there's enough people who are US citizens or green card holders who can do that. So I think practically, and I think I don't want to say it's a secret, but I think most people believe or think that a lot of the people that are working in trades and construction and I was going to say technology, not so much, but trades and construction are probably people who are out of status. And so if the president or this administration wanted to look at something like that, there may be a possibility of I don't want to say an amnesty because people freak out when I say the word amnesty, but of a possibility of creating a pathway for individuals who work in certain sectors and have worked in those sectors for a while to get permanent residence, especially if they're needed.
There you go. Thank you. Yes.
Somebody just made a comment that Elon will be the savior of the STEM people.
He's the same guy. Akshay is the guy only. So he was also saying, also it is true that you can use STEM OPT only once. For example, if I used STEM during my master's, then I cannot use it after my PhD. Please clarify.
Correct. Yes.
That's true. That's true, Akshay. So there you have it. Thank you. Thank you so much, David, for taking that up. Jorge says, just want to thank David for this session. He's very well spoken and knowledgeable. Definitely. Thank you so much, David, for joining us and making time for this.
That's very
now,
nice.
my
Thank
next
you.
question. Yes, thank you. Next question for you, David, is how will the proposed restrictions on OPT affect international students pursuing STEM degrees, and what steps can students take to mitigate these changes? We've been discussing this over and over, and maybe if you have any more points to...
Yeah, no, I think I pretty much said everything I can say. We don't know what they're going to do. Everything may change or nothing may change. You know, I know I sound... That's an easy thing to say. It gets me out of a lot of questions, but I do think based on previous experience, meaning the government's previous governing, or this government's previous governing, that things will get more restrictive. It will be tougher to get cases approved. They don't need to change the law to do that. The L1s, the H1s, they could take away spousal. I'm going away from OPTs, I apologize, but they could take away spousal work permits from the H2s or the L2s. I'm sorry, the H4s and the L2s. They could take away, meaning if right now, if I'm on an H or an L, my spouse can get a work permit. they could take that away. And by taking that away, it lessens the, I guess, desirability of people coming to the United States, because if their spouse can't work, then what are you doing? That's not very fair. It's fair, but it's their country. But what I'm saying is it's not as attractive to somebody who's coming. So they could do all sorts of things. So in terms of the OPT, I don't know that they'll do anything significant. I think the STEM OPT, that in itself is up for grabs. And to that person's point of view, Elon may be the savior. Who knows?
For sure. Okay, well, what do you want to say about the H-1B lottery? Maybe of course, we are going to expect changes, everything immigration related. But do you have anything to say on that H-1B lottery system?
Yeah, I mean, the 65,000. It's always it's a mad rush when cap season comes and employers file the expressions of interest, and wherever it's usually 15, 20, 25% that get picked. I can't see them going a lot higher than that. If they wanted to do things that were, I guess you could say, innovative, and then they could change that cap for the various industries that people go into. So for instance, there's a lot of people in STEM, a lot of US citizens and a lot of green card holders in that sense. So if you have if you have a degree in a STEM field and they need STEM people, then they can absolutely say, you know what, we can raise a cap in this area. We can get more people in this area. Why we need them? Or it could be another field or something of the sort. In the sense of that. So they could be innovative. You never know. Things could go better than it has been before. In that way, they could be somewhat creative and think outside of the box when they're doing these kinds of things, or they may just be completely restrictive. In other words, it may be a very good hedge, and it would be a good legacy for this administration if they changed the immigration policy and made it something that was more utilitarian for everybody, so that it's functional and practical, not necessarily a one-size-fits-all.
True, and maybe everything you say cannot happen. I mean, even Trump cannot say that whatever he has said can happen, right?
Right. No, that's exactly the case. I mean, in the end, it will depend upon who the president surrounds themselves with, right? It goes to the fact that if you are in a field or in an area that the president believes is important to the country, then he could basically do it he could do things that would be a great help to the US. And then, as I said, he's very concerned about his legacy. It could really help his legacy.
Right. Thank you so much, David, for that. And, I had some more questions from people who keep commenting on our groups and YouTube channel. So I think I would like to share that. But hold on, not this one. Okay. So this was a nationwide protest on Canada 2 months back when they were talking about deportation. But if you find it relevant and if you want to take them up, you may want to give out some views or perspective on this. So when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies. That was the agreement they signed.
Yep. Sorry, is there a question or?
It's just a comment. I mean.
Oh, yeah.
Then we have. Let me take this up for now. This is from Dixit. Asking urgent, I went for my first H-1B visa stamping yesterday and learned that my F-1 visa was revoked. I was sent for second interview on same day, but my visa is cancelled. The interviewer told me that I was involved in a fraud with my first OPT employer. My other friends have worked with this employer, but they had no visa issues. Did anyone else? Do you want to say anything on this?
Yeah, I've seen this before. It's a scam.
Okay.
So what it is that I've had people consult me on this, and that is they get an OPT for an employer that they're not really working for. And so, but the employer says that they're working for them. And so then they go ahead and they have their OPT, and then they can get the extension on the stamp and things of the sort. But realistically speaking, they're not working for the employer, and I think in the worst case scenarios, they pay the employer to basically say that. So, that unfortunately is a fraud scheme that I've seen before and keeps turning up. It leads me to believe that the authorities or the State Department or USCIS or CBP have been alerted to it and are now looking for it. So when somebody gets an F1 and they get an OPT and then they say, okay, I'm working for Mary's company, being a systems analyst or a software developer, and they're not really working for a Mary's company, they may be working at the Walmart or something of the sort, but they get that letter, and then when they go to get the H1, if they're picked, or they go to get a STEM extension, and it comes out, then that's pretty bad, because then you do get charged with misrepresentation, and you lose your ability to stay in the States and or go to the States.
Okay. Thank you so much, David, for taking that up. And now I have my next question, and that is also from this is with regard to the I-20. Got admission offer for spring, haven't filed I-20 yet. Now wanted to change my term to fall. At what point should I request for change of term before getting F1 visa, or after I get F1 visa? Or should I select defer in I-20 form to next term and submit? And get confirmation from university for fall, file the new I-120 then, or submit I-120 for spring now, get visa, and then ask university to change term to fall. Which one of the options will be better?
So I need to see it. Can you make it bigger so I can read it? I can't.
Sure. This is, I think, how it goes.
Okay. So I'm going to do it myself here for a second. Sorry. Got an offer for spring, haven't filed it. Now I want to change my term to fall. At what point should I change? No, don't go to the consulate if you're not going. Should I select defer in I-20 to next term and submit? If conference or submit I-20 for spring. Well, I would advise, this is my opinion. And again, I can't give you legal advice, but if you got admission to the offer for spring, and when you say file your I-20, or you mean going to the consulate, I'm assuming. Now, if you're changing fall, don't go to the consulate with an I-20 saying you're going to spring term, because that's misrepresentation. You're telling them you're going to it and you're not. So in the I-20, when you go to submit, get confirmation of the fall, fill in, I would get a proper I-20 for the session you're going to before you go to the consulate, and then apply to go for that session. I wouldn't go at all. I wouldn't play with going to, especially now. I wouldn't go to the consulate with an I-20 that has a different session than you're actually going to attend.
Okay. Thank you so much, David. I think that will be very much helpful. Thank you for that advice. And now I'll quickly take up my next question. And that is, my wife got admission in MBA in US. Should we apply F2 visa for spouse and kids along with her F1 visa application in one go? Or after she gets F1 and lands in United States, then we apply for F2 visa?
It's a very good question. I get this a bit in the sense, what strategically is probably the better way to go. Either way, they're going to be looking at it in the sense of temporariness of intent, right? So if you're going to your MBA, and it depends, realistically, this is going to sound, not fair, but it isn't. It depends where you're applying from. and it depends on your monetary situation, and it depends on the circumstances surrounding yourself. Meaning, let's say you you apply from a country that the U.S. has, their statistics show that people don't come back or they stay, and meaning you are not from a family that is wealthy or you have wealth, and in that regard, it's again, it doesn't sound good, and it kind of makes people say, well, you know, why can't I go if somebody else goes? But the truth is, if you're applying for a visa and the consulate is convinced you will return to your home country, or you have the resources to support yourself and go to your home country, they're going to be a lot less restrictive. So to your question, if somebody's applying for an F1 and the F2 and for your spouse and children, you can all go at the same time if you are confident that you are from a certain situation that make this, again, less restrictive. If you go separately, it's no guarantee that your spouse is going to get it if you didn't all go together. I guess my point is that I don't know if it makes too much difference. I think what matters most in that circumstance is whether or not you are of a certain individual or person that the consulate is confident that everybody will come back. So in the end, if you are from a certain strata that unfairly is treated a bit differently, then you can all go together. If not, then you can go separately, but it doesn't mean that your spouse and kids are going to get the visa if you go separately. You're still going to be subject to those issues and that kind of scrutiny.
Thank you so much, David, for such a truthful opinion and, help. Thank you so much. I wish I knew this participant's name, but it's anonymous post. So thank you so much for taking that up. Now, moving on, this is my next. This is, hi guys, I need your suggestions. I am admitted to UT Dallas for master's with a scholarship. However, I realized that I could have applied to UT Austin, Rice, UIUC. However, my visa is scheduled later this month. Do you guys recommend me to defer it and apply to these universities? Is it worth it? Or should I just go to UT Dallas?
Yeah,
what do you suggest?
I don't think it much matters, to be honest. I don't know that it matters. Somebody asked a question about, do you expect positively, negatively affecting any policy?
Yes, Hari Guru, let's take that up. Yes.
Okay.
Thank you.
Yeah, I don't know, to be honest with you. I don't see anything. If you are in valid status and you have the 485 is a change of status, by the way, and then you've made application to change status and you're in valid status and you're doing everything right, I don't know that it'll affect it negatively or positively. I don't think it'll affect it at all. I think it's being slow as it is. To your point, you've been there for 3 or 4 years waiting for your priority date. So I guess only negatively if they decide to slow down processing instead, which they have the ability to do. So if that's the case, then sure, that's negative. But in either event, if all things being equal and they're not looking to cause trouble to people in that situation, then I don't think I think it's a neutral answer. The only way it will affect negatively, as I said, if they decide to slow down processing as a means to limit immigration, meaning they don't have to change legislation to change processing and the law and how many people come, because they can make it more difficult within the parameters and the tools that they have already.
Okay. Thank you so much for taking that up, David. And now I have another question. This was on our YouTube channel. This was asked by Vijay Kumar. I am on my F1 visa OPT and recently got approved for H1B I-797B consular services. Since I am in US and working for employer on OPT, can my employer refile for new I-129 as change of status so that I can continue working on H1B and no need to travel for stamping? Thanks.
Yeah, they could, but I'm curious as why they didn't. To be honest, I mean, I don't know why they wouldn't to begin with. There must have been a reason necessarily. The second is that even if you do get you change your status, you can't travel at all unless you get that visa. So once you get a 797 and you don't have a change of status, then you have to travel to the consulate that you need to go to even to travel. So it probably wouldn't be a bad idea to do it, to be honest with you. I would go and do it, especially if you get the approval and you were in the States and you went to school in the States. There's no temporary intent for an H1. So that's a good thing. So you don't have to satisfy that. So the only thing they could really refuse you under is if they think that it wasn't a real job offer, or you don't have the qualifications or things like that. But given that you went to school in the States, given that you work for the employer in the States, if it's real, then I wouldn't be afraid of the consulate.
Okay. Thank you so much for taking that up for Vijay Kumar, David. And I think we'll just go on with one last question. And I think that should be, let me just see if this is the one. Or I think we've taken up all of them for now. Yes, but if you want to give a view on this. Hello, in my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process be the same for me? And once I upload my documents, do I need to keep studying during the processing time?
So if they've already changed their status to H4, they don't study at all because they can't. They're on H4 unless they get approval to do it. But that's what I was just talking about, in the sense that they have a visa, they have status, so they can't go anywhere. And until, you're changing status from F1 to H4, and they're asking, okay, well, can I keep studying? Do you have to keep studying? No. Are they studying? Did they finish? You know what I mean? Every situation is as it is. If they are still in F1 status and they file the change of status to H4, realistically speaking, they should stay in F1 status until they get an approval to H4, right? They shouldn't. So should they? If they're supposed to keep studying, yes, keep studying. If you are done, then you nothing to study. So you are in that status until you change your status, until you get an approval to change your status. By just filing the application to change status does not give you the new status. So you have to wait until the new status is approved before you can do whatever you want to do or not do whatever you want to do. In this case, not study. And in terms of travel, correct. They can't go anywhere. And if they do, they need a new visa.
Thank you so much, David. That was really wonderful, taking up all these questions so patiently and giving us all your point of views and expert advice, I would say. So thank you so much. And maybe we could wrap up if you want to say anything about maybe AI or these latest things that are trending right now, technology-wise or student-wise. And maybe even Akshay's last question. DHS says you can use STEM OPT twice. Please confirm.
Yeah, actually, do you want to contact me on that? Because I want to look at something. So if you want to contact me, I'm happy to answer it. Okay?
Absolutely. And so, yes, David, maybe you would want to say anything with regard to AI.
Well, it's funny. As I said, I'm dual licensed in Canada and the US. And Canada uses AI a lot in adjudication. And frankly speaking, I hate it. It's just because what happens is that if anything is out of the ordinary, it picks it up. Meaning, if you have a difficult case, and then it makes it more difficult. It goes to the officer becomes increasingly suspicious. And when the officer becomes increasingly suspicious, they're harder on the case. And AI as well is refusing a lot. Refusals have gone up, I think, by 12% using AI. So the US isn't quite there yet. It isn't really using AI per se, but it will. And I can only say that when they start using AI, refusals will rise. Because just psychologically speaking, right? If you get a case as an officer and you adjudicate it, fine, that's great. It can be a yes or no. And then when you have AI, if AI says, yeah, you should approve this case, you should approve this case, you should approve this case, you start to rely on it. But then when AI takes a case and says, well, there's something different here, you should look at it, the officer's perspective right away becomes negative, thinking, well, why didn't AI approve it immediately? And so that creates a harsher result, in my opinion, with regard to adjudication.
Thank you so much, David. Really, such a great session. I wish we didn't have to wrap it up as quick, but thank you so much. And folks out there, do contact Attorney David Garson, and maybe when you do, let him know that you found him here on Immigration and Jobs Talk Show, and tell him about your case, and maybe for sure he's going to be happy to help you. So his email address is david@garsonil.com, and his website is www.garsonil.com. So definitely go visit and contact David. Thank you so much, David, for doing this today.
Pleasure. Have a good day.
You too, have a good day, and I hope to see you again very soon.
Thank you. Myself as well.
Thank you. Thank you, David. And folks out there, thank you so much for joining us once again. It's really lovely that you did. And please do not forget to like, share, and definitely subscribe to our channel. It's Immigration and Jobs Talk Show. You can hit that bell icon so that, whenever we have sessions like these, you are notified. And definitely, if you resonated and if you think that your friends and folks out there can also resonate with this kind of content, don't forget to share, please. And also, my number is where you can also contact me on WhatsApp. This is my number, 408-335-6444. You can also email me. My email address is nipa@staffingly.com, and go visit www.staffingly.com to get to know more about us. Thank you so much for joining us. Y'all out there have a great day and a splendid week ahead. See you again. Stay tuned to Immigration and Jobs Talk Show.